What's up, grandkids? Good morning. Good morning. What's up, chat? Kenosha courts usually start on time, chat. We went live a little bit earlier just to get the stream set up and rolling. So we'll get a court feed up here very shortly. Very shortly. Please make sure to hit that thumbs up. Share the stream out everywhere, please, especially if you're in Kenosha. Currently in the middle of setting something else up that might be a cool surprise for everybody. So once I know the details and have them ironed out, then I will let everybody know. Actually pretty excited about this. So today is day 2 of the ZACHARIAH Anderson trial. They had opening statements the other day. You can find those on our playlist, Wisconsin versus ZACHARIAH Anderson, if you missed it. And there was almost a mistrial due to a statement the defense team made during opening statements. This trial has already gone to trial once before, and there was a mistrial due to a witness statement. And from what I'm kind of understanding, it was the girlfriend, the ex-girlfriend, when she was testifying, she had stated that she had gone to the apartment. And that statement caused a mistrial. So it was almost a mistrial again during opening statements. This time, yesterday, they had lawyer argument. Pretty short stream, wasn't very long. That is also on the playlist, ZACHARIAH Anderson. So if you missed that and you guys need to catch up, we have a playlist set up with those 2 streams on there. Today is day 2, officially day 2 of this trial. Once this court feed comes up, we will go live in the courtrooms. Please make sure you guys share the stream out. So as most of you know, I am from Kenosha, so this is kind of a big deal. We try to cover a bunch of Wisconsin-related stuff since we're from the area. What else? The other thing. So, you guys know I don't really chat during the trial, but during breaks and all those things, we do background. So we did with the lawyer argument yesterday. After that was done, because it was a Denny argument. So there's a case, and we went through basically the entire Denny case so that you guys had background on that. You knew what that was all about. And it referred to a whole bunch of other types of cases and all types of stuff. So if you want to know what all that is about, all the Denny argument, like I said, we did a whole deep dive into that. This way you guys have all of the information. You know what's going on. You know what the arguments are about. Not getting that on any other channel. Now, for those of you that might be new and those that are not new and are here constantly, like we did during the Mark Jensen trial, we did a mock jury. So once the trial was done, we held a mock jury. We had our viewers come on as if they were the real jurors. I would love to do that again for this trial. They've never found the victim's body in this trial. He is still missing, but presumed dead. So this might be a pretty interesting case. So it'd be fun if we can do another mock jury deliberation with our viewers at the end of this trial. So make sure you guys are here every day for this. Like I said, please hit that thumbs up, share the stream out. Once we get this court feed up, chat, we will get the court feed going. Thanks for tuning in. How's everybody doing this morning? Make sure you guys are active in the chat. Make sure you guys are subscribed. Hit the bell for all notifications. Every now and again, we do have our viewers that gift memberships, month-long memberships. Our memberships for the channel, where you get access to exclusive content, starts at 99 cents a month. But once in a while, our viewers will gift some memberships throughout the stream. So make sure you have all that stuff turned on. Doesn't happen every stream. Once in a while, though. But if you'd like to sign up for a membership, like I said, they start at 99 cents. Each level gives you access to to more exclusive content. So check that out. But be sure to be subscribed. Hit the bell for all notifications. Make sure on the back end of your YouTube that you have notifications turned on. And then also make sure on your phone, on the back end of your app section, that you have notifications turned on for YouTube so that you can be notified. We do get shadow banned sometimes because of the type of content that we discuss here on this channel. So it's really important that our viewers help us out by hitting that like button and sharing the stream out. Good morning, Nana. How are you doing? So Kenosha courts are pretty on time. Trial starts at 9. It's 9:05, so I'm sure they're bustling everybody into the courtroom. But please help us out, get everything shared out. As soon as we get this feed up, we'll get it switched over. It's been a heck of a morning. So for those of you that have been following my drunk, crazy neighbor situation, that already started. Like I said, 7 a.m. till 9. The kid leaves about 8:45 in the morning. So once he leaves, it sort of quiets down. So it sounds like she went back to bed. So hopefully throughout the day, it'll be nice and peaceful. We can have fun over here on the trials. I can engage with you guys. So like I said, during the actual testimonies and arguments with the lawyers, I don't normally talk. I know you guys like to watch the actual trial. But during breaks and things, we play videos, we do breakdowns. At the end of the day as well from the trial, we'll do kind of a breakdown recap of what happened, and it's a great time for discussion. Feel free to ask questions during the stream. I'll do my best to answer them through the chat, but if they're kind of require maybe a longer explanation, we'll get to them during little breaks and things like that. So, but please, guys, make sure you guys share this stuff out all over social media. If you have Facebook, Twitter, all of that stuff, share it out. Let's try to get a bunch of people here watching. We are just waiting for this feed to start. As you guys are popping in, make sure you guys say hi. We have a really fun chat. We'll get this court feed up here soon. As soon as it goes live, guys, we'll get this up. Here we go. Finally a stream. Finally a stream set up. Here we go. It went live. Perfect. Thank God. All right, chat. So, like I said, normally during the trials, when there's actual testimony, things like that, I don't talk. We do engage during breaks. We play some old videos. We play some content from the channel. We play breaking news things. We do breakdowns. We answer chat's questions. So all of that. So make sure you guys stick around, hang out here. This is a great place where you can get your questions answered. So I am working on something big in the background here. So something fun and exciting that we're gonna be doing. We're gonna have set up here. We are just trying to confirm the details and the times of everything. And once I have all of that set up, I will let you guys know. Okay, here we are. Make sure you guys hit that thumbs up on your way in. Share the stream out, please.
Anything before I bring the jury down? Anything before I bring down the jury?
I want to do that after. There are several matters, but I think that the state and myself would prefer to discuss that after the opening statements have concluded.
All right.
I do have one quick one, and that is that the court yesterday signed a material witness warrant for a Miss Swanigan.
I didn't, but one of the judges did.
Oh, some other, I apologize.
Judge
I thought the court did. We're asking the court to cancel that at this point, pursuant to contact with our office when the warrant went out. She is physically here and is at the courthouse, and so I believe she's in compliance with what we were hoping to accomplish. So we'd ask the court to allow that to be dismissed at this point, and we expect her to be a witness today.
Did you have comments?
No comment.
Your wishes is my command. All right. Anything else?
Anything else can wait.
All right.
Are you asking about the warrant? Did they talk about the warrant yesterday? I don't remember the warrant. I thought it was just the Denny thing. I mean, they definitely have some, behind the scenes things that we don't see all of it, but obviously they have, subpoenas and things that go around, but they probably didn't need it because the woman is coming anyway. If that's what your question
Yes,
was.
Now, please. Thank you.
So we have Judge Bruce Schrader again. You guys recognize him from the Kyle Rittenhouse case. Schrader is a dinosaur in the Kenosha County Courthouse. He is known as the judge you want to be in front of for a fair trial, but not the judge you want to be in front of for sentencing. Judge Bruce Schrader likes to max people out if they are found guilty. But he is known as one of the most fair judges in Kenosha County Courthouse. A lot of controversy during the Rittenhouse trial that there may have been a bias. So Zachariah Anderson is charged with first-degree intentional homicide, has a second charge of hiding a corpse, and 2 charges of stalking. He is accused of murdering his ex-girlfriend's new boyfriend, and his body has never been found. Pretty gruesome crime scene. This is another high-profile case that happened in Kenosha in May of 2020. So right before the riots. There's already been one mistrial. There was almost one yesterday.
Some discussion, and then the
Here we are again.
attorneys
Enjoy the stream, chat. Share it out. Hit that thumbs up.
consulted, and it's decided that the objection which was raised by Mr. Gravely has been withdrawn. So we'll continue where we were. Ms. Miller, thank you.
Good morning, everyone. So where I had left off when I last was speaking with you all was about how law enforcement in this case failed to actually investigate the events the state assert transpired on May 17th, 2020. How they ignored leads, how they didn't follow up on things, how they failed to look in places that should have been looked into. So I'm going to go into some of those investigative failures now. You'll hear that law enforcement really did no searches of Mr. Gutierrez around the immediate vicinity of Wood Creek Apartments where Mr. Gutierrez lived. That there's a wooded park area that is property of UW Parkside, and that all that they did with that area was send some drones to look around. But you'll hear that it was forested at that point because we're in the middle of May, and that they would not have been able to see the floor of that entire wooded area. So law enforcement looked nowhere close to Mr. Gutierrez's residence in an attempt to find potential evidence. Not only did they fail to do that, they failed to investigate legitimate Crime Stopper leads. So people could call in with tips, anonymous or not, and there was this one tip where an individual called in and said, I saw a woman standing in front of Mr. Gutierrez's sliding door on that concrete slabbed patio on May 18th, 2020. And I remember this because she had asked me what time it was. And I knew it was Mr. Gutierrez's apartment because his sliding door is right next to that exit door. Law enforcement got that information and ignored it. They did not follow up. They also didn't follow up on data that they obtained through a geofence warrant. And you'll hear that a geofence warrant is where law enforcement takes a certain area and asks Google to produce all the information and data on people that they know were in that location on a specific date and during specific time frames. And in this case, Detective Carrera had asked for the geofence data on all individuals who were around Mr. Gutierrez's apartment from May 17th, 2020 at 7 p.m. through May 18th, 2020 at 3 a.m. And that Google produced several hits for people that were in that area. And you'll hear that law enforcement did not attempt to investigate any of those potential people who were in the area at the time the state asserts the crime occurred. You'll also hear that Mr. Anderson did not appear in that data. When law enforcement arrived on scene on May 19th, 2020, there were two dumpsters next to Mr. Gutierrez's apartment, and they had gone and looked at them and noticed that there really was not that much trash. Maybe a bag, a box. And so they called the waste management company and they asked, hey, when was this trash picked up? And the waste management individuals had informed them that the trash had been picked up earlier that morning on the 19th and that it was sent to Zion landfill in Illinois. You'll hear that law enforcement chose not to go to Zion landfill and search what would have been freshly dumped garbage that could have produced evidence in this crime. And you'll hear that that could have been because Mr. Anderson, the person, remember, that they had chose as their main character, there was no indication that he had ever gone out to Zion or that he had spent any significant time in the Kenosha area. Didn't fit their script. They weren't going to investigate it. They also didn't investigate Pheasant Run landfill. That was a landfill that they had potential information that Mr. Gutierrez's body had been dumped there. They didn't go to Pheasant Run landfill. They didn't talk to anyone in management at Pheasant Run landfill to see whether there was any individual who dumped off trash that Monday, May 18th, that morning. They did not investigate that lead. They also didn't investigate people that Mr. Gutierrez owed money to. And you'll hear throughout this case that Mr. Gutierrez was in an extremely difficult financial situation. His mom was helping paying bills. He was about to be evicted from his apartment. And he had people messaging him about where their money is and how you don't do this to friends. And you'll hear that law enforcement did not investigate a single person that he seemed to owe a substantial amount of money to. And then they also didn't look into all of the women that Mr. Gutierrez would have been talking to or dating at that time. You'll hear that Mr. Gutierrez had several dating apps. They were located on his phone. He had emails from dating websites, and that law enforcement didn't look into any of the chat strings on there. And that's just the tip of the iceberg. What I just outlined for you is just a little sprinkle of an example of everything that law enforcement failed to investigate. But not only did they fail to investigate legitimate leads and potential other suspects, they also failed to effectively process the scene of the crime. They failed to obtain DNA swabs, fingerprints from areas that, according to their theory, the individual or individuals who was responsible for the disappearance of Mr. Gutierrez would have had to have touched or come in contact with. The first thing law enforcement did when they arrived on scene on May 19th, 2020, was they took a video of them walking into the apartment, of Mr. Gutierrez's apartment, and all of the lights were off. So the state claims that there was this blunt force trauma, this beating, someone was wrapped up in a rug, the crime scene was meticulously cleaned up so that no trace of the other people who were there could be found, that then the scene is staged to the point that it looks like a robbery could have occurred. That obviously didn't happen all in the dark, if they're claiming that this happened around 10 p.m. at night, yet law enforcement did not swab the light switches in the apartment for potential DNA, nor did they attempt to get any fingerprints. In addition to their failure to obtain swabs from areas that could have contained DNA of the people who are actually responsible for Mr. Gutierrez's disappearance, their lack of precision shows immensely in the fact that 9 days after they initially made contact with Mr. Gutierrez's apartment, Mr. Gutierrez's mother, Ms. Patterson, found Mr. Gutierrez's cell phone in the freezer. That law enforcement's there for 8 days. They'll claim that they searched, they processed, they were very thorough, yet they didn't find Mr. Gutierrez's cell phone that was right there in the freezer or the contents of his wallet that were in the freezer. So they did swab the cell phone for DNA, but what they didn't swab or process for fingerprints were the cards that were found, which, according to the state's theory, the person who's involved in Mr. Gutierrez's disappearance would have had to touch, to take out of the wallet, to put in the freezer. And they also didn't process the handle of the freezer. It's also critical that there was no blood on the handle of the freezer. And the phone, interesting enough, the DNA, they send the swab that they took to the crime lab, and it comes back and they say, yep, it's Mr. Gutierrez's DNA on the phone, but there was something that's called a trace allele. And you'll hear from the DNA expert that a trace allele means that it's someone else's DNA, that it's a portion of someone's DNA that did not belong to Mr. Gutierrez, but someone else. And you'll hear that that trace DNA that they found on that cell phone, as I just said, did not belong to Mr. Gutierrez. It did not belong to Ms. Patterson, the individual who found the cell phone, and it did not belong to my client, Mr. ZACHARIAH Anderson. So someone else's DNA is on that phone. You'll also see pictures and hear testimony about how the furniture in Mr. Gutierrez's apartment had been moved. And all of this furniture had been meticulously moved. Nothing's knocked over, nothing's broken. The kitchen table's nicely pushed back. The 2 white tables that were in front of the couch were nicely moved to the side. The couch had been moved, and we can see that because there's indentations in the carpet of where the couch had stayed for a long time versus where it was now. There were no bloody fingerprints or hand marks on the bottom of the couch. They didn't process that for DNA in that area of a couch where the person had allegedly moved it, would have had to have touched. They didn't process the areas of the chairs that would have needed to have been moved, the table that would have needed to have been moved by the person who's allegedly responsible for the disappearance of Mr. Gutierrez. They also didn't process the tools that appeared to be nicely laid out in front of the screen door. Nor did they process in Mr. Gutierrez's bedroom the open window. They didn't process that for fingerprints. What did they do? They processed the blood. That was it. Law enforcement's failure to investigate leads and to effectively process a crime scene is critical in this case. There's no body, no human remains, no murder weapon, no witnesses that can tell you exactly what happened. Yet they wanted to go with the narrative that it must have been Mr. Anderson, and that was someone that they looked into everything possible. They ignored everything else. They ignored the idea that it could be anyone else other than Mr. Anderson. And you'll hear that they meticulously searched Mr. Anderson's property, not just his house, his whole property. No body, no human remains, no evidence that there had been a huge cleanup at a crime scene, no murder weapon. Not only did they search his house, they also searched his family's tree farm, an 80-acre farm, top to bottom, multiple law enforcement agencies, every acre, no body, no human remains, no murder weapon, no evidence of a crime scene cleanup. They also searched Miss Susan Brown Williamson's home, and that was the place that Mr. Anderson had gone in the morning to work that the state claims is where Mr. Anderson, I guess, chopped up a body and put it in bags. They searched that property meticulously, not only the house, but the entire grounds. No body, no human remains, no murder weapon, nothing of evidentiary value. They then searched all of the bodies of water that were near that home and Mr. Anderson's home, not Lake Michigan, but quarries and little lakes. And they had technology that could go all the way down to the bottom to see if there was anything there. That search also revealed nothing. So the person they chose as their main character, the only person they investigated in this case, they did all of that and it yielded nothing. Mr. Anderson, as he sits in front of you today, is presumed innocent. And he must stay that way. Because the evidence in this case, as it will come in through this trial, will not establish that Mr. Anderson committed the alleged crimes beyond a reasonable doubt. And for that reason, when the defense comes and speaks to you, when the evidence is done, we will ask that you return the only just verdict, and that's a verdict of not guilty. Thank you.
All right, folks, we'll start with the taking of evidence at this point, and as I indicated, Christie, you'll be allowed to take notes if you wish. You're not obliged to. If you do decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may use your notes during your deliberations to refresh your recollections. Otherwise, you should keep them confidential. After the trial, the bailiffs will collect the notes and they will be destroyed. Okay.
Judge, can I be heard briefly?
You can.
Okay. As part of my withdrawal of my objection, the court will recall that we proposed a cautionary instruction. So the withdrawal of that motion was based on the cautionary instruction, which I hope the court will read.
I will, and I even told them that you'll have to remind me because I'll probably forget it. Thank you, because I did. This is a joint proposed cautionary instruction that the attorneys have agreed upon. And it states, unless otherwise guided by the court, you must disregard any statement by the attorneys or either of them that any specifically named individual other than the defendant was involved in the alleged homicide of Mr. Gutierrez. Any question about that? This is something they've agreed upon, unless I tell you otherwise. You should disregard any statement by the attorneys that any specifically named individual other than the defendant was involved in the alleged homicide of Rosalio Gutierrez Jr. Any question? Okay, thank you. All right, Mr. Gradley, you might call your first one.
Several things that before the first witness is called that the parties would like to address with the court pertaining to stipulations and things of that nature. So I believe that would be more appropriately done now before the first witness is called.
Okay, so that's legalese for scram. Now you can go, and I'm going to try again to keep it at just a couple of minutes. But you're welcome to go upstairs if you want, or otherwise you may remain down here in the library. And I'm hoping this will take under 10 minutes, maybe 5. Okay, thank you. In the meantime,
What are we hoping?
if I can talk to someone from Court TV, I can't get my computer cranked up this morning, and I'm wondering if something got detached while you were up here. I'm not blaming you. I don't want to call IT unless I have to. it won't stay on. I mean, the light goes on, so there's power.
Here we go with Judge Schrader and his lack of technology knowledge. All right, so while they're on this quick little break fixing this issue, so some breaking news for us. I told you guys I would tell you as soon as I had it confirmed. So those of you may have heard that a Kenosha car dealership, a young Black woman from the Waukesha, Wisconsin area, had driven down to Kenosha to look at purchasing a vehicle from a local Kenosha car dealership. Had to give her ID while she was doing a test drive of the vehicle, and decided not to purchase the vehicle. Kind of had a bad feeling about the dealership itself, and decided to not purchase the vehicle and left. She forgot her ID behind. The result of that, a video was posted to the Snapchat social media platform from members of the dealership who had her ID, claimed they didn't when she called back trying to get it back, claimed they didn't have it. And in this video, and you guys can watch that video, it's on our YouTube channel. I would watch the re-upload version because that's a kind of correct edited version of the video that we put up. But claimed they didn't have it, and then we're seen urinating on her ID, followed by a picture of the Trump Hotel carpet with these gentlemen in there. A very racist move and very disrespectful move, urinating on her ID. It's pretty disgusting. Followed by that, a lot of hate came to the dealership. The dealership changed their company name on Google to something very similar to a Racine car dealership. And because all of you super sleuths react very quickly, the Racine dealership ended up getting a lot of backlash and a lot of hate wrongfully because they weren't the dealership. We've tried to reach out to the Kenosha dealership multiple times. They have not responded, but the Racine dealership is offering a free car to the young woman who had this happen to her. And we have an interview set up with them tonight at 7 p.m. So we'll do a live stream interview. We'll invite them on. So make sure you guys are here for that. We'll go live at 7 p.m. and we'll hear from them about what happened to their dealership because of this whole box of crazy. The effects that they suffered and what they're offering to the young woman. So make sure you guys are here for that. That'll be a fun, interesting stream. I wanted to give you guys a heads up and let you know about that. 7 p.m. Central Standard Time tonight. Exclusive interview chat. Exclusive. How's everybody doing this morning? Make sure you guys hit that thumbs up. Please share this out, guys, everywhere. Share it out on Facebook. If you have Twitter, Instagram, wherever, please share it out. We can't go live on Facebook for another, I think, just under 2 weeks now. But once we can, we will start multi-platform streaming again. We caught a 30-day ban on Facebook for trying to live stream the Jeffrey Dahmer trial from 1992. Apparently, Jeffrey Dahmer is considered a dangerous individual. Like we didn't already know that. But kind of interesting. You can't even post about him, apparently. What else? We also do have the day 15 XXX Tentacion trial. That is also live on our platform right now as well. Some of you are interested in that trial. So we do have both trials going on simultaneously. Over there, it is still, the camera's still facing the wall. That courtroom is always late. It's kind of a box of crazy over there. The camera guy over there is horrible. Kind of almost ended streaming that trial just because of the issues with the camera person, but we're trying to get that trial finished. For this trial, chat, make sure you guys are here every day, or at least as much as you possibly can. At the end of the trial, we did this during the Mark Jensen trial in Kenosha. We will go, Jesus Christ, my phone is going off. We will do another mock jury. So we did a mock jury. We had our viewers come on. We did a whole like jury voir dire questionnaire that we sent them through their emails, and they were fun questions, silly questions, and then our viewers came on the stream. They had their jury numbers as their names. They didn't have their cameras on, so even our chats, our chat members had no idea who was in our mock jury. And our viewers then deliberated the Mark Jensen case as if they were the real jurors. It was a lot of fun. It was a fun stream. I would love to do that again for this trial. So it'd be good to get people that have, differing beliefs on whether Zachariah Anderson is guilty or not guilty, or you're undecided. So if you would like to be part of that, you can check out what we did for the Mark Jensen trial. It's under the live stream tab on our channel. You can kind of see what we did. I read the jury questions out loud. Each juror was given different questions. And again, they were funny, they were silly. And you get to listen to what our viewers were deliberating, and they were talking about the evidence. So if you want to be part of that at the end of this trial is only expected to go about 2 weeks. So get your pens and papers out and take notes. Take notes. The only thing that we require is that you're here for at least 75% of this. Obviously, you all have lives, and it's okay to miss some days or parts of the stream or whatever. But it makes for a kind of more fun and more educated mock jury if you guys are here for the majority of the time. But yes, please, guys, everywhere, please share this out. We're banned on Facebook, so even us posting the YouTube channel or any posts on our NSM News Updates Facebook page at the bottom of the
Entitled
feed.
Stipulated Facts Regarding Statements of Unavailable Witness, the name Douglas, and would you like it read or just in the record? And at the appropriate time, it'll be given.
Yeah, I'd like us to be able to read it to the jury as part of the evidence. My proposal to the court is that at a time that I would have called Miss Douglas, which will be this morning, which is why we bring it up now, that the court will allow us to read it. I will either read it in its entirety, or if defense counsel wishes to in some way read the first portion, the paragraph that is regarding Officer Paul Chase's report, I of course have no disagreement with that. And then I will read the second half to the jury. And then of course the court can have that stipulation in evidence, but we'll read it. I'll read it verbatim, or we will both read it verbatim. Miss Douglas is having met why we've tried to reach this stipulation, prevent her from having to be present. She has no prior convictions, so in terms of any impeachment, we're also aware of that.
Is this a correct statement of the stipulation? Are you familiar with this?
That is correct, Judge, and the defense would prefer that we read the portions as it relates to Officer Paul Chase's reports, and then the state will read the portion as it relates to the telephone call that was had with their victim witness coordinator, Heather Beasy. So that would, and we have no objection to it being read at the point where the state would have called Lene Douglas. We think that's appropriate because that will be around the time that other residents of Wood Creek apartment will be called. So it would only make sense to read that stipulation in then and there. I have given a copy of the stipulation to Mr. Anderson. He has read that and is, as far as I know, unless it's changed now, is in agreement with the stipulation.
All right, do you fully understand what is contained in the stipulation? And any questions about it at all? By stipulating this, that means the witness will not testify, and instead the jury will be read this stipulation and its stipulated facts. That means that the jury will be instructed that those are proved facts in the case, and there'll be no testimony admitted either to reprove those facts or those assertions, and there'll be no testimony permitted to disprove it. Stipulation means it's agreed. Is that clear?
Yes.
Any question about this at all?
No.
Has anybody threatened you, pressured you, or forced you in any way?
No.
Has anybody promised you anything in exchange for this? No. All right. Anything else then before we start?
Just that the first witness the state intends to call, Detective Lauren Anschutz, has no prior convictions. And another witness that we would call, hopefully without needing an additional break, would be Marissa Swanigan. She's the individual who's here on the warrant. She also has no priors. And so I believe that in terms of these early witnesses that we would call before there would be any additional breaks, that I think we've met our obligation to let the court know about any prior convictions.
Okay.
And we are in agreement with that calculation to the witnesses that the state just mentioned. And as the state said, we'll work diligently in getting the other convictions for the other witnesses to present to the court at a later time.
So let it be written, so let it be done.
I believe we're ready then, Judge, at
All
this
right.
point. Counsel, do you agree?
Yes. Well, unless.
All right. How did we do that time-wise? Pretty good? All right. Close? Okay. All right, thank you. Go ahead, Mr. Gately.
Your Honor, the state calls Detective Lauren Anschutz to the stand.
Is he out of the room?
He's being brought, he was outside, he's being brought in by our victim witness person.
Okay. I do solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please be seated.
Detective Anschutz, can you state your first and last name and spell both your names for the record?
Lauren Anschutz, Lornanschutz.
Detective, how are you employed?
City of Kenosha Police Department as a detective.
How long have you been a detective?
approximately 7 years,
And how long have you been a police officer with the Kenosha Police Department?
just under 20 years.
During that time period, have you had an opportunity to investigate scenes where blood was present?
Yes, several.
And do you have an estimate in your 20 years how many times you've come across a scene of that type and had to make some sort of decisions regarding either what to do next or what there was there?
It's several hundred.
In that capacity, as being on duty as a detective, did you come on May 19th, 2020 at just after 11 a.m. To be at a particular location that you were asked to go to?
Yes, I was told to go to 3709 15th Street for a suspicious incident.
And when you got there, were you the first officer on the scene?
No, there was multiple officers, a sergeant, another detective, and
Would it be would that be uncommon that other officers would get there before a detective for a call like this, or would that be standard that you detectives would not be called in as the first officers to arrive?
yeah, I've never been called first as a detective to respond to any scene. Typically, the officers will respond, make an assessment, talk to supervisor, and then we will be notified to respond.
And when you arrived, I don't want to know all the details, but what were you in general appraised of? So what were you told in general was the situation when you arrived before you made observations for yourself?
I was told that apartment 1B had a substantial amount of blood inside. It appeared as though there was a major incident occurred in the apartment and nobody was located.
And was that information provided by law enforcement?
Yes.
Were you provided information that the person reporting this was still on scene?
Yes.
And did you have a chance to interact with that individual?
Yes, I spoke with her, Sadie Beecham.
Okay.
Sadie Beecham was on scene. She was sitting in her car at the time I spoke with her.
And did you come to believe that Ms. Beecham had not fully entered the threshold of the residence, had not walked through the residence before calling law enforcement?
Correct.
Okay. So based on that, would your role in this case be to specifically search for a body or somebody within that residence, or would that be the role of other people who were at the scene?
That would have been the role of the responding officers to preserve life, to make sure the scene is secure.
Okay. And back before you were a detective, were you in that role many, many times over your career?
10 years, yes.
Okay. And so in that earlier role than yours, would it have been a priority to search for a person and not worry about what the evidence was, or are you already an evidence preserver in that first role that you described?
I'm going to object as far as leading.
Well, it had an alternative, so the objection is overruled.
Go ahead.
Can you rephrase, or can you
Sure.
give me the question again? Sorry.
Sure. In that earlier role, is the priority to do the search as quickly as possible, or to meticulously try to preserve evidence, like not step in things, et cetera, et cetera?
In those situations, you're concerned about the safety of others. That's your main focus and priority at that moment, as well as scene security. We don't know if anybody's in there. So that's what you're vigilant of when you first enter, and then obviously after you can slow down and then focus more on the preserving of evidence.
So I want to turn your attention to the address one more time. You said it was 3709 15th Street, apartment 1B. Do I have that correct?
Correct.
And do you know, is that a part of a complex, or is that an isolated single-family location?
So it's a larger multi-building apartment complex. I I believe there's 3 or 4 different addresses per building. 3709 is a in the middle of one of the buildings with an entry door specifically to that address. On both the west or north and south entrances of the apartments, you can enter either side. Once entering, there's 4 apartments downstairs, 4 apartments upstairs.
So this specific building that you're speaking of so far has 8 apartments. Did I get that correct? 4 up and 4 down?
3709 15th does have 8 apartments, yes.
Okay. And you are focused, of course, on one apartment of those 8. Is that true?
Number 1B.
Okay. Is that location, is that overall complex, does that have a name here in Kenosha?
Yes, called Wood Creek Apartments.
Okay. And is that address specifically in Wood Creek Apartments, that 3709 15th Street, is that in the city and county of Kenosha
Yes,
and in the state of Wisconsin?
yes.
And where is 1B in relation to the other apartments in the building?
It would be the northwest apartment. So of the 8 apartments, it's on the first level, northwest apartment.
So it's first level. And is it closest to the main doors that face the parking area on its side?
Yes,
Okay. And then there would be a second floor of apartments.
correct,
So if I understand correctly, 1B would have an apartment directly above it,
correct,
and it would have an apartment across from it.
correct.
And then it would have an apartment on the side of it as well.
Yes, so the way yes.
When you were there that day, what can you say about the weather conditions that were being experienced?
We had received a substantial amount of rain, so everything was wet. It was gloomy, cooler.
You say substantial amount of rain, just a short rain, a Wisconsin short rainstorm or something larger?
No, it had been days of rain.
And had that rain been going for multiple days before you arrived at the apartment on the 19th of May?
Yes,
Heavy rain.
a substantial amount of rain, very
Okay.
heavy.
Thank you. So when you got there, Detective, you arrived, there were already officers on scene. You indicate you speak to a person who identifies herself as Sadie Beecham, and she's located by her car. Is that correct?
That's correct.
Is it still raining outside in your memory?
I don't recall. I know it wasn't a downpour. If it was raining, it may have been sprinkling.
Okay. And at that point, what, if anything, did you notice about the demeanor of Sadie Beecham?
She was scared. She was visibly shaking, having a difficult time spitting out words, frightened, worried.
Could you tell what she was scared about? In general?
I'm going to object speculation.
What, if anything, led you to conclusions that she was scared other than these early physical observations?
I'm going to object again as to speculation to how his conclusions that she was scared.
People don't talk the way lawyers want them to. The lawyers are taught that the witnesses are to testify only to things that they perceive with their senses. I saw this, I heard this. That's not the way people converse in ordinary discourse. They combine their observations with the impressions that they personally have formed, which do often involve some degree of speculation, and sometimes involve making suppositions about what others are thinking. That's not how we talk in ordinary discourse, but when we get into the courtroom, the lawyers want to pin it down to exactly what the witness personally knows, what the witness has perceived with his own senses, But what the question is calling for is really a composite of what the detective personally observed and somewhat the conclusions, and they're suppositions as to what may have triggered the response that he was seeing with his senses. So I'm actually going to allow the answer, even though it does incorporate some of that, so long as you folks understand that there's going to be some supposition, and it can be dealt with further on cross-examination. But there will be some supposition built in, and not things that he actually has observed. So, do you understand the question? Do you remember the question?
No, I'd like it repeated, please.
So you've indicated she was shaking. You
Yes.
made a physical observation that she appeared frightened.
Yes.
Any other observations or information lead you to conclude she was frightened other than that physical observation you've testified to so far?
Yes.
And what was that?
She was concerned about her children.
I'm going to object. This answer is
Yeah.
hearsay.
That's it's supposition.
I'd briefly like to be heard.
Well, I didn't say.
Okay.
Now see, I'm supposing what you're thinking.
Wait,
And
I
bet
believe
I'm
you
right.
are. I believe
bet
you are.
I'm right.
Yep.
And we can have that discussion separately if and when you ask the question. But in terms of this particular question, it is not that it's hearsay, it's that it's supposition. So I'm going to sustain the objection.
All right. I'm going to head the direction you are anticipating now then, Your Honor. So, Officer, at the time that you first spoke to Sadie Beecham and she provided you information, was she physically shaking?
Yes.
And did she show signs to you that she was still experiencing emotion as she was speaking to you about what she was telling you?
Yes.
Was it, would you describe her way of expressing herself as calm or excited or distressed? What would be your explanation of the phrasing and wording and tone of her discussion with you at this stage in your contact?
She was truly scared of, petrified about what had happened.
Judge, I'm going to indicate to the court that this is an excited utterance and ask the court to allow admission of anything that was during the physical observations he's expressed.
And Judge, I would object. This witness has already testified that he was not the first individual on scene, so that there were other individuals who had spoken with Ms. Beecham prior to this. Several time had passed. Also, excited utterance has to deal with that immediate impression. Nothing was ongoing at that time. The defense would maintain that given the time that had passed and the time that had passed since she had made these observations, any subsequent statements made to Detective Anschutz, it does not fall under the excited utterance exception to the hearsay rule.
Well, let's begin. First of all, it's not my impression that they're actually being offered to prove the truth of what is asserted in the statement. I don't think the district attorney is offering this proof the content of the statement, which is asserted. Second, it's a non-testimonial statement, so we don't have that concern. And to the extent that it would qualify as here's definitionally hearsay statement, it is, I think, an excited utterance. The law with respect to excited utterances, the key is not, for example, the passage of time or the intervention of others. It's the spontaneity of the statement which is made. And given the situation that existed as portrayed in the testimony, I'm going to overrule your objection.
What did she,
I guess the couple of things, Judge, just if I maybe heard. First, we haven't heard what the statement even is.
Yeah, that's correct.
And second, if the state's premising their question that they're seeking to introduce the statement under the excited utterance hearsay exception, then they must be offering it for some sort of truth, or else they wouldn't need a hearsay exception.
Well, you're right, and that's why I let off actually starting with the confrontation, or actually, I actually started in my analysis with whether it's even subject to those rules, because it's excluded from the operation of the hearsay rule. So I would not even accept the premise that he needs an exception to get it out of the hearsay rule. But I understand your point, but I'm going to overrule the objection. Go ahead.
so my question is, what did she say to you when she was in the condition you have described?
She had told me she got to the apartment, observed the screen door closed, but the glass door opened. She looked inside, saw blood everywhere, and walked out. She said she was frightened for her children because she knew Zach Anderson had something to do with this, and
Judge, I'm
she
going to
was
object at this point and ask that be struck.
Judge, this is all during what she said during the examination. She's going to testify. This is subject to cross-examination. The officer should be allowed to finish saying what she told him on the scene in this excited state and not be interrupted unless there's a new objection. The court's already ruled that in that state, she can say this.
Well, I've ruled that when she's in this state, she can state things that would be normally reactive to a situation in which she found herself, but now she's getting into her analysis. There's actually another rule, which is the present mental state, purpose or plan, which probably would give some relief to the district attorney. But the problem with the testimony is it's reaching into the ultimate facts of the case, and it is relayed testimony for a witness who's available to testify. And correctly, you state she's going to be subject to cross-examination, but it's not as it's her opinion about the what she's concerned about is inadmissible. It's irrelevant what she thinks.
She expresses a alarm to officers.
Yes.
I think that typically a person who has observed a crime scene is allowed to tell an officer.
I don't want to talk about typical.
Oh, okay.
Okay.
Well, so in this case, she arrives at a crime scene. She has an abundance of evidence that, of course, is not in this case so far, right? But she has an abundance of information. She is in a highly frightened condition, according to the officer, and she expresses fear for her children because of something specific. I don't think any of that's irrelevant, nor is it hearsay.
The problem is that starting with the testimonial nature of it, it's still not. But we're getting to the point where you're getting into what should come in, if it's going to come in at all, as testimonial. She's not subject at this point to cross-examination. So I'm going to sustain the objection.
After she expressed fear for her children, what happened next in relation to Sadie Beecham?
Due to her concern for the children, she
We've got to move on to the next step, because he's incorporated the objectionable material into the beginning of his next answer. So just what happened next is the question.
Sadie left to check on her children.
And after that, did you then take it upon yourself to be part of an entrance into the residence?
I did.
Okay. Up until that point, what had you done in relation to the residence, if anything?
I peered in the sliding window, didn't enter, and I also walked into the hallway through the front entrance and looked around in the hallway.
I'm going to now show you what's been marked as Exhibit 1 in this case.
Exhibit 1, Photo 1.
State's Exhibit 1, Photo 1. It's going to come up on the screen up there. I'm going to ask you if you recognize.
Judge, I'm going to ask that it not be published for the jury before it's been admitted, that it needs to be shown to this witness first, not in front of the.
Well,
Let me talk to counsel briefly about that.
Okay, and I will
so
say-
that she understands at least what I'm talking about.
okay,
If I created an alien language in that moment, I wouldn't be surprised.
Shut up and sit down.
That it not be published for the jury before it's been admitted, that it needs to be shown to this witness first, not in front of the.
well,
Let me talk to counsel briefly about that.
Okay, and I will
so that
say-
she understands at least what I'm talking about.
okay, and based on the electronic experience we've been having this morning, it may not show up on the screen anyway.
Her objection, but she's first asking that I read a stipulation. This is a stipulation that we have previously provided the court, and it's about the admission of evidence that comes in either pictures or downloads. If I have your permission to read that stipulation to the court.
You may do so.
So this says the below signed parties stipulate. It's signed by both myself and Attorney Miller. It indicates the below signed parties stipulate that all photographs, financial records, phone records, social media records, computer downloads, and phone downloads be admitted into evidence without foundation testimony. The purpose of this stipulation is to allow all parties to discuss and question witnesses regarding these records without having to previously set a foundation. So essentially what we are doing, Judge, is we're stipulating that, you know, oftentimes in a courtroom, we have to bring in somebody to say who took the photo or how was the photo compiled. You know, there's additional witnesses or additional time. We're just going to seamlessly show those records as long as we make sure each other are apprised to try to save that time, because there's an enormous amount of records and photographs, as the court is aware. Is that true, counsel?
That is true, and I just thought it was appropriate to read that stipulation prior to it being shown to the jury, so there was that understanding and the record. But any objection to it being shown now is withdrawn, now that that stipulation's been read.
Thank you. All right. Best.
Again, I'm going to show, Detective, I'm going to ask you to turn your attention to the television that's above the jury and look at State's Exhibit 1, Photo 1. Assuming that it works. Judge, does your laser pointer work onto the television?
Doesn't work on the glass.
Okay.
But I do have,
You have the old school?
I have Sister Marcienne's, where is it?
Oh, can you?
Many's the time. It's not going to come on? Oh.
Okay. Just works perfectly and seamlessly, Judge.
Yes,
Yeah,
indeed.
all right. So,
If he's going to be using the pointer, maybe we'll give him a mic. Let's hope we've got power in this.
So, Detective, as you look at this, do you recall what this is a picture of, or know this picture contemporaneous with what we've talked about, May 19th, 2020?
So this would be a picture of the north side of 3709 15th Street from the parking lot, looking at the entrance to the residence.
The residence we've talked about, apartment 1B?
Correct.
And can you tell by the conditions of the vehicles and the roadway there what the weather conditions are at the moment these pictures are being taken?
It's either raining or had rained.
Is there, do you see a white larger vehicle that's prominent in the center of picture 1?
Yeah, should I point?
Yes.
This one?
I'm referring to that vehicle. Do you recognize that vehicle in the context of this investigation?
I do.
Okay. And what is that vehicle?
That's a white Ford Explorer, Colorado plates. That was belonged to Rosalio Gutierrez.
Okay. And is that the individual who you believe to reside in apartment 1B?
Yes.
Is Rosalio's sliding doors, in other words, a non-hallway entrance to his apartment or exit to his apartment, is that visible in this picture?
Yes, it is.
And can you point out where that is located within this picture? Okay. There appears to be a yellow sort of tape or rope that is located in this picture as well. Do you see that?
Yes, that's crime scene tape.
Okay, is that in a couple of locations in this picture?
Yes.
Can you point out again with your pointer where that is?
There's some here stretched, and then some from the entry door to 3709 stretched out towards the parking lot.
And based on your knowledge of these investigations, who put that up in general?
Usually the responding officers will area off so no one comes or goes.
This is after they make their initial assessment of safety and security?
Correct.
Okay. And so at the point that you have finished speaking to Sadie Beecham initially, is this the vantage point, or is this the view you are seeing back on May 19th?
Yes, that's accurate.
I'm going to show you now what's been marked as picture 2 of Exhibit 1. Do you see that picture as well and recognize that?
I do.
What is that a picture of?
So this is the main entrance to 3709. This would be the sliding screen door, glass door to apartment 1B, which is just inside the door to the right.
And do you recall whether the overall building where you see this door here, is that a locked door or is that an unlocked door to get into the main hallway?
That is unlocked door. There's also a door on the other side of the building that you can enter this hallway that is also unlocked.
Okay, so at this period of time, this apartment complex did not have locked doors into their central hallway.
Correct.
And what would you estimate is the distance from the Rosalio Gutierrez sliding door that we can see there onto that small patio, and then down to a vehicle parked directly parallel below? How many feet would you say that is, or however you want to estimate the distance?
25 to 30 feet.
Okay. And much of it is grass?
Yeah, there was a small concrete stoop and the rest grass, then sidewalk.
And of course, the concrete, the sidewalk and the patio would be probably concrete?
Yeah.
All right.
Yes.
Now I'm going to show you what's been marked as Exhibit 3. Again, is that something you recognize again from May 19th, 2020?
Yes, this is going to be the front entrance door to 3709 15th Street. This would be the sliding glass door to apartment 1B.
So it's a different vantage point, a little closer up.
Correct.
Now I'm going to show you what's been marked as Picture 4, Exhibit 1. Do you recognize where that is located on May 19th, if you do?
Yes. So when you enter that main entrance door that you just saw in the last photo, there's a stairway leading to the upper section of the apartment complex, and this would be immediately to your right underneath the stairwell. This is the door to apartment 1B.
So as I look at Picture 4, can you orient me on either direction where that front entrance hallway to the hallway is? Is it further down the hallway, or is it off to the, I guess would be the right of the exhibit?
I'm sorry.
The main doorway we saw in Exhibit 3 that takes you into the hall.
Okay.
Where's that located vis-a-vis this picture?
So this photo is taken just inside that main entrance to 3709.
Okay, so essentially this is taken in the doorway of the entrance we saw in Picture 3?
Yes.
Okay. And so how many feet, again, would you estimate it is to go from that doorway entrance to the doorway of 1B?
10 to 15 feet.
Okay. And there's a stairwell there?
Correct.
If a person wished to, could they ring the doorbell or knock on the door at 1B and be able to stand or crouch to one side or the other of that door? Is there room to do that?
Yes.
And where is there room to do that depicted on this picture, if it is?
So this is a small hallway or a small wall that extends out. If you were to go around to the other side of this, you wouldn't be seen. You also could back up to where the photo was taken and not be seen. And also there's a void here underneath the stairwell that you could stand or crouch under the stairwell and not be seen.
Are the metallic objects to the right of the door depicted on this picture, are those mailboxes?
Yes, those are the mailboxes for the 4 lower units. These are for the 4 upper units.
And based on how high up the stairwell is, if you can estimate, does a person have to sit down to be able to get to their mail, or if by bending or standing, are they able to reach their mailboxes in this picture?
You're able to walk up to it and get that mail.
If you know apartment 1B, does that door open, again, only if you know, does it open into the hallway or into the interior of the apartment, if you recall?
It opens in to the apartment.
So, and did it have a doorbell of some kind, if you recall?
Not in the hallway here.
Okay. So if a person knocked on this door and then did not become visible, is there one of those eye holes so that from inside you're able to see into the hallway?
Yes, there's a eye hole.
Okay. So if you kept yourself off to the side so you were not visible in the eye hole, the door opens back into the apartment if somebody is inside and they are opening the door to see who knocked. Is that correct?
Yes.
And until somebody peeked out, in other words, brought their head out of their apartment, that area by the mailboxes would not be visible to them until they somehow extended their head out into the apartment or took a severe angle after opening the door. Is that right?
I'm going to object as far as foundation, this witness's knowledge of whether that's possible and whether he attempted to do that himself.
I think he can make estimates based on his observation and how the door works. I mean, he's a physical observer. He's an eyewitness.
I think it's subject to analysis as something that he can perceive without any particular expertise beyond that of the ordinary layperson. But it's his description of it makes it more makes it easier for the jury to understand. Objections overruled.
Did you understand my question?
Go again. Sorry.
Sure. If somebody is crouching or attempting not to be seen and they're in the area of the mailboxes, okay, and they knock on the door and the person inside opens that door to be able to see somebody over by the mailboxes, would they have to poke their head out?
So I would say you would have to break the threshold of the door. We train on clearing room clearing in law enforcement. And in order to see up against this wall, we have to break the threshold. That's one of our main concerns when we clear rooms before we enter them, is a blind spot up against the wall right here. We can pie the room off all we want, but we can't see this. Even if we're standing way on the other side of this door, looking on an angle, we can't see against the wall. And that's our main concern when we enter rooms, because we can see the whole room except for tight against the wall.
When you say clear a room, does that mean to try to figure out if there's danger to you in that next room?
Correct.
And would that danger include a person having a weapon?
Yes.
And do weapons include everything from guns or knives to clubs or hard objects that could hit you?
Correct.
Okay. So when you clear a room, you're worried about all of those possible threats in the possession of a person who might be crouching. Is that right?
Yes.
So did you, before you entered the rest of the apartment, were you able to make observations that concerned you at the location we're talking about? In other words, then the door and the hallway that we're in right now, were there observations that you, as an officer of this extended period of time, having been to scenes with blood before, did you make observations that concerned you before you entered?
Yes. I see what appeared to be blood here. That blood was running down the wall, down the door frame.
Judge, I guess I'm
On the
going to
wall.
object to his answer saying that it's blood.
He didn't say it was blood. He said it appeared to be blood.
And, you know, Judge, this is a person whose credibility on this issue is that he's been to what he told you was hundreds of crime scenes over a period of more than a decade.
We're arguing about something that's not up because I didn't.
Yep.
The witness did not say it was blood. The
Sure.
witness said it appeared to be blood. So you're safe.
Okay.
All right.
Should I go on then?
Be my guest.
Thank you.
I'm crouching,
Excuse me.
but I'm crouching.
Officer, did you see anything else that caused you concern at this specific location in those early observations?
Yes, there was blood, what appeared to be blood on the door. There was also what appeared to be blood on a mailbox, the wall, the door, and the mailbox.
And then ultimately, did you enter the crime scene?
I did.
And do you recall what way you entered the crime scene? We've seen two entrances, the hallway and the sliders. Which one did you go in, if you remember?
We entered through the lock or through the sliding door.
Okay. Do you recall when you ultimately, if you know, do you recall whether this door was locked from the interior or not? Only if you recall.
Yes, this door was locked from the interior.
When you arrived at the scene.
Correct.
Okay. So when you entered, did you take any steps to try to be a steward of the evidence that was in any evidence that might be involved in that scene?
So at the time, it was the utmost importance preserving evidence on the scene. I wore booties over the top of my shoes. I wore a mask. I wore gloves. I didn't have anything with me. I was super cautious with transferring evidence.
So when you walked in, do you recall who went in with you, if anyone?
Detective Correa.
Just to stop you, is Detective Correa the individual seated in the here at council table with us?
In the gray suit.
Okay. Who else, if anyone?
Officer Widener and Officer Van Wee.
And do Officer Widener and Van Wee have a particular reason that they would be accompanying you within the Kenosha Police Department? Are they detectives?
No, they're highly trained in processing evidence. They're specialized in that, retrieving evidence.
So let me just ask you, to the extent you know, that's a specialty in a police department
Yes,
that requires additional training, extra training?
large amounts of training.
And do you know if, in your experience, our officer, did you say Van Wee?
Yep.
And Widener, are these brand new officers who have just started the evidence collection, if you know?
No, they're both seasoned officers who've been on longer than me, 20 years. And they have been processing evidence scenes for the vast majority of their time at the police department.
Is that why they would be sent to a scene like this one, in your opinion?
Correct. They're the best we have.
Okay. So why are they, was it a surprise that they were coming in with you, or does that make sense to you in the context of what this investigation is? Describe for the jury how come there are 4 officers coming in now. We know some officers have already been in there. They have a different role. What's going on now?
So we walked in, Detective Cree and I were the investigators on the case. Van Wee and Widener were there specifically for evidence collection. So while we were in there, we communicated with each another what we've seen, thoughts on what happened. And ultimately, you know, we picked up on things, they pick up on things, and then they completely, thoroughly process the scene.
If I said that this sounds like it was a walkthrough, is that a word, a phrase that you're aware of, or a term?
Yes.
And is that what
Nothing,
you just? Go ahead.
nothing was collected at that time. We simply walked through to get an idea of what had happened there to further our investigation.
So if I understand, it's not your role to pick up individual pieces of evidence. Is that right?
No, that would have been entirely up to Widener and Van Wee.
You're making observations to see what to do next.
Correct.
Okay. Do you observe any electronic items that are on that would at least cause you to note that in terms of, you know, why this scene would be where it is? Were there any electronic items on?
Yeah, there's a large television that had a blue screen with Rosalio, with the name Rosalio.
I'm going to show you what's been marked as Stakes Exhibit 150 and ask if you recognize that. This is, again, Exhibit 1, Your Honor, Picture 150. I apologize. I'm always mean, if I say 150, I mean the picture 150.
This is the television.
Yeah, I'll continue to say it. I just keep forgetting it. Yeah. So Exhibit 1, Picture 150. Does that depict what you have just described?
Yes.
All right. And so that's a television, I assume, that we see that has the blue screen?
Yes.
Okay. And you indicated it had Rosalio. Can you just point that out with the pointer, please?
Yeah, it appears to be in like a standby mode.
Now, it looks like the TV screen is above a cabinet or shelving that is fairly extensive in the room. Does that appear to be an accurate depiction of what you saw on the 19th?
Yes, this was on the west wall of the living room area.
All right, and I'll show you a diagram in a minute, have you point out where on the diagram. But before I do that, is there any evidence that anything has been disturbed in this? It looks like, I mean, is this a cabinet, or is this a bunch of shelving, or do you recall? If you know.
Both, I guess. I mean,
Okay.
it's cabinet with shelving, like an entertainment
Okay.
stand, have you?
Does it look like any items have been toppled from this or are disturbed in any kind of major way?
Not majorly disturbed. However, there were some items laying on the ground that may have been knocked off that. I don't know.
And were there any, as to this cabinet or this set of items, if you recall, did you make any observations about anything on this item? Only if you remember.
Yeah, there was blood spatter on the photos, photo frames, basically throughout.
Okay. All right. I'm going to show you.
Judge, again, I'm going to ask that that be struck as far as that it was blood splatter.
There's not a foundation for the witness to identify the substance which he observed as blood. So unless I'm corrected, we're going to interpret that as it appeared to be blood.
Appeared to be blood to me.
Judge, I just would like to approach just briefly. If we could just talk about this very briefly.
As you wish.
Okay.
All right, chat, what does everybody think so far of this trial? Are you guys intrigued? What do you guys think of District Attorney Mike Gravely compared to what you guys saw with Bob Jamboy or Binger and Kraus? We do have a poll up asking if you guys miss Bob Jamboy. 80% of you said no, 20% said yes. We got 3 likes, 7 people watching. Hit that thumbs up, chat. Make sure you guys are subscribed and active in the chat. Hit that bell for all notifications so you know when we go live or upload new content. We will be live
Officer,
again tonight at 7 p.m.
You just stated that an area was blood. There were some droplets there. You're not saying that you are aware that there's been some professional confirmation that it was blood. Is that correct?
That's correct. It appeared to be blood.
Okay. So when you say blood in this context, you're stating your opinion as a professional police officer based on your training and experience. Is that correct?
Correct. For now on, I'll say appeared to be blood.
But you're not saying that you did any kind of professional analysis. You're simply saying, based on what I do for a living, I'm offering you the opinion that's blood. Is that true?
Yes.
Okay. So I'm going to show you a diagram of.
He's offering the opinion that it appeared to be blood. And I would add what I said before about people in ordinary discourse add some degree of supposition and personal, or not personal knowledge, but historical experience into their answers. So if he does slip into saying blood, keep in mind that is not definitively proved. It's his opinion under all the circumstances and what it appeared to him to be. He's saying it looked like blood, but when he goes back to the police station and gets back into the ordinary discourse world, he's going to say, I saw blood in these spots. Okay? Any question about that? So there is some degree of lack of actual knowledge, and I'm gathering that this will be addressed further during the trial. So go ahead.
So now what I'm going to show you, Detective, is State's Exhibit 41, and ask you if you recognize what this not-to-scale diagram is of. This requires us to change machines, Judge, so we just need the patience of the jury. So. Can you expand out as large as you can, but still have the exhibit sticker, please? That's as far as it goes? Okay. All right. Please take a close look at Exhibit 41 for us and indicate if that appears to be a diagram of a layout, again, not to scale, that you recognize.
Yes, it's a very rough sketch of the apartment.
Does it appear to be basically accurate based on what you recall of your walkthrough at the residence at 1B?
Yes.
So on Exhibit 41, can you just point out for the jury, where is the hallway door that we saw?
It'd be right here.
Okay. And so when you enter that hallway door, what is on each side of you? So what are the first things that are on either side of you in the apartment as you enter? If you remember.
Coming through this door.
Yep. The hallway door.
So to the right, this way, would
Yep.
be, there was a couch.
Okay.
Um,
And does it appear to be an L-shaped couch?
yes, it was an L-shaped couch.
Okay. And then what else?
There was a mat standing up. And then to the left was a kitchen area. But I recall there being a wall or something here. I'm not 100% certain.
Okay. That's what happens when you first enter, correct?
Yes.
And is there a dining room table area?
Yes, this would be the kitchen. This would be the dining room area here, dining room table.
And the rest of that then, including where the couch is the living room area?
Correct.
Okay.
This whole area would be the living room area.
Where's the TV that we just saw located on this diagram?
Against the west wall.
Okay.
On the west wall.
And then where are those slider doors that we just saw that would bring you out by the street?
So the slider entrance is right here.
Okay. So when you entered, you said you entered the slider door, correct?
Correct.
And then if you enter that door off to the right, you see the TV that we already showed a picture of, correct?
Correct. The cabinet in the television photo that you saw would have been taken from similar to this.
All right. Okay, now, you're not the evidence person, so I'm not asking you for specific and sort of honed in detail, but as you enter the slider doors, what is it that you observe that causes you concern, if anything?
So as soon as I walked in, I observed a substantial amount of blood right here.
And
Uh,
located
well-
on what?
So it would have been on the carpet, pooling of blood. So within that pooling of blood, there was an obvious void where there was no blood in the shape of a rectangle. So substantial amount of blood right here, and then a void, as if there was like a rug there that had been moved after someone was bleeding.
What else did you observe that caused you any concern?
I observed a significant amount of suspected blood on this table, on the couch, on the walls, on the ceiling, on this wall, on the cabinet, on the floor throughout here, on the back wall,
So,
and some areas in the kitchen here.
so Detective, you sound like you're describing many locations in multiple rooms. Is that what you're intending to tell us?
There was suspected blood throughout.
Okay. And some of that's on the ground,
Yes,
and some of it on the ground is substantial?
yes,
Okay, a lot?
yes,
And some of it is on the walls?
yes,
And it's not just one wall, it's several walls in the residence?
yes,
And some of it's on the ceiling?
yes,
And it's on the ceiling in several areas of the residence?
yes.
What about the couch area? Did you observe any blood in that area or anything that, I'm sorry, again, that in your opinion was blood?
Yeah, so the couch had like droplets of suspected blood throughout it. However, against the backrest of the couch, right about here, there was a large amount of blood up where you would put your head, up towards the top of the rear cushion of the couch. Right here.
Okay. Do you, let me ask you about some specific pictures now and just orient me as to the diagram. So you mentioned a couch and you've pointed out that's the L-shaped object. Is that correct?
Yes, right here.
Okay. And then you mentioned that there was a table and a wall area that was over close to where the kitchen area starts, correct? Over sort of across from the couch. So now I'm going to show you what's been marked as State's Exhibit 155. Not 155, 55.
55?
State one.
State 1.
Yep, no,
55,
that's fine.
not
You're good.
155. So based on your observation of the scene at 1B, do you recognize this picture as something you observed in the period on May 19th when you were in the residence late morning, early afternoon?
Yeah, that appears to be taken right as you enter through the sliding door. Yes.
Okay, so is there a door depicted in photo 55?
Yeah. This door right here would be the door that enters into the hallway.
Okay. And then you indicated there was a couch and that you recall a wall and a table. Is the wall and the table that you recall depicted in picture 55?
This wall,
Okay.
there's a small table.
Okay. And was that an area of concern for you in terms of your observations?
Yes.
Why?
There appeared to be a substantial amount of blood on it.
Then I can see some areas that appear to be staining on a carpet or rug. Do you see the areas that are depicted on this picture? Okay. Now, you indicated in your testimony there was an area on the floor that you saw a substantial amount of what, in your opinion, was blood. Is that an area depicted in Exhibit 55?
Yeah, I had mentioned the pooling of blood on the floor. This is the pooling of blood I was talking about right here.
Okay. And there are other reddish or brown stains at many locations on this carpet. Is that consistent with what you saw that day?
Yes, it was everywhere.
Okay. And do you have an opinion as to what that was in the context of everything else you saw and know from this investigation?
It appeared to be blood.
Now, you've indicated a couch, L-shaped couch. Is that depicted in picture 55?
Yes, so this is going to be the front side of that L-shaped couch with the back of it coming, I guess, out this way.
And if we go to the right side of this picture, okay, so past where the bike is, where are we in the house or the apartment at that point? Just to orient us.
So directly to the right of whoever took the photo is going to be the television stand. And then there's a hallway right here that leads down to the bathroom and bedroom.
Okay. So we haven't talked yet about the bathroom and bedroom, and that was on that diagram. It's on the other end of that apartment, correct?
Correct.
Was there anything that caused you any concern that you remember in the bathroom?
No.
How about in the bedroom?
No.
Was there only one bedroom?
Yes.
Okay. So those two areas appear to you to be untouched, as best you could tell?
Clean. Yes.
Okay. Now, I'm going to turn your attention from Exhibit 55 to number 220, picture 220. Is 220 a vantage point or a picture that you recall from the 19th of May?
Yeah, so this photo would be standing over top of the L-shaped couch with one side of the couch going this way, the other side of the couch going this way. When I mentioned what appeared to be blood on the back cushion, this is what I was talking about.
And how would you characterize that? Was that just a small amount or a substantial amount? What in your opinion, what is that?
There was a substantial amount of blood. This wasn't just a spray. It was a large amount of blood.
And then what is the object that's located on that couch that we can see sort of in the center of Exhibit 220 or picture 220?
So that's a wallet.
And pursuant to your investigation, did you come to believe that that was Rosalio Gutierrez's wallet?
Yes.
At this time, was his phone located at this time period, if you know?
No, we did not locate a phone initially.
What about his credit cards?
I don't recall.
Okay. Did you, at some point in the afternoon hours, you can go back to your desk, apologize. Did you, at some point in the afternoon hours, come into contact with another individual who arrived on the scene and appeared to know Rosalio Gutierrez?
Yes.
And if you recall, about when was that?
It was about 2:30 p.m.
So you had been there almost 3 hours?
Yes.
And officers had been there for that period as well? You weren't the first there.
Right.
So when Mr. Campbell arrived, he had not been called to the scene, to your knowledge?
No.
When he arrived, did you speak to him?
Myself and Detective Correa did, correct.
And what, if anything, can you say about his demeanor when he arrived at the scene?
He was extremely worried, concerned about the welfare of Rosalio.
How did he know to arrive, if you know?
Objection calls for speculation and hearsay.
Let's see, how do I rephrase that? Pursuant to your investigation, did you come to have an idea how Michael Campbell knew to arrive at the scene?
Yes.
And what was that?
I'm going to object. It honestly calls for double hearsay, Judge.
You have an idea. That covers a lot of turf.
Yeah, it's really not for the truth of the matter. It's simply to orient how this person arrives there and sort of what happens next.
Well, if it's not for the truth of the matter, then
It's not relevant.
it's usually not relevant.
Well, when you said Mr. Campbell was highly concerned, what else can you say about what your observations were of his physical state when you saw him?
He was worried. He said that Rosalio was
why don't you rephrase your question? Well, we're getting into a lot of supposition, and I just think I've caught the scent of some real hearsay.
Based on the demeanor of Mr. Campbell, what happened next? So you saw him. Did you ask him some questions? And I'm not asking the answers. Did you ask him some questions?
I did.
And what was your impression of his level of cooperation or forthcomingness in terms of your experience as a police officer and investigator having arrived at the scene?
My impression of Mr. Campbell was that he was concerned for a close friend of his, who he hadn't heard of from in multiple days in a row. He was concerned.
Without talking about without talking about the content of
Judge, I'm going to object and ask that the last comment be struck from the record as far as what he did, what Mr. as non-responsive, and also it calls again for hearsay as to what Mr. Campbell said.
It certainly, this is why I was concerned about the sense of hearsay. What the testimony that the detective has given is, the appearances of whether someone appears anxious. Those are conclusions we all reach in our everyday lives, and that's okay. But when you encounter someone, even under these kind of circumstances, you really don't know what the person was anxious about. And if he reports what the other person said, if he's relating what was actually stated by the person, that qualifies as hearsay, generally. And then the impression that the detective has expressed, which is his conclusion from the whole incident, includes not only the hearsay, but also his own conclusion from it. And as I say, in our everyday lives, that is how thoughts are expressed, but it's not admissible in court. So I'm going to sustain the objection. And
so I just want to approach briefly again, Judge.
I'll tell you what, you'll probably be shocked that the Court of Appeals just doesn't automatically conclude that everything I do is right. They want, when there are discussions about evidence, they really want them taken down so they can see what I was thinking when I made a ruling on it. So if you want me to re-examine that issue, you're welcome to say so and why. On the record.
Yeah, so clearly one of the themes for the defense, you're asking me to do it now, is if I understood the court correctly.
It was my impression, now here, I'm in the conclusion business too. It was my impression that you felt that the ruling was not exactly correct.
I thought I had additional information that might assist the court. in terms of where I was going.
Morning break yet, did we? And I promised the jury. Let's take a break and then I'll chat with these people for a minute. Please don't talk about the case during the break.
Is it okay for me to go get some water?
And there's some right around the corner too. For people like me who actually drink tap water, as long as it's not from New Palestine. All right, what's up?
Police neglected to do some investigating of several aspects of this case. We have Mr. Campbell arriving at the scene without explanation, and we have certainly the defense has suggested that certain other things should have been investigated. I believe that the detective would be able to provide a factual circumstance as to why he did not proceed to begin to investigate Mr. Campbell and was instead oriented in other directions. Obviously, why officers conducted themselves at each point in this investigation is of direct relevance. That was really the theme of the defense opening here. And so I'm not suggesting, Michael Campbell's testifying, right? So again, it's going to be subject to cross-examination. But what information was shared with the detective that caused the detective to have no concern about the fact that Michael Campbell had shown up at this scene, from my perspective, is relevant to describe what the motivation of the officer is or why the officer did what he did next, which is in this case, did not believe that Michael Campbell was worthy of additional investigation or follow-up based on that moment, based on that incident. So again, it's all about the police investigation and what motivates them to do each thing, because that's, of course, been put into direct question. Thank you.
Just because there's a defense theory or theme in place and that it may address Michael Campbell doesn't mean that the hearsay rules and the rules of evidence don't apply.
Well, I think what he's saying is that what he's seeking is not being offered to prove the truth of the matter asserted, which would make it non-hearsay.
But then why is he looking to offer it?
Because it disproves something to which you open the door.
But I don't have to prove or disprove anything. So if he's looking to use that to provide an explanation, then it might not be the truth of the matter asserted for simply that point, but it is the truth of the matter asserted for then why law enforcement did or didn't do something. And
True, but that's not the assertion. The assertion is the content of what Mr. Campbell said. That's the assertion.
I mean, at the end of the day, Judge, I guess what I'm struggling with understanding here is that if the state's going to continuously ask what another individual said, and it's true that he will be subject to cross-examination, but he's not subject to cross-examination right now. So there should be an order of witnesses that if they intend on using Mr. Campbell's statements to justify further means and ends, then they should have called Michael Campbell to the stand first and then had this officer testify. I'm not sure what rule allows the state to proceed in introducing statements of other witnesses when they are using it to establish why things weren't done. So it is being used for the truth of the matter asserted.
First off, I think that confrontation is off the table. It strikes me it's not testimonial, at least not at this point. And I think he's offering it to respond to the accusation that you've made that the police did an inadequate investigation and not to prove the truth of what it is that Mr. Campbell claimed. And that would be true even if Mr. Campbell were not available. But if he's available for cross, then to the extent that there would be any testimonial component or hearsay component, that should be eradicated by his availability and your cross. So,
I have nothing further on the issue, Judge.
okay.
So I just wanted to tell the court when I inartfully, I think that's the word, right?
It's a word, but I'm not sure it's appropriate.
Well, it's because I'm not far along yet. When I inartfully raised the same theory regarding the utterances of Sadie Beecham, I was doing the same thing. As the court recalls, Sadie Beecham has been specifically mentioned in the opening. And so what she said to the officer about why, for instance, the officers, what the jury knows right now is that the officers heard from her and then they disengaged from her and they walked in the scene. That fits right into the defense theory. You got yourself a suspect right here. What do? You say, see you later. I'm
That was
highly paraphrasing.
heavily
but-
litigated. That can't be a suspect.
Finish.
But the point is, if you are trying to point out that officers are doing things in the wrong order, leaving things out, not doing it, then the information that they are receiving that causes them to do it. So in this case, my offer of proof is Sadie Beecham said, I'm terrified that my ex did this, and now I am prioritizing. I am so worried about the safety of my kids. I'm begging you to let me leave to go get my kids safe, and I'll come back. Okay, this is what she said. And so the officers let her do that, and she returns back later that afternoon with her daughter. Okay, so again, what otherwise could be depicted as, well, you got yourself a witness here, and you just let her leave, and you're not talking to her again for, X number of hours. It's explained by what the officers did, what their information is. So again, I'm not offering it for the truth, and she is going to be back. She's, Sadie Beecham is testifying in this case. What she said to the officer and whether it's legitimate and all those will all be able to be challenged. But that information to the officer is completely relevant to why he makes the decisions he does in terms of the order things happen in this case. Thank you.
Okay.
I have nothing further on the point, Judge.
Well, I think Mr. Gravely has been premature in throwing himself on his sword because I'm just picking up on it now, so I'm the one who didn't catch it right away. And the reason is it's so commonplace for the prosecutor, and not always just the prosecutor, but usually will try to fetch a little bit of extra hearsay out of the police officers by asking for some hearsay-ish information, and then when there's an objection, say, well, it's just being used to explain why he acted as he did next. And usually the response to that, as you correctly noted, is it's irrelevant. And it is. But this time, it actually is relevant because of your opening statement. So looking at it that way, it is proper questioning. So,
And then I would just ask that if these questions are going to be elicited, then I want to make the record now that I would cross-examine on those statements with this officer prior to
well,
the other individual testifying then.
the order in which he calls his witnesses, we talked about risk the other day, and we're back there because if the witness doesn't testify, then there could be an issue, although I think I've made clear, I don't think that these are confrontation issues or hearsay issues with this understanding. And so even if the witness ultimately does not testify, I don't think it would cause any problems.
I think though, in the situation where if they're eliciting testimony of what another witness would say for this purpose, that at the end, the defense would seek a curative instruction that the jury should not consider those statements for.
There's a limit to what he's going to be allowed to draw out, and so we need to be aware of that, and I'm sure he is. And if he questions to such an extent that large amounts of information are coming out that indeed become testimonial, then that's another issue altogether. But right now, I think we're still above the level of the water. So let's take 10 minutes and then we'll continue.
Thank you, Your Honor.
Thanks.
What's up, guys? What are you guys complaining about? What's the issue? You don't like anybody yet? Look, I don't like Gravely, but again, I'm from Kenosha, so I already know about Gravely. It's a giant pain in the butt. I don't like the way he talks. I never have. He's definitely irritating. The other attorney, though, I mean, I thought she's doing a pretty good job arguing for her client. Nana says this is going to be longer than 2 weeks unless they get on with it. Welcome to Judge Schrader's courtroom. I told you guys he's a dinosaur. He's a encyclopedia of information, and he's got to explain everything. It has to have an explanation. And then he sits there and he objects. He interjects himself into the trial, and then he does his own objections. It's the craziest thing I've ever seen. Like he stops witnesses from talking because they're about to go into hearsay, which I get. It's sort of cool, but at the same time, it's weird as shit though too. So it's just, I don't know. It's weird. You guys don't like the lady lawyer. Nobody ever likes the defense team. It's so funny. You guys ignore the prosecution all the time, and nobody ever likes the defense. I'd love to see her eyeballs, because she makes eyeballs and faces. I'd love to see her back in front of Judge Milosauskas. That would be funny. We already saw how Milosauskas is with other female attorneys, and especially female attorneys that make a lot of facial expressions. It's so funny. I mean, look, at least it's not the XXX Tentacion trial. There's no viewers over there. Nobody's watching that trial. Everybody stopped giving a shit. At least on our channel. We had a whole bunch of fans that contacted us and were thanking us for streaming the trial, and with all the craziness from the camera guy, like, nobody comes here. I actually like her, but she withdrew a good objection because Schroeder was boring her to death. I don't think he was boring her. I think she was losing. I think she was losing the objection. I like her for the simple fact that she's like adamantly fighting for this guy, and obviously that's what an attorney should do. Gravely, though, so you guys know, I don't think Gravely is as corrupt as Jamboy is. However, Gravely is also corrupt. He ignores evidence. It's like even with the Jacob Blake shooting that happened, right? So obviously there could be argument from both sides. But when we went to the press conference, and unfortunately we were banned at the time, and the streaming I was literally live streaming this thing, and the streaming didn't pick up, so it sucked. But we were at the press conference, and it was just hours of explanation. It was so ridiculous. We have the PowerPoint presentation that he used. That's up on the YouTube channel. But we were there, dude. We were there for like 3 hours. It was so ridiculous of his explanation. And the biggest point that he made is how Jacob Blake was doing nothing but turning his body like this, trying to shake the cops off. And then the explanation was that he turned his body to try to stab Shesky with the box cutter. And everybody is buying into this. I don't believe that that's the case. And listening to him drone on and on and on about how Blake is doing nothing but turning his body like this, trying to shake the cops off of him. I think that's what he was doing. And, your arms are flailing around when you're trying to shake people off of you. And that's what they used as the justification, but they used it as he intentionally tried to stab Shesky. But then in order to prove that further, they used a situation from years earlier. And this is how a lot of the rhetoric got tied in the initial beginning, because the rhetoric that went around at first was that Jacob Blake tried to stab Shesky, and they used a years earlier situation where he used the same box cutter and slashed an officer's vest. And they used that, but applied it to the August 23rd, that's what happened that day. And it's not. So that's why I'm saying there's so much rhetoric, but he justified all that writhing around with that situation from years early. It's two different situations. So you can't tie the two of them in like that. So it's just, I don't know, dude. I just think it's weird. But we'll see. It's only expected the last 2 weeks. I'm sure it'll be a little bit longer. It'll definitely be a few days longer. Schroeder does like to talk. He talks a lot. He has to explain everything. So as of right now, let's see. Oh, so tonight, for those of you that are listening, make sure you guys are active in the chat, right? I know some of you are like washing dishes, you're doing certain things and you're listening. But those that are not, make sure you're active. That helps us. So even typing about regular conversation with each other, that helps. It lets YouTube know that you guys are interested in what's happening, and whatever with the stream. It starts pushing us out. There's no reason we should have 6 people watching. We should have a lot more. So we need you guys' help. Make sure you guys are active. But tonight we're going to be live again at 7 p.m. So we'll get the stream set up early, and make sure you guys are here for that. So that situation that happened in Kenosha with the car dealership that urinated on the black woman's driver's license, another dealership got blamed for it because the bad dealership changed their name to something similar. And that dealership has now offered a free car to the woman. But they were affected. Bad reviews. They got their, and then because they offered the free car, and then everybody started commenting on their Google thing, they ended up getting their Google listing suspended. So they're fighting with Google. So there's been a lot of ramifications against them, even on the back end, business wise. So even when it went from the bad, and then all of a sudden everyone started praising them, there's still a consequence that is happening to them on the back end. So they are going to come on the stream tonight. We're going to do a live stream interview with them, exclusive interview with us. So grandkids, I have not. If you guys want to help me with some research on this stuff, send me stuff that you guys know. I know that this is a private law firm. This is not a public defender. Now, whether or not it is sometimes private attorney offices, they have to take on X amount of pro bono cases. So I don't know if it's that situation, but I do know that this is actually a private law firm. This is not the Kenosha County Public Defender's Office. So I know that much. The original mistrial for this case had to do with the girlfriend testifying, and it's all, and here we go again, it's all surrounded around the girlfriend being at the crime scene. So she testifies that she was there, she all these things, and it's immediately a mistrial because it's basically on that whole Denny argument again, where she's potentially a suspect, and it appears that law enforcement didn't investigate her thoroughly. And this is really what the defense is, that there could have been other people. But again, we read the Denny decision and the criteria that falls into that. But she was at the crime scene. So I don't know. It caused this mistrial the first time. Great. And the defense called for it. Gravely agreed to it. We're back again. During opening statements, defense team alludes that there could have been other people that could have done this. That's against the rules. You're not allowed to do that because of the Denny decision. And yesterday we had lawyer argument because it almost resulted in a second mistrial. But Gravely ended up backing out his objection and all of that for yesterday. The two sides came to an agreement. So the case is pushing on. But if we continue with some of this line of questioning, they're walking, both sides are walking a very fine line right now. And I have a feeling there's going to be a lot of tightrope walking throughout this trial, and especially when we get closer to the girlfriend testifying again. As of right now, so let's look at the schedule that we have going on. So we are streaming the XXX Tentacion trial. Nobody's watching. I don't know. Nobody cares anymore. I kind of stopped caring. Sound is awful. The camera guy is awful. So if you guys know of trial start in a few days, or when you guys are interested, let me know. Keep me informed on trials that are coming up. It's always beneficial when you guys can help. I can't do it all myself. But we have March 8th, so coming up in a few days. Aiden Fucci will be back in court. So he's the one that stabbed and killed Tristan Bailey 114 times. March 8th, they're coming back to court to discuss sentencing days. It is tentatively planned for March 21st and March 22nd. So we should have a better look as to whether or not that's going to happen on March 8th. So we have that. We also have scheduled, if you guys can keep an eyeball out for this as well, help me out with this one. So Christopher Shore. Christopher Shore is a Michigan cop who shot and killed Patrick Loyola. There was a traffic stop. There was a Loyola got out of the car. There was a scuffle, and former officer Christopher Shore pulled his gun out while Patrick Loyola was laying face down on the ground, and Shore was on top of him and shot him in the back of the head. So he was criminally charged. That trial is scheduled to start on March 13th. So obviously, because those are really the exact type of topics that we cover on this platform, regardless of what's happening, we are covering that trial. So ideally, we want to be covering this and the XXX trial and jump over to Christopher Shore and stream Zachariah Anderson and Christopher Shore. We also have Leticia Stotch trial that's scheduled sometime in March. If you guys want to help me find out some exact dates on when that's supposed to start, we may or may not be able to stream
those who
that.
are complaining about the room being hot.
All right, here we go. Oh, he's calling the jury. Okay, so Leticia Stotch is supposed to start. So I need help finding the days for that. Sarah Boone, the suitcase murder, is supposed to be starting April 10th. Okay. Then we have some other stuff coming up in April as well, and then in May. But guys, here is the thing. We need to start getting more than 5
You'll know.
people sitting here. I cannot continue to stream for 5 people.
Oh, I haven't done
And,
anything.
you know, even on the XXX trial, there are 0 people watching. I literally cannot sit here and keep doing
he
this.
knows what I'm talking
I'm
about.
actually putting my own life in jeopardy. So we got to get these streams shared out. We got to, if you guys can get into Facebook trial groups
Absolutely.
and share us in there, talk
And
about
I
us in
remember what
there.
Sister David
I have a
said.
hard time doing it because I'm the channel, so it's considered promotion. I'm in a couple of groups, but they know that I own the channel. So if you can get into Facebook groups, that helps us. Let's try to get more people in here. She does, dude. I think she's definitely got some googly eyes for this dude. They've definitely developed a relationship for sure. The way she looks at him and he looks at her. Look at. She's definitely got some. You guys noticing that? Am I the only one picking up what they're putting down? Make sure you guys are subscribed. Hit that thumbs up. Make sure you guys are active in the chat. All of that stuff helps push us out onto the YouTube algorithm.
Okay, thanks. I think I had sustained the objection, and after we conversed some more, I changed my mind. So the objection has been overruled.
So I'm going to return to the question, which was, what did Michael Campbell say to you regarding how he had happened to arrive at this scene at around 2:30 p.m.?
So Michael had said he was a close friend to Rosalio, that they communicated regularly, and he hadn't heard from him in a couple days. They worked together, they're friends. He also stated that he spoke with an Eileen Knoll, who was also a friend of Rosalio, and Rosalio was doing work at her residence at the time. Eileen said that Rosalio had not showed up to work at her residence multiple days in a row, and that she had not heard from him either. So he was coming to check.
Coming to Rosalio's apartment?
Correct.
And when you dealt with Mr. Campbell, how was his, as people either approach you or you approach people as an investigator, are there individuals who, when you ask them questions or are obtaining information from them, they appear to be reluctant to provide you either any information or full information about the questions you have? Do those people exist in your work?
They do, yes.
And are there also people you come across in your work who, when you ask a question, are actually trying to volunteer every fact they can think of? In fact, they're the exact opposite. They are trying to volunteer every piece of information from, again, your perspective as a professional dealing with individuals all the time.
Yes.
And if any of those are characteristic of Mr. Campbell, or if it's something else, what, if anything, can you say about Mr. Campbell's demeanor and attitude in that regard in your interaction with him at the scene? So
Mr. Campbell, when he got there, he sought us out. He was looking for us to speak to. And he provided, in a concerned fashion, the information that he gave us. I didn't feel as though he was withholding information. I don't feel as though he was hiding information. He answered all our questions. He elaborated on all his answers to the most knowledge he had to give us. That explains my encounter with him.
Based on your interaction with him, did you feel that you had to hold him or in some way keep him in a place or?
Judge, I'm sorry, I'm going to ask that the portion of the officer's testimony regarding how, and we can come up if you need, but a Hasseltine objection on the grounds of what the officer stated about.
It does sound like Hazeltine evidence.
Judge, it doesn't have to do with truth or vouching for the truth. It has to do with, again, motivating what kind of decision you can make. If one individual is in some way appears to not be providing you full information, you have one sort of course of conduct as an officer and you have to prioritize. If you have an individual where your impression, for whatever truth it is the opposite of that, and you're getting all the identifying information, obviously you prioritize other investigative avenues at that time.
Arguing no.
I thought you wanted me to. I apologize.
Well, no. I'm talking about your presenting the argument that's reserved for the later part of the case, not arguing the objection. The problem is I do think it's Hazeltine evidence. It's almost a dead ringer from the social worker testifying about believing or not believing an informant. He's made a judgment.
And it's not about, it's about level of cooperation. Apologize.
Let's do it this way. The officer's testimony is that having completed his discussion with Mr. Campbell, he felt satisfied that he didn't pursue anything further with him at that point. That is, you cannot accept the officer's conclusion as accurate. I'm not saying it isn't. I'm not saying it is. That's why you're here. He made a judgment based upon his, what he heard, and made some conclusions from it. That doesn't mean what the truth of what was stated is. Is that clear? I'm sure I could improve on that explanation, but the point is that when we talked about Hazeltine, there was a famous case where a witness who had interviewed an accuser in a case testified that, and it was, I think it was a social worker, testified that she thought that the accuser was being accurate in what she was telling the social worker. That's not permitted, because that is, the social worker is not allowed to decide the truth of it. That's for the jury. So we don't allow witnesses to speculate on the accuracy of statements made by others. On the other hand, people aren't in court all the time, and so they make their judgments based upon the world in which they live. And the detective exists in the world of investigating crimes and makes judgments. You refer to them as priorities. But none of that is conclusive on you folks. So to the extent that this testimony has been given, it can be considered only to on the issue of the quality of the police investigation. It may not be considered as supportive of the truth or accuracy of what Mr. Campbell stated. Any question about that? Okay, thank you. Go ahead.
Were you able to obtain identifying information on how to reach Mr. Campbell again in this case?
Yes, we got name, address, phone number. He provided everything.
And was there any difficulty at all in getting him to agree to give you that information?
No.
When Mr. Campbell talked about other people that he was engaged with and talking about, et cetera, what can you say about his level of cooperation in providing collateral numbers or ways to contact those people?
Mr. Campbell provided everything that he knew regarding phone numbers, addresses, all that. He was very forthcoming.
Based on all of the things we've talked about, did you believe it was appropriate to finish your conversation with Mr. Campbell and get back to the rest of the investigation of this case at that time?
Yes, he presented no reason to hold him or to further question at that time. He was free to leave. He left.
And I want to go back to our conversation regarding Sadie Beecham. Okay, now again, that conversation was before you went into the residence, right?
Correct. It was ultimately the first thing I did was
Okay.
talk to her.
Went and talked to her, and you mentioned that she was physically shaking and she appeared frightened for her children. Am I correctly summarizing that?
Yeah, she was very scared.
Okay. So one possible investigative avenue would have been to immediately take her down to the station and walk her through some more details. In other words, not just briefly have her tell you what she knew, but be very detailed about it at that first moment. That would have been a possible thing to do. Is that right?
Yes.
Were there concerns expressed by Sadie Beecham that caused you to feel that that should not be how you prioritize?
Yes.
If so, what were they?
Based on everything she had witnessed, everything that she had experienced, she felt as though her children were in danger, and she needed to get to them.
And why did she feel they were in danger in general? What was she saying to you in that initial interview that caused you to say, yeah, that's something I'm going to prioritize. I'm going to allow that to be the priority?
Because she knew, she was aware that Zach Anderson knew where the children were at that moment. So she needed to get to them and bring them somewhere where he wouldn't know where they are.
And when you say Zach Anderson, is that a person you now know in this investigation?
Yes, the defendant.
So for the purposes of our record today, when you have referred to a person named Zach Anderson, can you point out who that person is? Say what they're wearing today.
He's sitting in a defendant chair in the middle with a gray suit, tan and blue tie.
Now, as Sadie Beecham was expressing her worries about the safety of her children with ZACHARIAH Anderson, the defendant, knowing their location, was she still manifesting those physical shakings and scared things you've talked about so far?
Yes.
Based on what she told you, the content of what she said, and what you observed about her physically, did you make a decision about whether she would be allowed to take care of that priority before you interviewed her further?
Yeah, she provided where the children were, where she was taking them, and that she would be coming back as soon as that was completed.
And was there anything about her demeanor that caused you concern about her level of cooperation, such that you might feel you had to take other steps, to preserve an ability to be in touch with her?
No, she was genuinely scared.
Consequently, were you able to again interact with Sadie Beecham later that afternoon?
Yes.
And had, to your knowledge, had she been given the time to accomplish the priority she had?
Yeah, I believe she was, she left that scene after talking with her roughly 1 o'clock, 1:30ish. And I met her again at about 3:45.
Okay, now I want to now bring you back so everything we've talked about so far has occurred in the afternoon hours, starting at 11 a.m., but now the afternoon hours of May 19th. Is that correct?
Correct.
At some point, did you have occasion to know that the defendant had been placed in custody?
Yes.
And if you know, what jurisdiction or was it Kenosha police officers who placed him in custody, if you know?
No, it was Mequon Police Department.
And did he eventually have occasion to be in your presence?
Yes.
Where were you present with him? Were you in Mequon or in Kenosha?
He was arrested in Mequon, brought to Kenosha.
So your interaction with him was in Kenosha?
Yes.
And if I indicated that appears to have begun any interview of him occurred to have begun at 10:48 p.m. on the 19th, 10:49 p.m. on the 19th of May 2020, do you believe that to be accurate?
Yes.
And am I correct that the interview ended at approximately 12:18 a.m. on what would then be the 20th of May?
That's accurate. Yes.
So if I'm doing the calculation, that is 1 hour and 29 minutes. Does that sound right?
Yes.
Okay. And did you Mirandize him? In other words, read him his rights during that interaction?
Yes, he was read as Miranda rights.
And during that interaction, how many people were involved in any questioning of the defendant?
It was myself, Detective Correa, and Mr. Anderson.
And was he in an open area or was he in an interview room? What sort of environment was he in?
So we were in the interview room. Detective Correa on one side of the table, Mr. Anderson on the other side of the table, and I was sitting in between.
And at the point that you came in contact with him, had you received guidance as to what the defendant was aware of about any circumstances regarding Rosalio Gutierrez? In other words, had you been made aware that he had some knowledge of some subject matter as you began to speak to him?
Yes, it was my understanding Mequon PD had informed him why they took him into custody, and he knew why he was coming to talk with us.
And so do you believe he had an awareness based on the information you were provided that an individual named Rosalio Gutierrez had disappeared?
Yes.
So you believe he knew that at 10:49 p.m. on the 19th of May?
I'm going to object as far as speculation as to what he believed Mr. Anderson knew.
Well, Judge,
And if it's not speculation, then there's been a lack of foundation.
again, it goes to what the officer did at what point in time. Go.
If I may respond to that, Judge.
Go ahead.
Thank you. This isn't getting to why the officer did something, or this is getting into statements of Mr. Anderson and what Mr. Anderson believed to be or not to be. I think we need to make a clear distinction between the other witnesses.
Well, this is it's similar to the other witnesses, but this is a huge amount of speculation, and it's explanatory only on the issue of why the police acted as they did, which in and of itself is only is usually not an issue that we examine in any depth. There is, however, a claim in this case, which has been made by the defense, that the police did a inadequate investigation. And so to some extent, we're scrutinizing, well, you're scrutinizing the adequacy of the investigation in terms of the ultimate issue for you, which is the pursuit of the truth of this incident. His conclusion from what he heard from the defendant is totally insufficient to establish what the defendant was thinking, and is explanatory only of why he acted as he did in furtherance of the investigation. So I'm going to let the question be answered, but you must understand that under no circumstances are his conclusions legally adequate to base a verdict as to the truth of anything in our strictly for explanation of course of the police investigation. Is that clear? Okay, thank you. Go ahead.
And because of the hour, I'm going to move on to another topic, and at some other time, I'm going to come back to the interview, just because I don't want to chop that up.
What you wish?
So I'm just explaining to the court why I'm changing topics after the court ruled. Detective, did the Kenosha Police Department do some searching at a residence that they believed was owned and occupied by the defendant on May 19th, 2020?
Yes,
And was that address 6813 West Highland Road in the Mequon area?
yes,
And on the 19th of May, were you in any way involved in that search?
no, I didn't partake in any searches there that day.
And was that partly because you instead were involved in interviewing the defendant?
Correct.
Okay. On the 20th of May, were you part of a return to that address at 6813 West Highland Road to check out additional areas and to do additional search for evidence?
Yes,
And was that during the daylight hours?
yes,
And you hope that being there during the daylight hours, I assume, would assist you in searching the property. Is that correct?
correct.
Okay. Do you recall in general, can you in general describe that property? In other words, how do you get there? How do you get in there? And what in general do we have that you needed to look at?
Yeah, so it was a gravel driveway entering the property. There was a house and several outbuildings, including a couple garages, a couple old like chicken coop areas, a couple lean-to parking areas, some sheds, and I remember there being a camper parked on the property as well.
And when you got there on the 20th, did you observe vehicles that were of some interest to you at that time?
Yes, there was a black Audi sedan and a black Chrysler minivan.
And had those vehicles in some fashion come up in your interview with the defendant on the 19th?
Yes,
I'm going to show you now what's been marked as State's Exhibit 1, Photo 254. Just ask you briefly if you recognize that item from your search of that Mequon area residence on May 20th.
yes, that's the black Chrysler minivan that I saw at the residence.
And did that vehicle appear to be owned by the defendant, if you know?
I don't recall.
Okay. Then at some point, first of all, did you actually search that vehicle, or did you just observe the interior of that vehicle?
So I looked in the side and rear windows of the van. I never went inside.
And what could you, in general, observe from the inside of that van?
Observed a container of Clorox bleach wipes, an opened box of garbage bags in the back. I observed that the rear seats were out of the minivan. And I also observed that there was a large piece of carpeting removed from the back. About a third of the carpeting in the back area had been roughly cut out. And the carpet that remained had several white blotches on it that appeared to be like a bleach stain.
I'm going to show you now. I'm going to show you now what's been marked as Exhibit 1, Photo 263. Is that a vantage point or a view that you believe you observed in the context of May 20th, 2020?
So that's with the tailgate up, the lift gate up on the back. But yeah, I was peering through the window of the van, and that's what I observed.
This is the vantage point. Essentially, this is from the back, but this is what you saw when you looked inside.
Yes.
So if you could take, if the court would indulge us and let you have that pointer again, then I'd ask you to approach and first point out to me where the items that appear to you to be bleach stained.
I don't need to talk.
Where's the area that you felt appeared to be bleach stains?
This whole area here, some here, the white off-colored.
Okay. And then the area that you said was about, I think you said about a third that was rough cut. Is that area depicted in this? And if so, can you just point that out in general?
You're inquiring about the area that was cut out, correct?
Yeah, if you could just point that out for the jury. Where is the area?
This whole third back section.
And does that area include exposed wires?
It does.
Okay. And exposed sort of bottom of the vehicle because the carpet's out?
Correct. This didn't appear like a factory, like how it comes, because the under insulation area here was kind of sticking out, and a factory cut would be nice and clean. This was not clean cut.
Now, did you do anything further with the van, having made these observations yourself?
That day?
Yes.
No.
Okay. Was the van retained as evidence so that other decisions could be made about the van based on the observations at a later date?
Yes, it was secured and decided that we would take the van.
Okay. From that Highland Road address?
Correct.
And where did it go to, if you know? Only if you know.
The Wisconsin State Crime Lab.
Okay. And what is the Wisconsin State Crime Lab a place that analyzes things like this van, if you know?
Yes.
You can sit back in your chair. And so would that be the logical place you would send it for a more thorough investigation than the Kenosha Police Department is able to do?
Yes. State Crime Lab's probably would do the most thorough job of processing evidence.
I'm going to now ask that you take a look at Exhibit 1, Picture 271. Is that a vehicle or a vantage point you recognize from the residence?
Yes, that was the Audi sedan that was parked in the driveway.
Had this also come up in the interview?
Yes.
All right. And so that was also at his residence on the 20th when you arrived?
Yes.
Did you have an opportunity to search the house itself?
Yes, I went through it.
Do you recall how much land we're talking about here?
I believe it's 4 acres.
And did you have an opportunity to search the outbuildings that you described?
Some of them, yes. I personally, some of them.
Did you have a crew of people with you that day?
Yes.
Do you believe that, and was it Kenosha Police Department?
Yes.
Do you believe that all the buildings were searched on the 19th and the 20th?
Yes.
And were the grounds searched as well?
Yes.
Was there anything of note or interest to you, knowing that you've talked about the weather conditions over the last few days before and the heavy rain? Was there any anything of note in the outdoor area that was of any interest to you, particularly knowing that it had been raining?
Yes, there was a larger sized fire pit that was smoldering directly behind the residence in a grassy area.
And can we see that general area in this picture or not really?
Just here, I can point.
Yeah, if it's partially depicted. Okay. All right, you can go back. And you said that was still smoldering?
Yes.
And that, what does that mean to you? How were you able to tell it was smoldering?
It appeared the ash in the fire was still burning and creating a smoke from it.
And was it? It looks fairly sunny at the moment you're there on the 20th. Is that at least based on that picture? Were there moments of sunshine on the 20th, that you know of? It's not the 19th. It's the day after, the 20th.
Yes.
Okay. At some point, did you also find that there was a dumpster at the residence?
Yes, it's in that picture right there.
Okay. Is it a blue object in the picture?
Yes.
Were the contents of that emptied and looked through?
Yes, we actually had a dump truck or a loader come and dump the contents out in the driveway.
And was there garbage either in the house or attached to the house in some fashion, connected with the house? Garbage bags, garbage cans?
In the dumpster?
Okay. What about in the home?
Yes.
Okay. Was that garbage searched?
Yes.
And was there a trailer located at this home?
Yes, camper.
And did it have debris?
Yes, there was a trailer. There was also a camper trailer.
Okay. So I'm sorry. Okay. So there was a trailer like that somebody would use as a residence or a place they might park at a campground or something?
Yes.
Okay. Was that searched?
Yes.
Okay. Was there also a trailer that someone pulls to move items around?
Yes, it had, it was a sided trailer with some furniture and like lath and other construction stuff, I guess. Yeah.
Where was that located at the residence in general?
Next to the dumpster.
Okay. And in that, were the contents of that trailer that we've just talked about also looked at in this case?
Yes, it was thoroughly searched.
Okay. I'm going to show you what's been marked as State's Exhibit 1, picture 274. Is that the trailer we've talked about?
Yes.
Before it was looked at item by item?
Yes.
And now I'm going to show you what's been marked as Exhibit 1, page 275. Is that the same trailer?
Yes.
Is that a vantage point of the trailer that is a way shot of some tools that were located in that trailer?
Yes.
And again, is this before the vehicle itself or the trailer itself was looked at item by item?
Yes.
And then I'm going to show you what's been marked as photo number 276 in Exhibit 1. Is that a close-up of tools located on the defendant's property at Highland Road in that trailer?
2 hammers and a knife.
2 hammers and a knife, and the knife is in a sheath of some kind?
Correct.
And are these all true and accurate pictures? In other words, that's what you remember from the date of?
Yes.
So at some point, did you come to believe that persons who you could identify who had last seen the defendant described him as wearing a flannel shirt?
I'm going to object as far as hearsay. That is being used for the truth of the matter asserted.
It only goes to, again, these are people who are going to testify. It goes to why he would search for this particular item. You know, he's doing a search. It only explains why this item would be an item he is searching for. You recall a flannel shirt being brought up by witnesses saying when they when they last saw the defendant, he was wearing a flannel shirt of a certain type.
Yes.
And were you provided a picture of that flannel shirt?
Yes, I was.
So you knew precisely what sort of shirt and what you were looking for when you did this search warrant on the 19th and the 20th, weren't you?
Yes.
You weren't there the 19th, but on the 20th you were.
On the day of the 20th, I was, one of the key things I was looking for was that flannel shirt.
Okay, so I'm going to show you what's been marked as State's Exhibit 42.
Like 40, sorry.
So is that a picture provided you by witnesses so you knew what shirt to look for?
Yes, what you see is significantly blurrier than the photo that I have. It was a lot clearer, the one I looked at.
But it does depict the same shirt.
Yes,
Okay. And so you looked for that shirt
I did.
at Highland Road.
Yes.
Did you, was that shirt found in any of the buildings that we've talked about?
I was unable to locate that shirt.
Was it found in any of the garbages that you looked at?
No.
Was it found in any location on that property in any way, shape, or form?
No.
Having seen that a third of the van carpeting of a van on the property appeared to have been not industrially cut out, did that become something you were interested in?
Absolutely.
And so as you searched all of the areas we've talked about, did you look for this van carpeting so that you'd be able to account for it and see if it had any evidentiary value?
Yes.
And did you find that in any part of this property or location?
No.
Were you, had you spoken to witnesses who indicated that they had seen brand new duct tape and brand new rope at the residence just on the day that Rosalio Gutierrez disappeared? Were you told that on that same day, earlier in the day, duct tape and rope had been present at the residence?
Yes.
That was new.
What's that?
That the person believed was new.
Correct. Brand new in packaging.
And did you attempt to search for those items
I
at
did.
the residence?
I
And
did.
Were those items anywhere located at the residence?
No.
Judge, based on me finishing that topic and the next topic being a fairly significant one, I would suggest this is the ideal time to break for lunch.
No problem with that, Judge.
Any problem with that? Let's take a break and let me ask that you return at 1:15. Is that convenient? Okay, please don't read, watch, or listen to any account of the trial. And any questions? Thank you.
All right, court is on a break. Both trials, court is on a break. Let me load up the opening statement day. So for those of you that are new to this and haven't seen that,
There's no such thing. These are opening statements. They're intended to be brief roadmap, I guess, to highlight for you things that the party.
so there's weird glitches in the video.
What it is expected will be proved, and the district attorney will lead off. And after he's completed his remarks, then the defense has the opportunity to make opening statement now, or if it is preferred by the defense, they can reserve opening statement until a later point in the trial. Again, they're not intended to be argument. That'll come at the end, the closing arguments. And then the lawyers will be trying to convince you. Well, of course, they're always trying to convince you, but they're going to be exhorting you to come to a specific verdict. But these should be generally expected to be brief and informative of what they hope the evidence will show. And with that, Mr. Graven,
ladies and gentlemen of the panel, thank you, first of all, for all your service. Can everybody hear me? This will be several days. There'll be a lot of difficult and some emotional testimony, and I just wanted to thank you in advance for the time and effort and attention you're going to put in this case. This case has a lot of moving parts, and so though the judge has asked that it be brief in his discussion with you, I fear that I need to cover a number of things with you, so I'm going to take the time that I believe that the evidence demands to try to give you a roadmap as to what I believe you will hear in terms of evidence in this case. I start with what I understand Sadie Beecham will share with you. Sadie Beecham, I think, will tell you that on May 17th, 2020, she felt her life was finally about to change. She had with the defendant last in 2012. So this was 8 years later since she had last lived with him on a regular basis. They had 3 children together. She will tell you that he basically came and went as he pleased. He had a different household. He did not pay on any kind of regular basis. Sometimes he showed up on weekends, and yet he expected and anticipated that they were in a relationship and that simply was going to be enough. In December of 2018, she didn't want to live that way anymore. And so for a variety of reasons, they broke up. And so that relationship, that separate houses, you come when you want, when you mess up, you just beg me for forgiveness or do a gesture that tries to get the same situation where you're always in control, was going to be over. And so for a few weeks, they didn't have any contact. And then slowly but surely, the defendant wanted to have visits with his kids, which of course was fine with her. And he was able to get back in touch with her on a regular basis, trying to get back together with her, again, trying the cycle of trying to get forgiveness and everything will change. But this time she wasn't going there. It doesn't mean she wasn't nice to him. Doesn't mean there weren't times where she tried out of kindness to explain why this relationship was not happening. Doesn't mean she didn't have feelings for him in some way, shape, or form based on their history, but she was ready to move on. And by February 17th of 2020, she was on a dating site, and she met somebody where she thought maybe this will go somewhere. The person she was in contact with was Rosalio Gutierrez. Now, he was from Kenosha, so there was that was a drive to sort of see what she was going to be able to make of this. But he seemed to love his kids and to have a relationship with his kids, and she liked that it might go somewhere. Now, this is the early weeks of this maybe relationship, right? It's not exclusive. And so she doesn't feel like she wants to share that yet with her 11-year-old who turns 12. And she certainly doesn't want to share it with the defendant, who is her ex. She knows him, and is right in the sense that what I'm going to talk about next in the evidence, I'm going to ask you to look for a certain pattern. I'm going to ask you to consider whether the defendant, as I outline the next grouping of incidents, is an individual who shows by each of these incidents that he is overwhelmed with jealousy. You'll hear a number of communications where that is clear even from his own mouth, and that he has an overwhelming need in that jealousy to be in absolute control when it comes to safety. Each of these incidences can be characterized as a gesture where he demands control, and as he loses control, we'll talk about what the evidence shows comes next. More and more irrational each time, more and more disturbing. And then I'm going to ask you to take a look at whether the defendant in each of these incidences shows you his determination to have absolute control by using every tool available. Using human spies, a person named Steve Lentz, he texts as a lookout for him. Age 11 and 12 will tell you I was recruited by him as essentially a spy. And that he's willing to use electronics too. Basically, every way you can spy on another individual, the defendant was employing in regards to Sadie Beecham. So let's talk about each of those incidences briefly. April 24th, and this is just a 1-month period where the defendant slowly but surely learns no matter not get control. And so what culminates at the end of that about a month-long period is Rosalio Gutierrez no longer being alive to anybody who cares about him, to anybody who knows him. So I start with April 24th. The defendant has his 3 children with Sadie at his house. So he has his 11-year-old daughter, whose birthday is going to be the next day, and his 2 4-year-old twins.
What do you guys think about this trial so far?
He is the only adult there.
Just the case-wise, like, is it
Sadie
intriguing
does not
to
have
you
the
so
kids
far?
on that day. So what Sadie does is invites her new relationship, Rosalio, to come over to her home. She has no children there. She's a consenting adult whose children are at their father's. She invites Rosalio to her home. In the middle of the night, she's awoken. She's awoken because her doorbell rings. She looks out and she sees a vehicle that looks like a vehicle that the defendant owns squealing away. The next day, Rosalio and her discover that Rosalio's truck has been entered. A letter has been taken from that truck, as well as his car registration, a registration that has his stepfather's name signed on it as the person who signed, I believe, the title, the registration. That's missing from Rosalio's truck. The 11-year-old daughter.
I'm interested. I'm interested because it's Kenosha.
Please talk to her. She is 12.
So obviously, I mean, you and I are from Kenosha.
Says that in the middle of the night,
I'm interested in it. But there's so many mistrial, like
with her father,
walking on eggshells with this case.
To the home of her mother, who she normally lives with, Sadie, that her father peeks in the windows at that location. The daughter says the two twins, age 4, are left at his house unsupervised. She actually says, I didn't feel that was safe. She says her father, the defendant, gets the paperwork out of this person's truck. She says her father, the defendant, takes a listening device and puts it in a vent at her mother's home. She says that he summons her over, and she is encouraged to look inside the window of her mother's home. And at that time, she sees her mother and a person she's never met, she hasn't seen before, who she now believes to be Rosalio, in that, I believe, living room of her house through the window. Her father's instructions are, be sure you don't steam the window up because they might be able to see it. This is the middle of the night for an 11-year-old girl the day before her birthday, when a rational mind might be making sure everybody had a really good night's sleep, anticipating a party or a celebration the next day. This is how the defendant chooses to conduct himself. He admits to law enforcement that he had a premonition that something was going on over there. And not only does he admit he went there, but he admits that he encouraged or helped his daughter look in that window. He denies that he put a listening device in. He denies he left the 4-year-old twins behind. He says he brought them along in the middle of the night. Rang the doorbell.
For those of you that were here during when we did the opening
To
statements,
show in a gesture,
what's kind of your initial
I'm
thought?
still in
I'd like to
control.
see what everyone's initial judgments are. And then as we go through the case, kind of taking polls on
You'll hear that
if that's the
in
same
the
or if it's
defendant's
changed.
phone when law enforcement apprehend
Just based
him,
on the opening statements for those that
in
were here to
his
listen to
phone,
that. What do you
they
guys think?
find a screenshot that has a section of the registration of Rosalio Gutierrez on it. It has the signature section for the person who is Rosalio Gutierrez's stepfather. And in handwriting, which the daughter will tell you is my father's handwriting, it has Rosalio Gutierrez's home Kenosha address written down. Now, the event I've told you about on April 24th occurs at Sadie's home. The defendant, of course, knows Sadie's home, right? He's been there in the context of the children, etc. This is new. This is information about Rosalio Gutierrez's home. You'll hear Sadie Beecham indicate that also during this time period in April, she finds Olivia to have a phone she didn't know that she had. She looks in the phone. She discovers and knows that it's the defendant, one of the multiple phones the defendant utilizes. And you'll hear both Sadie and Olivia describe multiple phones. The defendant has a phone that he uses primarily, but he has a couple of other phones, one in particular used to record. She's looking at one of those phones, and she sees the defendant has ordered 2 tracking devices from Amazon. They are auto tracking devices you attach to a vehicle, and that are voice activated recorders as well. So they have dual purpose for spying missions. Electronics to help you.
Yeah, that's my initial reaction is
So
guilty.
by now, Sadie
based off the
has
opening
heard
statements.
from her daughter that there was this invasion of her privacy on April 24th.
He's definitely
She knows
guilty of
trackers
stalking, in my
have
opinion,
been
for sure.
purchased, by the defendant.
The whole plan with the
Knows
daughter is
through a number of texts how jealous
kind
and
of
irrational he is regarding her
kind of spooky.
beginnings of a new relationship. He is describing Rosalio Gutierrez as Beaner, Booger, using all sorts of abusive names and terminology for him. On May 8th, Sadie again does not have the children with her. and she is going to Rosalio's home. And based on the suspicions of what I've talked about that have occurred in the last couple of weeks, she thinks to herself at some point, you know what? He's probably tracking me. And so she searches her car, and she finds hidden under the car seat of one of the twins a phone that she knows belongs to the defendant, and it's on, meaning it would track her location. On May 8th, she drives to Kenosha. She turns that phone off. There's then a controversy between her and the defendant where he says, well, I just lost that phone. That phone must have toppled out of my pocket when I was working the car seat for one of the twins. Well, we know from looking into the electronics that he was using that phone and using an app he had just loaded on his phone recently, Find My Phone, to track her that very day. And so the things he told her about the circumstances were simply untrue. Instead, we know it was an app that he was using on that phone, connected to that phone, to figure out just where she would go on May 8th. Every time she brings this up, he acts like she's crazy. He acts like all the facts are false. But when you go into the electronics, when you go into his actual phone or computer, when you talk to Olivia, all the things she suspected and thought are actually true. The defendant is again and again fundamentally dishonest with her, acting as if these are all in her head or are accidents. Let's talk about the continuing escalation that this pattern that I've described shows. On May 13th, Sadie again does not have the children. Again, as a consulting adult, she decides to go down to visit Rosalio at his home address in Kenosha. Now, I want you to understand what we've talked about. April 24th, May 8th, and now May 13th. Because we are talking about just weeks, just days before Rosalio Gutierrez at this same location is never again seen by those who love him, is essentially dead to those who love him. So now May 13th, we're 4 days away from that fateful day. On May 13th, Sadie goes down to Rosalio's. She is going down for food and to watch some movies. On the phone of the defendant, when taken into custody, on that phone, we have in the phone recordings of directions that look like GPS type directions, which direct you. They are deleted, but they are recovered. We don't have every one of them, but the pattern of them gets you to Rosalio's address. This is the defendant's phone that is traveling per those directions that were deleted to Rosalio's home on the same date Sadie has gone down there. Now, Sadie is in Rosalio's home. And I want you to picture this, that this is what the evidence will be. Conversations you have as you start your meal and you're sitting down to watch something on TV. Rosalio says something specific to her about, do you want to watch this or something else? Conversations that many of you have had as you begin to start your meal. Suddenly, right after it comes from the lips of Rosalio Gutierrez, she receives a text on her phone. The text is from the defendant. And the text is an exact quote of what Rosalio just said to her. It's an exact quote that he's just texted her. Now, he tells her later, oh, that's an accident. I didn't mean to text you. That was just an accident. But his phone at that moment in time is going off a Kenosha tower, not a tower by his home in Mequon, a Kenosha tower, and it's the tower closest to where Rosalio Gutierrez lives. So not only do the directions get him there, and by the way, have him arriving at the right time, but his phone places him at that location, quoting what is being said inside. I must be in control. Every gesture has the same pattern. I must be in control. By the next day, May 14th, we are now literally 3 days from Rosalio Gutierrez being dead to everyone who knows him. May 14th, the defendant now is looking for a confrontation based on his text messages to Sadie. May 14th, 4:13 p.m. You want me to stop by to meet Junior tonight? 4:41 p.m., a half hour later. Still not off this topic. So you're saying I can stop by and meet someone later. Now, none of Sadie's communications are inviting him over. Let's make peace. Let's talk. Why don't you come on over? Why don't you two meet? This is the defendant attempting to provoke, but revealing his intentions. This is a communication suggesting I am looking for a confrontation. Here's what Olivia says about the period we've talked about so far. She says, every time I and the twins come over, this is the daughter, I apologize. This is the daughter, age 12. Every time we come over, he leaves and goes to follow mom. Every time we kids come over. She says to law enforcement, I am his spy about mom. I did it to please him. Here's a plan that she describes, age 12, to law enforcement that the defendant has cooked up and convinced her to be ready to implement. A spy operation. You ready? The 12-year-old says, on an occasion where I am brought over, I and the kids are brought to my dad's house because it's a visit, and where I know that my mom is going over to Rosalio's home, the plan is I will call my dad and pretend, that my dad will drive us kids back to mom's house, which of course would be unoccupied, right? Because Sadie would have gone to Rosalio's home. So my dad will drive us back to the unoccupied house. It's important I keep a key so that I can get in even though mom's not there. I and the twins will go into the house, and then I will call my dad and tell my dad, even though he's just dropped me off, hey, mom abandoned us and left us alone. This is the 12-year-old telling law enforcement that this is the plan that the defendant devised for her, his spy. And she said, at that point, my dad would report this. He would report that my mom had left us abandoned. That is the lengths that we're willing to go to get control, to end this relationship. They call it the plan. It's discussed multiple times. Now, on May 16th, 2020, one day before Rosalio Gutierrez is never again seen by those who love him, May 16th. Remember, I told you on May 17th how full of hope Sadie was. Well, here's why. On the 16th of May, Sadie gets a communication from Rosalio has a boy, 11, and a girl, 8. They're at his house for the weekend on the 15th and 16th, and she's being invited for the first time to meet his kids. And they go for ice cream. And I think Sadie will tell you that this is a truly meaningful moment in her life. Still today, when those few hours she spent with those kids and Rosalio. She left for the night. She didn't spend the night. It was the last time she ever saw Rosalio Gutierrez. But it meant something to her because it's not an exclusive relationship, but it felt like her hopes that this relationship was going to build and get bigger and get better and maybe be the relationship for her. It felt like this really mattered. Here's how the defendant was handling that same visit. You race down to Kenosha every chance you get to lay down with some Down syndrome Mexican version of your father. That's a text from the defendant to Sadie trying to impose himself in this real moment in her life. He's texting spy Stephen Lenz, who lives just close enough to Sadie that he can see if cars are in her driveway. So he's a good lookout, right? He's a good lookout post. This is the defendant to Stephen Lenz on May 16th, asking if she has a car in her driveway. Remember, she doesn't have the kids. So whether a car's in her driveway or not is frankly none of his business. But his spy is being employed at that moment. So on the 17th of May, that's the day after this big moment where Sadie met his kids. And Sadie has said throughout this case that it feels like the defendant is some way monitoring all her communications. Everything that she's communicating with Rosalio feels like the defendant seems to somehow know it in real time. No one knows how that happened. That's how it is. So at 1:52 p.m., this is literally 8 hours before Rosalio Gutierrez is gone and dead to everyone who knows him. 1:52 p.m., Sadie texts Rosalio. Sadie says to him in the text, "I want to be yours and get more serious with our relationship." Okay, that's how she felt after she met his kids. That's her putting herself out there, right? Not an exclusive relationship, but here it is. So there's some text back and forth. Rosalio calls her at 8:30 p.m. that night. This is an hour and a half before he's never seen again. And she misses that call. His last text to her is at 8:36 p.m., his phone to her phone. She never hears from him again. She tries him on the 18th of May. This is a relationship where they are in communication in some way, shape, or form several times a day during this period of time. On the 18th, absolutely no communication from him. On the 19th in the morning, still absolutely no communication from him. And so finally, she jumps in her car and she drives from the Milwaukee area on that morning. What is going on? Trying to figure out what's happening. And she gets to his home in Kenosha. And she finds that the sliding door is open. You'll see in the pictures, Rosalio Gutierrez has that apartment in an apartment complex that's the bottom floor, and his slider and his screen face right onto the road. So the sliding door is open, the screen is closed, and she looks in, and boy, does she see a lot of blood. And she calls 911. And at the moment she calls 911 and law enforcement gets there, there will be a number of things that law enforcement focus on in their investigation. And I'd ask you to think about these areas of focus as you think about the evidence as it comes in this case. One area of focus is, when was Rosalio Gutierrez last alive to those people who know him? The second area of investigation is, who has the motive and who has any pattern of conduct where they would be a person we should look to as a person who might have finished that pattern, completed that pattern, or acted on their motive and ended Rosalio Gutierrez's life. And then the third, of course, area of investigation was, where is the body of Rosalio Gutierrez? And I'm not going to belabor that in this opening. You'll hear about very substantial efforts in many jurisdictions involving many agencies to look for the body of Rosalio Gutierrez, which is never found. So on May 19th, okay, so this is 2 days after Rosalio has last been heard from, at 11:07 a.m., the Kenosha Police Department is at Rosalio's address. And they find through their investigation before too long that the last person in touch with him appears to be a woman whose last name is Macias, who received a text from him at 9:27 p.m. on the 17th, okay? And then she texted him back because she arrived at a building she thought was his. Turns out she was at the wrong building, but she thought she was at his building, and she calls him and texts him multiple times over the next half hour. Where are you? She'd never been here before. Are you coming out? You know, that kind of stuff. And there's never again an answer. So sometime after 9:27 p.m., the state's going to suggest to you all that blood results, and Rosalio Gutierrez is no more to those who know him. They go through family and friends, and no one has heard from him since that 9:27 p.m. time on May 17th through any other method of communication. And so law enforcement focuses on Sadie Beecham. Remember, she called 911. She's still at the scene. She is distraught. She's shaking. She's overcome. And she's really focused. Members of the jury, you'll hear the officer testify. She's really focused on getting her kids safe. She's afraid that the defendant has done this and that her kids might not be safe because of what she sees. And so she is allowed to prioritize that, and then this investigation, of course, continues. Rosalio's vehicles are still at the residence. His keys are there. There is a large amount of blood all over his residence in several rooms. The outer hallway, including outer hallway in a way, suggests that that door opening into the hallway was open at a time when significant bleeding happened, including sprayed blood, blood that looks like it's impact type of blood. There's blood then right inside the door, as if someone is now in the apartment and they are continuing to have some sort of intervention or attack happen where their blood is spraying. That blood is all over that now closed door on that interior. It is all over the rug area there and on the walls and on the tables. It extends to the dining room table. It extends to the chairs on the dining room table. Some of it hits the laptop. Some of it is in the kitchen counter. Some of it is pooled blood throughout that area where you are first in the entrance. There is a small stick of processed wood, like a baseball bat or some other hard object. It's not a log. It's not a piece of cut timber. That piece of wood ends up having blood on it, which is found to be the blood of Rosalio Gutierrez, and hair on it as well, which is also found to be Rosalio Gutierrez. There is significant blood on the curtains, which are on the entire other end of the apartment from where that entrance to the hallway comes. There is blood on the fan. There's blood on the ceiling in multiple rooms of this apartment. There is pooled and seeped blood into the carpet in the living room on the floor area, and seeped blood, a significant quantity of seeped blood on the couch that is the primary couch in that living room. And in the middle of the area by the couch, there is a missing area where there's blood surrounding it, but then there's a rectangled off area that has no blood whatsoever. It's pristine, which certainly suggests to anybody who looks at it that an area rug, a medium sort of size area rug, was there when significant bleeding happened and is now missing from that apartment. There are little splinters of wood on the couch that are also there, interspersed in the blood and interspersed in hair that is located, strands of hair located on that couch as well. Law enforcement tests several locations at various places. You'll hear where they tested. Each time they tested and they found that it was blood, each of those times the blood came from one individual, and that was Rosalio Gutierrez. You will hear that the blood is sprayed, meaning there was impact in multiple locations and multiple different times based on where the blood is located and how the blood presents or looks when law enforcement is present. Remember, present 2 days, about a day and a half after the event. Again, that area rug is completely missing. You'll hear that you might hear some testimony about something called arterial spray, where there's a finer, misty place there too. So some of what you might hear is blunt force trauma, hard objects hitting a bleeding surface. Some areas that you might hear about are more likely, or at least are possible areas where maybe a knife or some sharp object penetrated someone as opposed to blunt force. Rosalio's own phone records say that he dropped his kids off because he had them that weekend. He dropped them off on the 17th. And then he went home, and he was home by 9:08 p.m. So just within an hour of when he's never seen again. Opened a beer, drank a beer. I think maybe opened a second beer. Was expecting this Miss Macias to arrive. His TV was on, and his phone it goes off at 10:30 p.m. around. And that's found several days later, hidden in his freezer. His phone and his credit cards are behind all the items in his freezer, hidden there. In the cold, the phone goes off. The last time that phone is on in any way, shape, or form is around 10:30 p.m. on the 17th. Rosalio's keys are there. His wallet has ended up on the couch over some areas that already had blood, so it was placed there after the bleeding occurred. As I said, his credit cards were found in the apartment. There's been no evidence that his credit cards or his bank accounts or any other identifying pieces of that type have been used ever in the 1,018 days since. The home, you'll see the pictures, is filled with pictures of his two children, 11 and 8. He didn't miss gymnastic events. He was an enthusiastic baseball coach for his 11-year-old. You will hear electronic media talk about his excitement and planning for his coaching of his 11-year-old that will be starting literally just days, certainly weeks. Baseball season is right around the corner, and watching his son play baseball was one of the true pleasures of his life. 2 days after he is gone, he has in his date book, his planner, that he is going to be at Camp Timberlea with his children. Some of you may know that local summer camp. That's a 2-day. That's an experience that's supposed to occur on May 19th, just 2 days after this. He never arrives. He never accounts for this with his kids. Obviously, he never coaches baseball. In fact, neither of his kids, who talked to him all the time, who saw him every week, who were in contact with him multiple times a week. You'll hear that his 11-year-old son spoke to him during this time period multiple times per day. And there was never another split second of communication, and has not been for 1,018 days. He has missed their birthdays. He and his mother had a very close relationship, very close. And he has missed all of her important occasions in the last 1,018 days. And the kids he was so devoted for. Never, ever before missed these occasions. Never before, ever out of touch his entire life with the people who cared about him. And not a peep from him since. So I'm back to who the police should go to first. The defendant has actively admitted to Sadie that he is jealous, he has admitted to Sadie, and then finally to law enforcement, that he took his 11-year-old, as I mentioned, to the mom's home. He has a recording of that incident in his phone, a brief recording of that in his phone. And so law enforcement certainly focuses on the person who has documented motive and jealousy documented. All of this is interesting because it happens while the defendant, according to a woman, his girlfriend, Christine Remsburg, is literally living or staying 4 or 5 nights a week at his girlfriend's home. So what I'm describing to you are things he is doing only when he has his kids over, if he is actually traveling around, or he is doing it despite the fact he continues to have this relationship with, when she's interviewed in May of 2020, she says this relationship has been going on about a year, and that he spends 4 to 5 nights a week at her house. But the motive for the defendant is to end this relationship and to do anything he must to stay in control. So the defendant has his kids on this weekend of May 16th and 17th, right? This is the fateful weekend. Sadie picks those kids up in the afternoon. So in the late afternoon, she picks those kids up. And the daughter will tell you, 12 years old, the back of my dad's van, his minivan, which he used to transport us on the afternoon of the 17th, so the same day this happens, was normal. There were no bleach stains and no problems with the carpet in the back of his minivan when she last saw it on the afternoon of the 17th. So now the question is, what is the evidence that the defendant prepared for this attack, this murder? Well, one of the things he did was on May 15th, he took out $50,000 in cash from his account. When law enforcement gets there, he still has more than $46,000 in cash. You're going to see pictures of the bank bag, literally all the money still bound together. So he's got that, and the state will suggest to you that's in case anything goes wrong. You can make that quick run to some location to be out of harm's way or out of apprehension with that much money on hand. You'll hear the daughter indicate that when she left on Sunday afternoon, just hours before Rosalio Gutierrez is gone, that she saw rope and duct tape, new rope and new duct tape down in his basement. It was down on top of essentially a wheelie, a desk chair that's down there. When law enforcement gets to this location on the 19th, there is a wheelie chair down there in the basement. The daughter is completely right about that, but no rope, no new rope, and no new duct tape. So the state would suggest to you that is ideal stuff if you think you need to move a person bleeding, dead. You need to seal up a carpet, try to prevent as much bleeding as you possibly can from the body of the person you're removing from his own apartment. During this period of time, there's an extremely heavy rain going on in Kenosha and in the Milwaukee area. Very heavy rain. And so people are not out and about, obviously, in the same way they normally would be. Another way that the defendant prepares is when we go into his multiple phones, we find that the phone he usually uses to contact people, the phone that he usually uses in situations, is not being answered, though it is just before and just after, but not being answered from 7:30 p.m. to 11:19 p.m. Left behind the phone that had smart capabilities that would be tracked, left that behind, and so was not able to answer the calls and the texts that come from multiple people, including his girlfriend, Christine Remsburg, who tries to contact him multiple times because she is expecting him in those evening hours to come over. She's talking about what they're going to have for dinner. She's talking about what movie they're going to watch. And finally, she basically, sometime before 11:19 p.m., says, okay, I'm going to bed. She's expected him. And he never shows up at her house and never gives her an explanation until after he would have time to drive from his home in Mequon to Kenosha, commit this crime, and get back to the Mequon area, grab up the phone that he hasn't been answering, and now texts her and says, oh, sorry, fell asleep. Fell asleep during the exact hours that Rosalio Gutierrez is never seen again. And then has a very long conversation with her, like a 42-minute conversation with her from midnight to 12:49, maybe trying to get back in her good graces. Because she's back with him the next night. She comes to his house for one of the very first times she's ever come to his house. She comes to his house that night, the next night, and then the night after that, which is the night he's apprehended. So then I want to talk about the cover-up, because a lot of times the way you can tell that somebody's responsible for something is their cover-up, right? That's a common way of determining somebody did something really bad. So officers get to the defendant in the evening hours. And so it's been 2 full days since Rosalio Gutierrez is gone, to everyone who knows him. And prior to police getting there, a close couple of buddies of Rosalio Gutierrez, who have heard Rosalio Gutierrez say, hey, I've got this new woman I'm seeing. Her name is Sadie. She's got a crazy ex-boyfriend, and maybe even that he broke in my truck one time, right? So when Rosalio Gutierrez is missing, and the friend group begins to understand this, Michael Campbell is the type of friend who will drive to the person's house where that is suspected in his mind and just go and try to confront the guy. And so he and his buddy go there and they beat the police there because the police are still, doing the police thing. And they bring up, hey, our buddy Rosalio is missing. Do you know anything about this? And the defendant claims he's not his brother, claims he's not ZACHARIAH Anderson. He claims he's his brother. He calls the cops. By then, these guys have already left. They're not trying to fight anybody or anything else. They're simply trying to ask a question. This guy's clearly not going to answer their question. They leave. So he already knows by that moment that Rosalio Gutierrez, this person he's focused on, who he's been to his house, he's texted a direct quote of what he said, he's done all sorts of other stuff regarding him, he's certainly communicated to Sadie many times about him. This guy's missing. When they go on the 19th and they look inside that minivan of the defendants, they find that the back is bleached. There's all sorts of bleach stains on the back carpeting. That the seats are out, just the front seats are in, and the back third of the carpeting in that van has literally been cut out. So you're down to where the electronics is exposed. You're down to the plastic flooring under. The carpeting from the minivan is missing, is cut out. Where on the 17th in the afternoon, his daughter said, yeah, it was in there. Nothing was cut out of there. And there was no bleach. Fresh smell of bleach. Carpet cut out in the last 48 hours. You'll hear that in the early morning hours on the 18th, so let's say defendant arrives back in Mequon. By 4:18 a.m., he's searching for area stores by him and when they first open. So he puts in Menards, he puts in Walmart, he's going through all the basic stores. Which of them opens first is essentially his line of inquiry. And he ends up getting a Walmart, opens at 8. This search happened at 4:18 a.m. Okay, this is now about 6 hours after Rosalio Gutierrez is last known alive. And you will decide what to make of this. The defendant arrives there just after 8, like 8:15, 8:18. It's pouring rain. It's still pouring rain, just as it was the day before. Pouring rain parking lot, not many cars. He parks as far as you can humanly park that minivan from the entrance. And he walks that whole distance in, as opposed to parking in any of the probably hundreds of spots that are closer. He parks as far away as possible. Does he have the body still in the back of that car, wrapped in that rug? He buys, with cash, bleach, rubber gloves, garbage bags, shampoo, Q-tips, pays cash, leaves, and heads over to an area where he is doing home demo and rent. He's doing some demo at a lake house in the Belgium, Wisconsin area. A little more isolated locations, not his house, in case law enforcement was already looking for him, in case the body had been discovered. This is on the 18th in the morning, okay, just hours after Rosalio Gutierrez has never been seen. He's at that location, according to his phone, for 3 hours. And then leaves, goes to many other locations, but near that location, so within that immediate area, is a state park, is Lake Michigan, is a number of other remote locations, and hundreds of dumpsters, right? Over the course of any area in Wisconsin, there are hundreds of dumpsters where you might put the remains of Rosalio Gutierrez. He's got a burn pit at his house that he has smoldering when the cops get there 2 days later. He's been operating the burn pit in the pouring rain. In it are an underwear band from Fruit of the Loom underwear, jean buttons, steel-toed boot components. Did he burn some clothes that he might have been wearing on that day? Officers eventually get into the defendant's laptop. When they get into it, they find a file that's labeled Rosalio Gutierrez Jr. So it's got his name. This is before law enforcement talks to him. I mean, you know, I'm sorry. They don't know this. They haven't been in his computer when they speak to him. But he's typed in the name, Rosalio Gutierrez Jr. In that are picture after picture screenshots of Facebook photos of Rosalio Gutierrez out socializing, but also a number of pictures of him with his kids. And we're going to show those to you to let you think about whether this is obsessive sign of dangerous behavior to have collected these kind of photos in this folder on your laptop. It's got business info, it's got CCAP entries, it's got an electronic map that's pinned to the actual location of Rosalio's home. And then in that same file, under that same label, he's got a picture of one of these trackers. Just a photo of the tracker, you know, like a screenshot, right? Auto tracker, voice activated, that spy equipment that he has ordered and paid for just days before. So the defendant, when law enforcement speaks to him on May 19th, knows Rosalio Gutierrez is missing, knows they want to talk to him about the possible stalking of Rosalio Gutierrez. That's what they tell him they're talking. He knows what he has been doing. He knows the facts that we've described happened. There's no way the defendant does not understand how important a moment this is. Here's his chance, if he's an innocent man, right, to talk about exactly what the details are that will exonerate him. Let's clear this up. Here's what the defendant does. When asked what vehicle he drives, he wants to stick with that he drives the Audi vehicle. In actual fact, Christine Remsburg is driving the defendant's Audi around because her car's on the fritz. So he hasn't driven that car around recently much at all. In the Walmart video, for instance, on the 18th, he's driving the minivan. When he drives the kids back and forth on the 17th, he's driving the minivan. He decides to only share that he's driving the Audi. Why not bring up the minivan? Why not tell him right away, hey, the car I'm using is the minivan. Please go search it. Go do whatever you want. Go take a look at my minivan. Absolutely. Instead, he wants to talk about the Audi. Reluctantly indicates that the minivan is a vehicle. Oh, but you know, anybody could drive it. That's how he decides to behave, knowing how important this moment is. He acts to these officers, tries to give these officers the officers the impression he doesn't even know this Mexican guy's name. I think they call him Junior, something like that, he wants to say. Well, he's written Rosalio Gutierrez Jr. in his computer. He's told his daughter the name of Rosalio Gutierrez. There's a phone message or a phone recording that he records between him and Sadie where he finally admits, okay, I told her the name. And yet with law enforcement on the 19th, he chooses to act as if this is not even a name he knows. He says Olivia gets that from a grandma, when in fact, he admits to Sadie that's not the case. He denies ever being at Rosalio's home to the officers, where we know based on the electronic evidence, both his text and his own phone, that he's there on May 13th. We know that. But he chooses to deny that he has been there. In fact, says, I don't think I've been to Kenosha. Though his phone is going off a Kenosha tower when he is directly quoting Rosalio. Then he's asked a very simple question. Again, this is the 19th. Where were you in the evening 2 days earlier? Okay? Not where were you 5 Wednesdays ago. Where were you in the evening 2 days ago? He says, yeah, I was with my girlfriend, Christine Remsburg, spent the night over there. That's where I was. Later goes off that, later changes that up a little bit, but that's what he wants to go with. When Christine Remsburg, who has been with him the last 2 nights after he didn't show up at her house on the date of this homicide, when she's asked that question, also during this exact same time period, where was he? She also chooses to provide false information about his whereabouts. She says, yeah, he was with me, and that's completely false. She eventually is exposed because her sister says, that's not what happened. And when confronted with that, she says, okay, you're right. He wasn't at my house. So the two of them have exactly the same false information about where he was. So you are going to finally hear 2 other important pieces of evidence from the state's perspective. One is when the crime lab examines the van in question. These are people who are the experts in the state at trying to figure out whether there's worthwhile evidence and then trying to do the appropriate testing of evidence having to do with DNA in the state. And so the experts come and the van is eventually brought to them, and they go through that van and they identify a particular location that is near the back. So in that same 1/3 of the minivan where the carpet has now been cut out, but it's about halfway up and it's on the plastic panel and it's just a little speck. And when the 2 DNA and crime scene analysts, when the DNA and crime scene analysts see that, they both say, we think that's blood. But it's so small that they decide that is just going to be our observation. We're not going to use a chemical on it. We're afraid we might not get DNA if we do that. So they observe, they believe it's blood. It is taken to the crime lab. It is tested. And based on the results, again, the analyst, Lisa Treffinger, will tell you she believes it's blood. She believes that based on process of elimination. It's not semen. It's not skin cells. It's not saliva. It's not a piece of hair. And therefore, based on the content, based on what we can get on the results, it is blood. I believe it to be blood. She will offer that opinion. She'll also tell you that her test tells her that blood is the DNA of Rosalio Gutierrez. Rosalio Gutierrez, there's not going to be any evidence he's ever been in this van, certainly that he's ever bled in this van, that he has anything to do with this van. And his blood, his DNA, is located on that speck amidst the area, not in the same area, but in the van filled with bleach and with the cutout carpet. Cutout carpet is never found, by the way. Clothes that the defendant was wearing on the 17th are never found, by the way. Then finally, you're going to hear evidence of an individual, an inmate named Mequon Washington. Mequon Washington has very serious federal charges that are going on right now, and he's being federal charges. You'll hear him say that several months ago, he came forward to his attorney and told his attorney that I previously roomed with, I shared a cell, I was a bunkmate with, that when that occurred, that we bonded over some common sort of criminal activity. So, we talked, and I'm not going to talk about the details, but that they bonded over some discussions of their life prior to this date. You'll hear that Mequon Washington was able to tell details about the case, such as when the police raided residence, they found a lot of money and a little bit of weed, and that
You'll hear Mequon Washington say the defendant described the house that was raided as a crappy house, but in a nice area. You'll hear Mequon Washington say the defendant told him when talking about murder that murder takes a lot of work, that you have to figure out ways to track people and stalk them, learn their habits, learn what they are up to so that you can find your moment. He suggested trackers from Amazon would be something that would be worthwhile to consider. Mequon Washington says the defendant told him that he wrapped the body up and took it away, that he put the body in trash bags, that he made sure the trash was gone and so it will never be found. Mequon Washington will say, well, how did you lift that guy? You know, how did you lift him, you know, like however you got him out of there? And the defendant told him, I was working out at that point. I was so strong, adrenaline. He said, I was like Superman. The combination of adrenaline and my working out was what allowed him to do it solo. Mequon Washington tried to get him to tell him, well, why? Why'd you do this? And he said he never really had a real answer, but that one thing that struck him that the defendant told him was, my ex was getting serious with this guy, and she was happy. The defendant admitted to Mequon Washington he also had a girlfriend then, though they are no longer together during the period of time that the two of them stayed together, but he provided those details. So you'll hear about the act itself. You'll hear from people who love and care about Rosalio Gutierrez that he is gone. You'll hear about the physical evidence, and you'll hear about the confession made. And when you combine all of those pieces of evidence, then from the state's perspective, you will have enough evidence and will hold the defendant responsible. Thank you.
Thank you, Mr. Gravely. Let's take a break. As I indicated when we broke yesterday, I had some further discussion with the lawyers about some legal issues. And then I was doing some more reading last night and have come to a decision. I've given them the decision, but I'm going to give them the explanation. So that's going to take a little more time than the usual break. I'm hoping we'll get back together in about a half an hour. Please don't talk about the case during the break. And as you know, there are 21, I think, 21 steps to the jury room. If that's something that puts you off or is a problem, just tell the bailiffs and they'll give you directions how to get up without using the steps. Any question? Okay, we'll see you as soon as we're able. Does the defense desire to make opening statement now?
Yes.
Okay, and who's going to be speaking?
Me.
Okay, and I think we will, now, do you want the break first?
We're still on a lunch break, guys, so I'm still watching the stream. So as soon as it
Legal
gets set up,
discussion
you know, when they
after the
come
break,
back.
Or would you, either way? Okay.
Judge, I'd prefer to do my opening
opening statement before.
Before the explanation?
Yeah,
Yeah, we can do that.
thank
Okay.
you.
Okay, well then we'll try to start at
You don't want to go into lunch.
about 25,
Yeah, because I'm.
about 25 after.
Okay, so we have 15
My
minutes.
watch, which is 15 minutes,
15?
1-5.
Thank you.
Once they come back from lunch, we'll stop the excuse me, we'll stop the opening statements and get back on with the actual trial. So I just wanted to play this for any of you that may have missed. All right, guys, welcome to the stream. So we're gonna fast forward through all of the little breaks and all of that. We obviously don't need to watch any of those things. Nothing I can do about the weird glitches that happen. That's how the stream was today. So hopefully Thursday morning when the jury comes back, it'll be better. If they go live tomorrow during lawyer arguing discussion, I'll go live for this. If not, then this trial will resume Thursday morning. So make sure you guys. So we do also have that. So that lawyer argument that did happen yesterday, it did go live at 1. That's also up on the channel. So we do have a playlist for the ZACHARIAH. I think it's Wisconsin versus ZACHARIAH Anderson playlist on the YouTube channel. So if you guys have missed any of this trial, you can go to the playlist and catch up. Remember, at the end of this trial, it's expected to go 2 weeks. So I do want to do another mock jury like we did during the Mark Jensen trial. But we need to start getting some viewers on here. We got to get people. So please share these streams out. Keep the chat active while you're here. Hit that thumbs up, subscribe, all of that fun stuff. Otherwise, we can't keep doing fun things. Like and follow and hit the thumbs up.
You're looking for. The state just talked to you at length about some of the evidence that it believes is going to come in, and that evidence is going to show you that Mr. Anderson committed the crimes as charged. And the state and myself, he explained to you kind of what opening statements are. Not going to do that. You're all capable people of understanding why we're speaking to you right now. But I'm speaking because I see the evidence a little bit differently. And when I'm walking you through the evidence that will come in today, it's not based on speculation. It's not based on some theories that are in my head where there's no evidence to back that up. I'm going to walk you through the actual evidence that will come through during this trial. But let's start with what the state kind of walked you through, that this really all stems because Mr. Anderson is a crazy, jealous, obsessive ex. The evidence during this trial will debunk that theory. And in addition to that issue, motive is not an element of the crime. In order to be threatened by a serious relationship has to exist. The state talked about how things were getting heavy between Mr. Gutierrez and Miss Beecham, that they were meeting each other's kids, that there was talk about that. What the state didn't inform you was that Mr. Gutierrez was actively dating and seeing several other women. He was not in any means exclusive with Miss Beecham. He had in fact told some of his closest friends that he was intending on breaking up with Miss Beecham. Miss Beecham had never met a single one of Mr. Gutierrez's friends. And this concept of that the state talked about how, she had never talked to her child about Mr. Gutierrez, or that information must have come from Mr. Anderson. That's not accurate. And the text messages that will come in will establish that Miss Beecham had discussed Mr. Gutierrez with her daughter. There were text messages that she sent to Mr. Gutierrez that says, Liv wants to meet your kids before she meets you. Well, obviously, she must have had a conversation with her daughter about who Mr. Gutierrez was, but still doesn't change the underlying factor that this was not a serious relationship. Additionally, from February of 2020 through May of 2020, there was consistent communication between Mr. Anderson and Miss Beecham. And that communication wasn't, oh, I want you so bad, come back with me. It was kind of a mutual agreement that their relationship was toxic. They were never getting back together, that she had guys she was seeing, and Mr. Anderson had his own girlfriend. The timeline. The state said that the timeline shows Mr. Anderson must have been involved, but the state's ignoring critical evidence as to that timeline. The state admitted May 17th, 2020, Mr. Anderson had his kids, his 3 children. They were at his home in Mequon, Wisconsin. That later in that afternoon, around 5 to 6, Miss Beecham picks them up. Mr. Anderson then, they don't have any evidence that Mr. Anderson left his home. They claim that this is the time where he traveled down to Kenosha, but you'll hear from law enforcement officers that they got surveillance video from multiple places, not only in the Mequon, Ozaukee County area that Mr. Anderson would have had to pass to get to Mr. Gutierrez's apartment, but they also got surveillance from gas stations, schools, the transit authority, from the buses, from neighbors' ring cameras from the area in Kenosha that Mr. Anderson would have had to have passed if he was driving. And you'll hear from law enforcement that they don't observe Mr. Anderson's vehicle. So the state has absolutely, there will be no evidence during this trial that will be presented to you that shows that on May 17th, 2020, when Sadie Beecham is at Mr. Anderson's home, she sees him there. He then texts someone at 11:19 p.m., and you'll hear from law enforcement officers that his phone pings at his home at 11:19 p.m. Nothing shows he ever left home.
Hey, look at that.
night.
Nans. We got Nans as
People
a monthly
falling
member.
asleep around 7 to 8 p.m. as
We
adults
love it.
who have children
Thank you,
and have been with
Nans.
them all day.
Welcome
That's
to
not
the member
unreasonable.
club. Awesome.
So the next morning, he wakes up. He
We're
goes
still
to
on break, guys.
Walmart.
We're just playing the
You'll
opening
hear
statements
evidence
for everyone,
that
so
Mr.
everyone's
Anderson's
caught
a
up.
contractor. He was going to a home up in Cedar
So
Grove
they're still on
area
break. I'm
that
watching
he
the
was
court feed.
working on. He
I
was
got it
doing
up.
lath removal and other
Just get
serious
everybody
removal
caught up.
jobs. It was basically a complete reconstruction of the property. And so if he went to Walmart and parked far away, you'll hear evidence that he likely had tools in his van. And in addition to that, he then goes to his job site for 3 hours. And the state's saying that after that, they don't know where he goes. No idea. The evidence will establish that after he was at the house in Cedar Grove for 3 hours, he went to Menominee Falls to pick up his taxes. That's a nice fact that the state didn't talk about that will come in. And what's interesting about the fact that Mr. Anderson had gone and picked up his taxes in Menominee Falls right after working at his job site in the morning is that that evidence wasn't readily given to the defense. That you'll hear that this evidence, this receipt that's dated 5/18/2020 from the tax accountant services was a piece of paper that was located in Mr. Anderson's van. And that law enforcement, when they executed the search on Mr. Anderson's property, they took all the papers and put them in a pile and labeled them miscellaneous papers. And they took one picture of all of those papers and put that into discovery, and that picture's blurry. You'll see that picture. It wasn't until the defense asked to see that documentation that we saw this receipt that proved that Mr. Anderson wasn't for hours getting rid of a body, but was going to pick up his taxes in Menominee Falls. And you'll hear from the accountants that he was there. You'll also hear from them that they had video surveillance, that law enforcement, had they gone and talked to these people, would have been able to get that surveillance video to see what Mr. Anderson was wearing, the fact that he didn't have any blood on his clothes. And then after he picks up his taxes, he goes back home and spends the night with his girlfriend, Christine Remsburg.
Can I do that briefly?
Yeah.
Okay, so I intend to ask about the contents of the hour and 29 minute interview that occurred between the defendant and the two detectives. I would like to be able to ask the detective whether there were additional questions that the detective did not have the opportunity to ask during that interview.
And
Let me finish. I'm almost done.
sorry.
And then also, were there any other opportunities to interview the defendant? So I don't intend to go any further than that. But again, we're talking about this avenue of what was the investigation. Certainly an hour and 29-minute video or interview does not, as the court is well aware from its long experience, is not an amount of time to cover all topics that would be necessary. I don't intend to go any further with it, but I believe that is the line, and I'm asking the court if I have permission to go that far and no further.
Go ahead.
Thank you, Judge. Asking why there were other questions that should have been asked that weren't, and then that they weren't able to have the opportunity to question him again is encroaching on the fact that my client asked for a lawyer, and that was why the interrogation concluded. So asking those questions, implying that there's more and that my client chose not to speak, is directly going towards his right to remain silent at that point. So I would argue that the state cannot ask those questions of, oh, would you have asked more questions if you would be able to? Because the inference there is that they weren't able to because he invoked his rights, and that they didn't get to talk to him again because he invoked his right to silence.
And again, I only bring this up because of the issue of the adequacy of the investigation, right? So there are natural limitations. I'm aware I cannot go any further, so counsel indicated, what I can't argue, and I absolutely agree. I can't say here's why or in any way imply that in argument or in question. But I do think it's a proper question right at the line. It's a proper question to ask as I described to the court.
Well, the problem is you're lobbing the ball over into their court and saying, did you have an opportunity to ask more questions?
As you often are when you go to the line. Right? I mean, that's the nature
but we don't
of
want
it.
to do anything brazen.
Right.
You're lobbing the ball onto their side and making them respond. And they're kind of handcuffed. If the answer is he lawyered up. And of course, then you're in the forbidden woods.
Right.
So
really the analysis, though, is am I asking a question that comments on his silence or comments on his invocation, right? So the court is right. It has some consequences, but the question is the question one where I am calling on the officer to indicate in some fashion that he has invoked his right to silence or to an attorney? I would suggest to you, as suggested, the question does not do that. Of course, I can't argue. I apologize.
So, yeah, a very, very tight interpretation. You could make that claim, but the problem, as I say, is you've you're forcing the defense into a position where it has to come up with an answer. And if the answer is that he had talked to a lawyer and whether he talked to a lawyer or not, he simply decided not to discuss anything further with the police, they can't respond. And so it's sitting out there. And if during the remainder of the testimony, a juror is thinking, after hearing the remainder of the testimony, a juror is thinking, all these years since this, and the defendants never told the police anything more, then you're definitely, what is the name of the case? I think it's Champlain Chambers, one of those. Not one of those, well, whatever it is, the rule is very clear that there's no comment permitted by the prosecution on the failure of the defendant to address the case.
That's a bright line rule, and I'm aware of that.
Okay.
Now, what has happened is the defense has lobbed into the states. Let's be sure we talk about this fully in the venting of what you described. There's been an opening statement. It is certainly said detectives made a number of poor choices here, right? I mean, that is the clear thing, right? So a reasonable juror hearing the 25, perhaps 30 questions that officers did ask would very reasonably, based on the argument made and the ball being lobbed into our court, say, well, why the heck didn't the officers ever address with the defendant why this van is cut out, a third cut out, or any other thing that the state suggests is of significance here? Why wasn't that ever brought up to the defendant? That sounds like it's the same pattern of they didn't test fingerprints at X, Y, and Z. They didn't search this part of the woods. And we're left with no way to respond, because in fact, those questions would have been asked, or certainly could have been asked, had there been a different posture. Now, again, I am absolutely conscious. I am not allowed to bring up an invocation of either silence or the right to an attorney. But I think that the simple declaration by the detectives that they would have asked, that they would have liked to ask additional questions, and that they never had an opportunity, settles that. It creates the prosecution is not going to be penalized based on the argument made by the defense for any question that the juror wishes a detective would have asked the defendant. I mean, otherwise I'm left without an explanation, right? Because the explanation is a legal and constitutional one. So I'm tied. If the court says I can't even reach that line, I have no way to respond to a juror concerned that in the context of what's been said, what the heck, why wouldn't a detective ask that question? He asked 25 others.
First, about the ball being put back in their court. The ball's in their court. They have the burden. It's never that we've shifted that burden here. And second, as far as the answer to a question of why weren't you able to answer these questions that you would have, the only answer that a detective or any witness can give is that we weren't able to continue questioning because he invoked his Miranda rights. So there's no leeway here. It's not the defense's fault if the state doesn't have any other evidence to support its claims. It's their job. The case that deals with this issue is Griffin versus California, 380 U.S. 609. And in that case, and I'm just going to read, says that a comment to the jury by a prosecutor in a state criminal trial upon a defendant's failure to testify as to the matters which he can reasonably be expected to deny or explain because of facts within his knowledge or by the court that the defendant's silence under those circumstances evidences guilt violates the self-incrimination clause of the Fifth Amendment of the federal Constitution as made applicable to the states by the 14th. There is, and also this concept that I'm going to ask an officer, well, why didn't you ask my client that? Well, obviously, I'm not going to violate my own client's constitutional rights. I would not ask a question of that sort. The questions that the state have outlined are clearly across the line of what's permissible under a constitutional lens and pursuant to Griffin versus California and my client's Fifth Amendment rights.
The case does not stand for the proposition that I can't reach this place that I am. I've been very careful in the litigation here. I've approached the court first. I'm doing the exact opposite of commenting on the defendant's silence. I'm asking the court for guidance on how I can structure a question to a detective that allows there to be no comment on silence, but also allows a fair presentation of this evidence to a jury in the way I've described. Again, the only other option we're left with is a jury wishing there were answers to other questions, knowing a series of questions have been asked, and left with the implication that officers are not competent enough or not or too lazy to ask these additional questions. Now, again, I don't mean to comment on either of the two things. I simply ask the very structured questions. I believe I'm doing it in the appropriate way. It's the exact opposite of the case cited where a prosecutor actually comments on this. I am trying to be careful in my litigation here and ask the court for guidance to be able to ask those two questions. Did you ever get a chance after the interview and so forth? Did you ever question the defendant again? And then the second one is, were there other questions that you would have?
Your new home needs more than just paint. It needs the power of CertaPro painters.
To the extent that you ask me for guidance as to what you can do, that I can't do. I can't give you advice.
Well, I've told you
Present
this.
your case, and I've made it pretty clear what you can't do.
I've told you the two specific questions I intend to ask. So I think the court can probably help me with that.
Well, but definitely the second one is totally out. What was the first one?
The second one is, did you have any other opportunities to speak to the defendant?
No, that's
Okay.
That's
So the
gonna
first one was, are there other questions that you desired to ask of the defendant that you did not ask?
The fact that you're complaining that you're left without a way to somehow effectively cover this, that sometimes that happens. And sometimes it happens because of the Constitution. But it's what it is. And I don't know if can you cover something like that in your argument to the jury and say,
I imagine that is more problematic.
I didn't tell you what I was going to do to raise your hair. For those events. And I think I'm actually going to stop and not do it, but there's at least one way I can think of that I would at least be tempted to do. And I'll leave it at that. I don't think you're without a way to buttress the police investigation. But the way that you're explaining it to me is not one that I think is one that I would sanction or even permit.
Okay.
No.
Okay, thank you.
Okay.
Do we have any prior record that we have to work out? It doesn't have to be.
Ready to go? Okay. Were there late jurors or?
No.
Everybody was here on time.
Hello.
Would you come down, please?
Yep.
We're kind of seeing
Johnny,
that Kenosha DAs like to push the line when it comes to commenting on people's Fifth Amendment rights. They did it in the Rittenhouse trial too.
Well, another state is.
Binger or Schrader snapped on Binger for that. he snapped at him. And then here we have the head district attorney, Michael Gravely, trying to do it again. Kenosha is famous for stuff like this. It's crazy, chat. Crazy.
Enjoy the day. No, I haven't checked the weather forecast. Are they still talking all kinds of ominous weather this afternoon? Oh, it's tomorrow. Okay.
For Kenosha, they were wavering somewhere between 1 and 5.
I thought there was a chance it was all going to be rain here.
They started approaching, and then they said it's worse south of us, but with the slightest change in wind. Meteorologists are my favorite.
Well, you're being too harsh there. They've correctly predicted 45 of the last 3 snowstorms.
Judge, currently the Weather Channel is saying snowfall around 1 inch for whatever that's worth.
Hey, this is Wisconsin. I won't even notice. All right, Mr. Gravely.
Thank you, Your Honor. Detective, when last we were here, I was about to again begin to ask you about the interview that occurred on May 19th, 2020, regarding the Zachariah Anderson. And again, you've identified Zachariah Anderson as the individual here in this courtroom. Is that correct?
Correct.
And you spoke to him for about an hour and 29 minutes in total.
Yes.
And that was a question and answer format.
Yes.
And did it include the defendant also asking some questions during some of that period?
Yes, he had some.
And did you provide him any nourishment, any food or water?
We gave him water, which he requested a couple of times.
And ultimately, that interview then concluded, if I got this correct, at 12:18 a.m. Does that sound right?
Yes.
Okay. So in the time period of that interview, did you provide any threats or promises to the defendant to get him to provide any information?
No.
Did he provide that information? Did he answer some of the questions you asked at least?
Yes.
All right. And did you at some point have occasion to talk about a phone that purportedly appeared to have ended up in a car driven by his ex-girlfriend, Sadie Beecham?
Yes, I did.
And was this something that you asked him about?
Yes.
And what do you recall him telling you about whether he had intentionally placed that phone or some other explanation?
So Zach had said, Mr. Anderson said that Ms. Beecham had dropped the kids off at his residence. And during the course of taking his son out of the back seat, he believed that this cell phone may have fallen out of his pocket, or his son may have grabbed the phone and put it in the car.
What, if anything, did he say about whether he on purpose hid that phone under the car seat?
No, he said he didn't realize this until after Sadie had left and he realized the phone was gone.
What, if anything, did the defendant say about how he managed to figure out where that phone was then located after it was in Sadie Beecham's car in that location?
Mr. Anderson said he contacted the phone provider, Cricket, and Cricket told him that the phone pinged in North Kenosha.
What, if anything, did the defendant tell you about having loaded an app on his electronics that would, in fact, trace the exact location of that phone prior to losing the phone? What, if anything, did he tell you about that?
He said nothing about it.
What, if anything, did he offer to you regarding indicating that on the date that Sadie discovered that phone, that he actually had accessed that app to be able to discover where the phone was using the app in his own electronics. Did he mention any of that to you?
He said nothing to that.
Did you ask what, if anything, did you ask the defendant about having been to Sadie's home during the early morning hours over the last few weeks? Did you ask him that question?
Yes, I asked him if he had been to Ms. Beecham's house at any point during the early morning hours.
Let me
It was
let me just stop you for a second. And did they live together at that time?
no.
And per your investigation, was he welcome at that house in the early morning hours?
No.
Okay. So when you asked him that question, it was a specific question about in that context. Is that true?
True.
And what did he first offer up to you as his explanation for for a visit to her home in the early morning hours? What was his first explanation?
He said there was a time when he had picked up a couch late one night and he was dropping the couch off there late.
Go ahead. And did you then repeat the question, ask him again, and ask if he had his kids along on any occasion? Did you ask him that?
Yes, I asked him if there was another time when he had his children that he went there.
And then did he offer that he had?
Yes.
Could he remember the date? As best you remember?
No.
And which children did he claim he had taken along with him?
All three of his children.
Okay, so he has a couple of twins who are younger, and then a daughter who's 10, 11, 12, something like that.
Correct. He said he had taken his daughter as well as the two twin boys.
Was it at night?
Yes.
Did he indicate why he felt a need to take his children? He had the children with him. Is that what you're saying?
Yes.
So why did he indicate he felt he had a need to take his children when Sadie Beecham would have not been caring for the children?
So he first he said there was a car in the driveway, and then he stated he had a premonition that there was someone at her house.
And at that point, were these two in a marriage, as far as you know?
No.
Were they in a situation where any of the children would be at Sadie's home?
No.
Okay, so he and the children drive to her home per his report. Is that right?
Correct.
And at what does he indicate happens when he is at that residence?
So he said when he pulls in the driveway, there's a vehicle there with Colorado license plates.
And let me stop you. Does Rosalio Gutierrez have Colorado license plates on his vehicle that you saw at his residence when you discovered he was gone?
Yes, he's a white Ford Explorer with Colorado license plates.
Okay, so what else did he say?
He said he got out of the vehicle and looked through a window.
Look through a window through a window at the vehicle?
Looked through a window at the house.
Okay, and whose home is he speaking of?
Sadie Beecham.
Did he say he saw some things inside?
Yes, he said he saw them on the couch.
Okay. And did he indicate whether any of the children were also involved in looking in the windows?
Yes, he said his daughter came out of the car and looked through the window.
And did he indicate that he had that was something he was a part of in some fashion?
He had told me his daughter did this because she wanted to.
And did you at some point ask the defendant whether he recorded any using any devices of his at Sadie's residence when he and his daughter were there looking in windows?
Yes, he denied recording anything, although he did admit to having a cell phone in his possession at the time that he used the light on because it was dark.
And was it his regular cell phone?
I'm going to object as far as foundation.
Did he? I'll ask again. I'll clarify. Yeah. Did the defendant explain to you that he had more than one phone that he was using on a fairly regular basis?
Yes.
Okay. And did he describe one as his primary phone and another as his secondary phone?
I guess, Judge, I've been lenient, but all these questions have been extremely leading. So I'm going to object to leading and ask, and that it not be leading.
And I apologize. I was just doing it in this situation. I was just doing it because it was a foundational question. So, but
It's just been like 5 minutes of foundational questions then.
They are tending towards being suggestive, so if you can rephrase.
what do you recall about whatever he told you about these phones?
He had 2 phones, one he used primarily for calling.
And what, if anything, did he say about doing any recording using any devices on this particular date?
He did nothing. No recordings.
At some point, did you begin to ask questions regarding a new boyfriend of Sadie's?
I did.
And what, if anything, was the defendant's discussion with you when you first brought up this individual in terms of things like whether he knew his name, a general discussion of what he appeared to know about this new boyfriend?
He said he found out about the new boyfriend through his daughter, as well as a grandmother. Grandmother had shown daughter a Facebook profile of this subject, and that's how he found out who he was. I asked him what his name was, and Mr. Anderson said I believed it was Junior, and that his last name started with a G, and that he was a Mexican.
And what, if anything, did the defendant ever tell you about the fact that in his own phone he had, well, let me stop. Okay, so did the defendant ever reveal to you that he actually did know the full name of the individual that Sadie was dating? Did he ever tell you, yeah, I know the guy's name?
No.
Now, at some point, did you begin to focus on the vehicle that the defendant may have driven at various times that you were interested in?
Yes.
And what vehicle specifically were you interested in regards to your interview with him?
I asked him about the Chrysler minivan that was parked in his driveway.
And what do you recall about the defendant's response when you first suggested anything to the effect that he was a driver of the van?
He described the minivan as either being black or blue or something, and that was his words. He also indicated that he doesn't drive it much, and that it's basically there for the taking.
Did he describe to you that he drove a different vehicle, if you know?
Yeah, the Audi. He mentioned the Audi.
Okay. And what, if anything, did he say about whether he had ever been in Kenosha at a time that Sadie had been there?
He said he couldn't remember the last time he was in Kenosha.
Period?
Period.
Okay.
He did mention that he plays board games with his brother, and they may have been in Kenosha. But he didn't recall ever being in the city of Kenosha.
And in connection with being there because Sadie was there, what, if anything, did he tell you about that?
I'm sorry, repeat that?
Yeah. Did he indicate that he ever followed Sadie down here to Kenosha?
No.
At some point, did you direct your questioning to whether anything had ever been taken from Rosalio Gutierrez's vehicle, that truck?
Yes.
And what, if anything, did the defendant tell you about whether he had taken any items from the vehicle of Rosalio Gutierrez.
He told me to spare the accusations. He's already been accused of this and that it didn't happen.
And what, if anything, did the defendant offer to you that in one of his phones, there is a screenshot of, in fact, a document, a registration document regarding that truck?
Nothing.
What, if anything, did the defendant say to you regarding whether he had any jealousy towards the fact that Sadie had a new relationship?
He had admitted to me that he did have some jealousy, however, spun that and said that Sadie was the one that was jealous of him.
And did you, what, if anything, did you ask whether these two individuals, meaning the defendant and Rosalio, whether he had ever seen Rosalio?
I did. I asked him how many times he had seen the subject he was referring to, and he had told me it was just the one time when he peered into that window.
So what, if anything, did the defendant offer you about about his phone being in Kenosha on May 13th, which would be a different time than the time that you are speaking of? What, if anything, did he offer about that?
Nothing.
What, if anything, did he offer to you regarding the idea that he was texting Sadie, directly quoting things that Rosalio was telling Sadie in Rosalio's residence on May 13th in Kenosha?
He said nothing.
So as to May 13th in Kenosha, what, if anything, did the defendant say at all about that in the context of perhaps being a second time he had seen Mr. Gutierrez?
It was never mentioned.
At some point, did you bring up an individual named Steve Lentz, or did the defendant bring up a person named Stephen Lentz to you?
Yes.
And just so we understand, who is Stephen Lentz in this investigation, if you can tell us?
Stephen Lentz was identified as a friend of Mr. Anderson, a neighbor. At one point, Mr. Lentz actually lived in his backyard in a tent at one point. Mr. Lentz's mother lives right down the street from Miss Beecham, about 400 feet down the road on the opposite side of the street.
From where Mr. Lentz, and was Mr. Lentz residing there in April and May of 2020?
Yes, he was.
And from Mr. Lentz's then residence, could you see any portion of the house or a place where Sadie Beecham was living?
Yes, you could see the driveway of Miss Beecham's residence.
And were you able at some point to obtain a phone number from Stephen Lentz?
I did.
And just for purposes of us clarifying, was that phone number based on the records that you reviewed, et cetera, 414-378-4935?
Yes, I believe so.
Okay. So let's go back to the interview with the defendant. At some point, Stephen Lentz came up. What do you recall about how he came up?
We went back to the idea that he had a premonition someone was at the house. Ultimately, Mr. Anderson told me that there was a guy named Stephen Lentz that would call him and tell him when vehicles are in the driveway. But he also stated that he had never told Mr. Lentz to provide this information.
And what, if anything, did the defendant ever tell you about communicating with Stephen Lentz, asking him on occasion if there were cars in Sadie's driveway?
Nothing.
Now, when you spoke to the defendant, what were you telling him that you were questioning him regarding?
I told him we were investigating the stalking incident.
Did you tell him who the people were who you were suggesting he might have been stalking?
Yes.
Okay. He had been arrested, were you having this discussion with him? So if I understand correctly, there was a contact with law enforcement and he got arrested in Mequon?
Correct.
And then about how long after that arrest in Mequon do you estimate it was before you're having a conversation with him about stalking Sadie and this other individual?
I don't know the exact amount of time, but probably 3 or 4 hours later.
Okay. And at some point, did you focus on attempting to figure out where the defendant had been on the day of May 17th, 2020?
Yes.
Okay. And if you can briefly say, why was that your focus as opposed to the 16th of May or the 23rd? You know, what was the reason why you were focused on the 17th of May in your questioning of the defendant at that moment?
From what we knew at the time, that was the last communication with Rosalio was on the 17th, and we believed that that was the day that the incident occurred from what we knew at that point.
And did you believe that also to be in the evening hours?
Yes.
Okay. So you had a general amount of time that you were focused on because that's where your investigation was at that moment.
Correct.
So do you remember focusing on that with the defendant where you asked him, so please tell me about what was happening on the 17th of May?
Yes.
Okay. And again, you're on the 19th of May now?
2 days later, yes.
So you're asking him on a Tuesday what happened on that Sunday during the day. Is that correct?
Yes, day and night.
Okay.
Yep.
And so what do you recall about what he offered to you first in terms of his activities on Sunday?
So he said he was with the children during the day, and Sadie came to pick them up.
Did he tell you in general when that occurred? In general?
I don't recall.
Okay.
I wanted him to keep going with the rest of the remainder of the evening. And he said he thinks he went to a girlfriend's house named Christine.
Okay. Did he eventually offer the last name of that girlfriend as well?
Yeah, Christine Remsburg.
Okay. And did he indicate that when he went there that he believed he had spent the night? Was that his initial discussion with you?
He was very wishy-washy on what he did that night. He said he may have been there. He may have stayed the night. Wasn't really sure. Yeah.
And did that wishy-washiness come when you pressed him and said, dude, you don't remember what happened 2 days ago? Is that when that happened?
Yeah, I was unable to get anything concrete as far as what he did that night. And he was just throwing out things. First he said he stayed with her. Then he said he may have called her. He doesn't remember. He just never gave me an answer.
What, if anything, did the defendant say about ever having an in-person interaction with this person, Rosalio Gutierrez? Did he offer what, if anything, did he offer in regards to that?
Nothing. He said he only saw him that one time, which was through the window.
What, if anything, do you recall about the defendant offering up something about Sadie and her having a nice jacket and what that meant? Do you remember what that was about, if anything?
Said Sadie dropped the kids off at one night, and she was bubbly. Called him ZACHARIAH, and said that she had a nice jacket in the back of the car, and suspected that she was going down to Kenosha to visit Junior because she had that nice jacket in her possession.
Just one more second, Your Honor.
Woke up this morning. 42 regular, wasn't it?
Yeah.
No further questions of this witness. Thank you.
Yes, thank you, Judge. Detective, I'm just going to start off with some follow-up on this interview that you had with Mr. Anderson, since that was just the last thing you talked about.
Sure.
You had testified just now that you had asked him about taking the registration from his truck, correct?
Yes.
And his exact response was, I don't have his registration card for his truck.
No, he said, spare me the accusations. That was the first thing he said. And then I didn't take it.
If I was to show you a transcript of that interview, would that help refresh your recollection?
Sure.
If I may approach the witness, Judge,
So do you have a copy for me?
I can show it to you.
Copy of it. Use the transcript and use it as a source.
I can show you what I'm going to show him to refresh his recollection. I'm not introducing it as an exhibit.
How do I know it's not enough?
You have the record. There were multiple points where you had asked him about the registration card for the truck, correct?
That's possible.
And he was adamant that he didn't have a registration card for the truck, correct?
He said he didn't take it.
And in your investigation, was there a state-issued registration card that was ever located in any photo at all for Mr. Gutierrez's truck?
I don't recall.
You had talked about earlier you had reviewed photos from Mr. Anderson's cell phone, correct?
Some. There was 4 cell phones.
So do you ever remember seeing a state of Wisconsin registration card issued to Mr. Gutierrez that was in any of those photos?
I don't recall there ever being a state of Wisconsin registration card involved in this.
Okay. So Mr. Anderson, when he told you that he did not have the registration card for Mr. Gutierrez's truck, you did not have any evidence to support that Mr. Anderson did in fact ever possess the registration card for Mr. Gutierrez's truck.
So I'm going to object as to irrelevant whether there's a Wisconsin registration. This is a Colorado vehicle. So the absence of a Wisconsin registration is irrelevant.
Well, it had Colorado plates. Is it a Colorado registered?
I'm not aware it's registered in Wisconsin or that
Well,
that's what
no,
we're
no,
talking
no,
about.
that's not what your objection is.
I'll rephrase the question to call a Colorado registration, if that would, any state issued registration card
What's your question?
that you never found any information that Mr. Anderson was in possession of a state issued registration card for Mr. Gutierrez's truck.
I don't know. I don't know.
And let me ask you a question. You're a detective, obviously, right?
Yes.
You've been working, you said 20 years in the force?
Yes.
When you refer to a registration card, normally in your day-to-day business life as an officer, you're referring to a state-issued registration card, correct? As it relates to vehicles.
I guess.
Were you-
What am I referring to?
Sure, I guess an example is, did you ever work patrol?
Yes,
When you pull someone over, right?
yes.
You'd say, hey, can I have your registration?
Okay.
Or when you ask for the registration, are you asking for a state issued registration card or something else?
Yes, state issued registration.
Okay, thank you. You also were asked about what information Mr. Anderson had given you about Junior or Mr. Gutierrez, and you said it was very limited, but isn't it true that Mr. Anderson admitted that he had looked up Mr. Gutierrez's information on CCAP?
Yes, he did tell me that.
And you were also asked a question about Mr. Anderson's statements about him being jealous and whether the state had asked you whether Mr. Anderson had expressed any concern about him about Miss Beecham dating Mr. Gutierrez. Do you remember that line of questioning?
Can you say that again, please?
Sure. Do you remember the state asking you about what information Mr. Anderson relayed to you as it relates to his feelings about Miss Sadie Beecham dating Rosalio Gutierrez?
Yes, he stated there was some jealousy.
He also stated, I'm seeing somebody else. She's got the right to see somebody else, correct?
He said that, yes.
You were also asked at length about what Mr. Anderson said he had done on May 17th, 2020. And isn't it true that Mr. Anderson in fact told you, I don't know, took a nap, probably. I think I went over to my girlfriend's house. I'm not really sure.
Yes, that's what he said.
And then later he did say in response to other questions about what he'd been doing the last 2 days, he had informed you that he was tired and really didn't want to blur things together to give you wrong information, correct?
I don't recall him saying that. I know he did say he just didn't remember because his memory is bad.
And what time did this interview happen at?
11:30-ish till just after midnight, 11 o'clock to midnight.
So you agree that it's likely that someone could be tired after all day and then being interviewed at around midnight?
Sure. Could be tired. Oh, yeah, sure.
You also, in talking about Mr. Anderson's interview, talked about Stephen Lenz. Remember that?
Yes,
And that's Lenz.
correct.
May I use the Elmo judge?
Yes.
Thank you. And you said that, well, the state asked you that Mr. Lenz would be used as kind of a eyes for Mr. Anderson.
The state said that?
Well, yes. Do you remember being asked that questioning?
I remember the questioning about Mr. Lenz, yes.
And you said that there was communication between them that showed that Mr. Anderson was asking him to look in on Sadie's house, right?
Are you saying that I asked that?
No, I didn't say that.
Okay, because that long string of communication in your investigation doesn't exist, correct?
I didn't say that.
Okay. Did you see the communication between Mr. Anderson and Mr. Lenz?
No.
Okay. So you don't know what they actually talked about then?
I know there was text messages. I don't know exactly what those text messages said. I didn't deal with that part of things.
Okay. Do you remember who did?
I don't know.
I want to go back now to follow up on some things that you first started testifying about. Primarily, when you first got to the crime scene, you had noted that it's important to make sure that you're very careful with how you enter into a crime scene, correct?
That's correct.
And why is that?
We don't want to damage evidence. We want to preserve it as best we can.
And in your experience, you'd agree that when you are processing a crime scene or entering a crime scene, it's important to be extremely thorough.
Of course, yes.
Now, you talked about how Officer Van Wee, some other officers came in, and that they were very experienced in evidence processing as evidence techs, correct?
Yes, they are experienced.
You said they were specialists with Kenosha Police Department, right?
They have the title of evidence technicians.
Now, do you have any specialists that deal with missing persons cases?
Nobody with the title.
So you had noted during your direct examination that you were an investigator in this case, correct?
Detective, yes.
And role of a detective in a case with a missing person is to try to figure out what happened to them
Yes,
and where they might be
yes,
and who may have been involved in the disappearance.
yes.
So besides Mr. Anderson, who did you investigate as being involved in the disappearance?
Personally, I didn't investigate into anybody else. We did look. We looked for other leads, other clues, other evidence. But personally, I didn't take the initiative to go look specifically at somebody else.
I want to pull up an exhibit. And Judge, I apologize. I'm not going to use the Elmo at this point. The state's kind enough to pull up one of the exhibits since it's already connected. And I'm pulling up what's been previously marked as State's Exhibit 1, Photo 150.
Is the TV on though? We're working on it. Oh, okay. Counselor, you said 150.
150, yeah, thank you.
Looks like it's just getting.
I just want to make sure.
Thanks, Jessica. Oh, God, yeah. Thank you. So you had previously testified about this photo, and you had talked about how there's a standby screen on the TV, correct?
Yes,
And it was determined that that was a standby screen for Hulu, correct?
I believe so. Yes,
Did you subpoena Hulu to get the usage records?
I didn't. No,
Could that have been something that you could have subpoenaed for?
I don't know. I have never subpoenaed Hulu.
Okay,
Possibly.
all right. And then did you check the make and model of this type of TV?
No,
So you'd agree that there are certain TVs that have standby modes and sleep modes, correct?
I don't know.
If you left, do you have a TV at home, Officer Detective?
I do.
Your TV, if you turn it on, does it stay on or would it turn off after a certain point of time?
I don't know.
Okay, is it possible that you didn't check to see if this TV had a sleep timer or anything where it would have turned off after a certain amount of time?
I did not check personally, no.
And you agree that that could have been useful information in determining a firm timeline?
Potentially.
And then you had also talked about how there appeared to be some items that could have been knocked off, but you weren't sure. Remember that testimony?
Yes,
And you're not sure because prior to May 19th, 2020, you had never been into that residence, correct?
correct.
So the items on the floor, it's possible they had already been on the floor because you didn't know how this apartment looked previously.
That's correct.
Thank you, State. I no longer need that exhibit up. Thank you. You also talked about when you looked in and you saw some pooling of blood that you noticed a void, right?
Yes,
And I think you said that that void was where a rug would have been at some point.
that's what it appeared like to me. It looked like a rug had been there at one point.
Did you determine the size of that rug?
I personally didn't.
Do you have any information of whether any officers in the investigation did?
Not that I know of.
But you were familiar enough with the layout of and the size of the apartment, right?
Correct.
It was a relatively small apartment.
I would say that, yes. One bedroom.
Okay. It wasn't, in your opinion, it couldn't have been like an 8x12 rug.
No, it wasn't that big.
It was more like a 5'7" area.
From what I recall, that seems to be about accurate.
Okay.
Maybe a little smaller.
A little smaller than 5'7".
Yeah.
Okay. And you said that you looked in the bathroom. There was nothing of concern there.
Not that I saw.
You went to the bedroom. You said that there was nothing of concern there.
Not that I saw.
Judge, I would like the Elmo now. I appreciate it. Thank you. Okay. Pulling up what's been previously marked as Defendant's Exhibit 60. From you being there, what room is this?
Appears to be the bedroom.
Okay.
Like the northwest corner of the bedroom.
And the window, do you see the window in the picture?
Can you change the lighting maybe? It's hard to. Maybe we could
that
turn
better?
the light off, Judge, so that.
As you wish.
Okay. You need the light off, or are you good?
I'm good.
Okay.
Can you see it?
Yeah, that's fine. Yeah.
Yeah, we're good. There's a window in the picture, obviously, right?
Yes.
That window, is it open or closed?
It looks like it's cracked
The
open.
blinds or the window?
The window itself.
Looks like it's one of the panes is cracked open.
Okay. And did you look into that at all? The fact that there was an open window in the apartment?
I didn't look. I guess, what do you mean look into it?
So that window, I'll go back a little bit. That window is accessible from immediately right outside that apartment building, correct?
Yes, it looks outside to the north.
So an individual, if they wanted to gain access into Mr. Gutierrez's home, that could be a point of entry into that apartment, correct?
Correct.
We just saw that the window was open, correct?
So I don't know how many panes of glass are on that window or nothing like that. But it does appear as though the window is slightly opened.
Okay.
Yeah.
And that could have been a point of entry.
Could have been.
So you'd agree that that is something relevant in the bedroom?
Okay.
Is
Yes.
it?
Sure. Yes.
And it's important when you don't really know what happened to an investigating to determine every possible outcome or situation of how an individual might have gotten into Mr. Gutierrez's apartment, correct?
Correct.
And you'd agree that that's one of them.
Correct.
You talked a little bit about your contact with an individual named Michael Campbell.
Yes.
Do you remember what he looked like?
I don't.
Okay. So you can't remember if he had any facial hair, what his hair looked like?
I believe he had a slight beard. But like I said, it was 2 years ago. I haven't talked to him since. I don't remember.
Okay. And the state had gone into what he was telling you, but he didn't tell you that he was at Mr. Gutierrez's apartment on May 17th, 2020, correct?
I didn't hear that. Yeah, I didn't hear him say that.
And when you were with Miss Beecham, questioning and talking to her, at any point did you observe her on her cell phone?
I may have. It's possible she used her cell phone.
Was she talking to anyone?
I don't recall.
Okay. Moving to your observations on Mr. Anderson's property, and you said you looked into the van, correct?
Correct.
I'm going to ask you some follow-up questions on that a little bit later.
Okay.
You looked in the dumpster. There was nothing of evidentiary value found there, correct?
Correct.
And you had noted something interesting, that you located lath in the dumpster.
Yes,
And in your investigation, you were aware that Mr. Anderson was doing lath removal at a house in Belgium, Wisconsin, correct?
yes,
And you said there were other areas on the property, and just in a whole, you did not find a body on the property, correct?
correct,
No human remains on the property, correct?
correct.
You talked about the flannel shirt, and if the state would be so kind to pull up that exhibit 40. Oh no, I think I got it, Jessica. Thank you. I'm gonna, for record purposes, pull up state exhibit 42. When was this picture taken?
I don't know.
This picture, wasn't taken on May 17th, correct?
Correct. I believe I was older than that.
It was much older, right? And you don't have a single photo of Mr. Anderson wearing that shirt on May 17th, 2020, correct?
I do not.
You don't have a single photo of Mr. Anderson wearing that shirt on May 18th, 2020, correct?
I do not.
You don't have a single photo of Mr. Anderson wearing that shirt on May 20th, 2020, correct?
I do not.
And you said the state had asked you about whether you searched the house and if you found the shirt. You said you had not, right?
We did not find the shirt.
Did you search Christine Remsburg, Mr. Anderson's girlfriend's house, to find that shirt?
I did not.
Did you search Miss Beecham's house to see if that shirt was there?
We did not.
So the only place you looked for that shirt was at Mr. Anderson's home.
The house in Belgium, a tree farm we looked. Yeah, those three places.
Okay. But you didn't, there were places that you could have searched for it and did not, correct?
Essentially,
Okay. So I'm happy you brought up the house in Belgium. Were you involved in searching that residence?
me along with several others, yes.
And are you aware that the state believes that Mr. Anderson, I guess, chopped up Mr. Gutierrez's body at that residence?
Objection calls for a conclusion that I don't think is in evidence in this case.
I can rephrase and ask a better foundation question.
But
You have no idea where Mr. Gutierrez's body is, correct?
Correct.
And you have no idea how his body or where his body is now.
Correct.
And in fact, he's still technically considered a missing person, correct?
Objection, how would that determination by some mystery person be relevant in this case?
that does,
It's fine. I'll withdraw the question and continue on, Judge. In your investigation, you were unable to determine what, if anything, Mr. Anderson had allegedly done with the body, correct?
Correct.
So when you went to the house in Belgium, you found absolutely nothing of evidentiary value, correct?
Objection, that would call for a conclusion by the detective.
Sure, I'll go into it differently, Judge. You found no human remains at the house in Belgium, Wisconsin, correct?
That's correct.
And you know that this, in your investigation, you're aware that Mr. Anderson had been there the morning of May 18th, 2020, correct?
I know that at some point he was determined to be there. As far as the exact date and time, I don't know.
Okay. And you found no blood evidence or suspected blood evidence, correct?
At that house?
Yeah.
No.
Did you find any trash bags filled with body parts?
No.
Okay. Did you find any bloody knives?
No.
All right. Did you notice that the property was under construction?
Yes.
And did you see that there, I don't know your expertise in the line of contracting work, but you had testified you had seen lath at Mr. Anderson's home. Did you see things consistent with lath removal at that property in Belgium, Wisconsin?
It's likely that's where the lath came from.
Okay. You noted, I want to move back to Mr. Anderson's property. You said that you had looked into the black van, correct?
I did.
And you noticed that the van carpeting had been cut out,
Yes, is missing.
missing. But you cannot definitively say your investigation didn't produce any definitive answers as to when exactly that carpet was cut out of that van, correct?
Well, objection. His investigation does have witnesses that put a time on that.
Well, then he can answer the question. I think it's a totally plausible question.
Why would he be charged with that knowledge?
I'm asking him if he knows.
Well, he can answer if he knows.
Correct.
Yes, I know. I know we have it narrowed down to when it was removed.
And that was solely based on statements of another witness, correct?
Correct.
It's not based on photos of Mr. Anderson removing the carpet, correct?
Correct.
And there were no other witnesses that could corroborate that one witness's statement, correct?
Correct.
You talked about some duct tape and rope. That was also from a single witness, correct?
Correct.
You were not provided any photos of that duct tape and rope, correct?
That's correct.
And you had never observed that duct tape and rope prior at Mr. Anderson's home?
No, I didn't.
The state, kind of going back to the cross-examination or the direct examination on Mr. Anderson's interview with you, had talked about and asked about Mr. Anderson not really admitting to which car he drove, but he said he drove the Audi and the van, correct?
City primarily drives the Audi. He doesn't really use the van.
Did he say he used the van for work purposes?
Yes.
And your understanding is Mr. Anderson's work is as a contractor?
Well, can I approach?
If there's an objection, they can state it.
I think the question opens a door to this officer. He has some knowledge that question. I guess I have no objection. The question was asked, what is his current job, or what's his source of income? That is
exactly, but
that question's been asked. Let's let it be answered. I don't object.
all right, everybody's on board, so.
You go ahead and answer.
Well, if we can have one moment. I'm going to re-ask the question.
Judge, there was no objection. Can he answer the question?
Do you remember the wording of the exact question, officer?
Yeah, what he did for work?
Well, were you aware that Mr. Anderson was doing contract work at that time?
Yes.
And there was evidence that Mr. Anderson admitted to that proves that he was driving the Audi around this time, primarily that he was driving the Audi on April 24th, 2022, correct?
I don't know if he specifically told me that. He did say he was operating a car that night.
And that was confirmed by other witnesses.
Correct.
Okay, I'm putting what's been marked as Defense Exhibit 59 up on the screen. Do you recognize this?
Yes.
Okay, and that was a pizza box and receipt that was on the stove at Mr. Gutierrez's apartment, correct?
Yes.
Did you investigate this at all to see when this delivery was dropped off?
I did not.
Do you think that would have been useful if it was dropped off, let's say on the 17th at night, to talk to the delivery driver?
Potentially.
Because that delivery.
If it was, I don't know when it was dropped. I didn't look at the receipt.
But there's potential investigatory points that could have been covered in investigating this,
Potentially, yes.
and it wasn't, correct?
Objection.
No.
Are you indicating that nobody did this or he did not personally do this? Objection as to vagueness, I don't understand the question.
You can cover it on cross or redirect
Okay.
And I'll even cover it.
if the witness understands the question.
I didn't investigate it.
Okay, and I'll just ask the question the state wants to ask, which is, are you aware of any other officers investigating this?
Huh?
Okay. So I'm going to object because it implies that he would know if other officers did. No one has indicated that he would have some overall supervision of this investigation, Judge.
He's previously testified that he was one of the lead detectives in this case.
Well,
I don't believe he had.
I never said that.
he testified that when he arrived, there was one other detective who was there, but I don't recall any testimony that he is saying that he was the lead detective, but I don't know if he did or not.
Were you aware of other tasks other detectives and officers completed in this case?
Some.
Okay, and the some that you do know if anyone investigated this?
I don't know.
Okay, thank you. Showing what's been marked as Defendant's Exhibit 61. You're familiar with the fact that, well, let me strike that, rephrase. Did you look at the dumpsters in Mr. Gutierrez's or near Mr. Gutierrez's apartment?
No.
Are you aware that that happened?
I don't know.
Okay. You were at Mr. Anderson's home, correct?
Correct.
You looked around the property, you said before, right?
Correct.
It says marked as Defendant's Exhibit 76. Did you notice the trash bags up against the barn at Mr. Anderson's home? I'll zoom in for you if you need.
I don't recall.
Okay, but you'd agree those are trash bags in this photo, right?
That's what they appear to be, that, yes.
Okay, great. Then you said when you were at Mr. Anderson's home, you had looked into the van, correct?
Through
Did
the
you look
window.
at the front window too?
I believe I made my way all the way around the van.
Okay, so I'm going to show you it's been marked as Defense Exhibit 62. Is this an accurate depiction of the front seat of Mr. Anderson's van?
Appears as such.
Okay, and there were tools in his van, correct?
I believe so.
You'd agree that those are tools or a toolbox of some sort on the front passenger seat?
Yeah, tape measure, tools, looks like a tool bag.
Okay. And you'd agree that there's a lot of cluttery stuff around there too, right?
Yes.
Okay. I'm going to show you what's been marked as Defense Exhibit 65. This is another view from the behind of the vehicle, correct?
Correct.
And you'd agree with me that there's a lot of dirt and stuff on the floor, correct?
Looks dirty.
Looks dirty. It hadn't been vacuumed or meticulously cleaned, correct?
Doesn't appear as though.
Okay. I'm going to show you another picture of the front, Defense Exhibit number 66. Again, lots of items, correct?
Yes, very busy.
And this is how it appeared to you on, was it the 20th of May?
Yes.
Okay. And another angle of the front seat taken from the passenger, Defense Exhibit number 67. Again, lots of items, correct?
Yes.
And this is how it appeared to you.
From what I recall.
Okay, great. Showing you more pictures of clutter here.
Yeah.
Defense Exhibit 68. This is the front of the vehicle, correct?
Yeah, between the two front seats, looks like.
And we still see a lot of that clutter,
Yes.
and that's how it appeared to you?
What I recall.
I'll show you another picture from inside the van. Defense Exhibit 69. I think you can see that dirt and trash a lot more clearly, correct?
Yes.
Does this look like a car that has been cleaned to you?
Doesn't appear so.
You said you also went to the tree farm to help with the search that was executed there.
Yep.
And you're aware that there was a burn pit at the tree farm,
Yes.
and multiple agencies had come to process that burn pit, right?
Yeah, there was approximately 100 people that took part.
And you were able to confirm that there was a controlled burn there on May 8th, 2020, correct?
I believe that was the date. Yep.
And that the owners of the tree farm had alerted the Ozaukee County Fire Department of that burn.
I believe so, yes.
Okay. So I'm just going to show you some pictures. This is Defense Exhibit number 70. This is part of that linear search of that burn pit, correct?
Yeah, so I didn't take part in most of that
Okay.
search. I was doing other things.
Okay, but
that looks like the burn pit, and that looks like what they were doing.
Sure.
Searching.
So maybe I'll just ask you then, you were aware that that was a large operation,
Very large, yes.
and they didn't find any human remains there, correct?
Not that I know of.
And they didn't find any bloody evidence there, correct?
Not that I know
Okay. Back to Mr. Gutierrez's home, I'm going to show you what's been marked as Defense Exhibit 58. The number of his apartment building, 3709, that you can see that in this exhibit, correct?
of. Yes.
And that 3709, you can see that from in the parking spaces right in front, correct?
Yes.
And you had been at this scene during the day and at night, right?
No, I was there during the day.
Not at night? Okay. As part of your investigation, you talked to an individual named Kim Lavora.
I did. Kim Labora?
She also goes by Undendum Lavora. I can go get your reports if that would help.
Yeah,
refresh your memory.
you need to
Okay.
clarify that one.
Yep.
We talked to a ton of people.
Yeah,
So.
no.
So I'll stipulate rather than, if you want to refresh, you can, but if you just want to.
I do want to refresh.
Okay.
Thank you.
Yeah.
Could hold those ones in the red file till tomorrow.
Guys,
Kim. Oh, done. Okay.
Counsel, for purposes of the record, you don't want him to read it out loud. You're just
No,
refreshing his memory.
for purposes of the record, I've handed the detective a copy of his own report to refresh his recollection. Does that help?
Yes.
Phone records were obtained in this case from Mr. Gutierrez, correct?
Yes.
And I'm going to show you what's been marked as Defense Exhibit 75. Probably going to have to zoom in here and focus, so bear with me.
Well, given the hour,
This is going to, go ahead, Judge.
well, if it's going to be brief.
With this point, yes. Then I have some other stuff.
Well, I know that. I wasn't going to put it in your entire examination. But it's 1 minute to 3 minutes.
This will be like 1-2 questions max.
All right, I don't know you.
Okay, I won't disappoint. So this phone record shows that these are Mr. Gutierrez's phone records show that he called a Kim Facebook on 5/17/2020 at 8:49 p.m., correct?
Appears as though yes.
And that when we look further up, there's a duration column, and the duration of that phone call was 17 minutes, 4 seconds, correct?
Appears as though, yeah.
I lied. I have 3 questions, Judge. So if there's a phone call that started at 8:49 that lasted 17 minutes, that's going to put that phone call to approximately 9:06 p.m. I'm terrible at math.
Yes.
Okay. Thank you. Judge, if you wanted to take a break.
Well, I won't wait for others. But let's take a break, and please don't read, watch, or listen to any account of the trial. Discuss the case with anyone. And let's aim for about a 15-minute break. Any questions? Okay, thank you.
All right, quick little break. So we're seeing how Kenosha Police Department does investigations. Many things they didn't investigate. Other options they should have looked at. It is interesting, though, that the girlfriend being on the scene, that they allow her to leave, right? She uses the excuse that she wants her kids, she wants to make sure the kids are safe and all of that, right? Obviously a valid excuse for any mother. But she's on scene. She's not escorted by a police officer to make sure if there's any type of physical evidence on her, that's not discarded. No officer escorts her to make sure the kids are safe, that there's not multiple homicides that are happening right now. A lot of interesting things. Leads that they could have potentially looked at are not even looked at. So we're already seeing doubt laid into the jury's minds. But you guys are seeing Kenosha and how they investigate stuff. There's a lot of lazy cops out there. There's definitely way better police departments that do way more thorough investigations in the state of Wisconsin. So, what do you guys think so far of this trial? Are you guys into it? Type in the chat where you guys are tuning in from. Got several people here. Make sure you guys tune in tonight, 7 p.m. Central Standard Time. So in Kenosha, again, it's always Kenosha. A young black woman got her driver's license urinated on by a racist Kenosha car dealership. Another dealership was affected by that because the bad dealership changed their name to a similar name, and the internet went crazy and attacking the wrong dealership. We have an exclusive interview with the good dealership tonight, who's offering to give her a free car because of the bad experience that she went through. So they've offered to give her a free car. So we set up an exclusive live stream interview with that dealership tonight. So we'll have them on tonight at 7 p.m. So make sure you guys tune in for that. So when today's court case ends, I'll end up setting up the stream, and then you guys can share it out. But we will go live at 7 p.m. with the cool dealership. So make sure you guys share that out everywhere. If you're on TikTok, you can follow us on our TikTok page and then do your little duets and stitches and all whatever it is that you guys do on TikTok, and do that with our video and get it out there. Let people know on TikTok that we're getting this dealership on here. Share, the stream. When we set the stream up, you guys can come on to the YouTube channel and you can already start sharing it out. You don't have to wait until 7 o'clock once we go live. You guys can share it out already and give people advance notice. If you're on Twitter and all types of other pages, share the streams out. Let's get a bunch of people here. I've been watching the murder trial. Yeah, we were streaming a little bit of that. The majority of the defense case is finding fault with law enforcement in their incompetent or even shady investigation. Yeah, specifically South Carolina Law Enforcement Division. I don't know if it's poor training, lack of resources, not enough personnel, but the quality of law enforcement in general has really declined. Yeah, it does seem like when there's, like we're hearing obviously in the last few years, right, about a lot of police brutality issues and all of these things. But if we kind of ignore a lot of that stuff and we talk specifically about like actual crimes that are happening, murders like this and these unsolved murder cases, cold cases. We just did the Mark Jensen trial and we saw that they put a detective who had done one homicide before that, and he's walking around the house touching stuff without gloves on, not taking, bowls and cups that potentially could have had antifreeze. You know what I mean? And there's so many mistakes that are happening. So I wonder if you're onto something, that even like legitimate investigations, they're not being trained properly to handle that. And a lot of you, like when you live in your cities and you see that a district attorney's office has a 97%, a 98%, a 99% conviction rate, that doesn't mean that they've taken those cases to trial and they've won. That means that they've overloaded the charges to scare people, and the big majority of people end up taking plea deals. So, the people that are taking their cases to trial, there's a decent amount that are actually winning. So yeah, I've been wondering the same question. Are police getting lazier, or are they not being trained properly when it comes to investigations, when it comes to evidence handling, places to look? I think we're kind of used to some of that old school stuff where they're kind of taking everything, right? Every piece of evidence. It's kind of that exaggerated with like fingerprint dust, right? Like the whole house is covered in like black dust from them dusting everything. But even in the Mark Jensen trial, we're finding they never fingerprinted pictures. They're not fingerprinting cups. They're not fingerprinting any of these things. Their original press release or a new one? I saw their original press release that they're aware of the incident, but what they're not going to tolerate is threats, and basically they stuck up for. Oh, here. No, they just put one up an hour ago. Look at these scumbags. February 26, 2023, Kenosha Police Department was made aware of a video depicting a person's driver's license being urinated on. Contact was established with the person to whom the driver's license belonged to the same day. With crime victims' rights in mind, our investigators provided time for consideration to the victim. On March 1st, yesterday, 2023, follow-up conversation with the victim led Kenosha Police to refer the following misdemeanor charges to the Kenosha County District Attorney's Office. Each of the two adult men associated with the video received the same referrals: criminal damage to property, disorderly conduct, theft, unlawful use of computerized communication systems. Additionally, Kenosha Police obtained and served a search warrant for the incident location and recovered the driver's license. Kenosha Police Department is not naming the victim, nor will we name the suspects until they are formally charged. Holy shit. Holy schnackes. Interesting. Thanks for alerting me to that. I didn't get notified because I don't have my Facebook up. Very interesting. They just keep going down. What is with this long crime, bro? Their feeds suck. We need to be at the courthouse and get court TV. Thousand people watching on fucking long crime. Hopefully they don't get off. Yeah. We need copies. If the state's attorney picks up those charges, we need to get one of you guys, either you or grandkids, to go to the courthouse to get us a copy of the criminal complaints. So I'm gonna start messaging them. I'm gonna start messaging the DA's office and the court so that we can get notified right away if the DA actually accepts charges. But I mean, those of us that live in, are from Kenosha, we already know, right? Like KPD will be like, "Oh, we don't want any nonsense. We're going to issue charges," knowing that the state's attorney is not going to pick those charges up. Yeah, Melinda, I agree with you 100%. 100%. All right, let me type my breaking news. Day drinker, grandkids, do me a favor. Try to find this woman. I've tried to contact her already. Try to contact her. Try to get a hold of her. We have the dealership, the good dealership, coming on for an exclusive interview. Let's see if we can get them. Let's see if we can get her on and get them all in one spot on the stream. Let's see if we can get her a car tonight. Can you guys reach out, try to find her, try to see if she'll message? Interesting, grandkids. Interesting. Whoa, what the fuck was that, dude? All right, I'm posting this on the Facebook page now. If you guys can share this out everywhere from our page, that would be helpful. Super helpful. I'm gonna do a TikTok video right now with me. See behind the scenes. They need to hurry up with this court break. Let's see, we'll do it. We'll do a TikTok video behind the scenes. How do we do this? Hey, what's up, TikTok? We just did a video about Kenosha with this racist car dealership that urinated on a young black woman's driver's license. We have an update for you. The two individuals seen in that photo have charges pending that were referred over to the Kenosha County District Attorney's Office. You can check out the details of that on our Facebook page, NSM News Updates. Also, tonight, we have an exclusive interview with the dealership that is offering the woman a free car and also suffered some ramifications for this event. So tune in on our YT channel. The link is in the description tonight at 7 p.m. Central Standard Time for an exclusive interview. All types of updates about this situation. Be sure to tune in on our YT channel. The link is in the description and in our bio. Check that out. And we will see you tonight at 7 p.m. Central Standard Time. Tons of updates, folks. Tons of updates. Tune in. Oh my God, I hate fucking TikTok. Fucking hate TikTok. I need like one of the mods to be doing this because I can't be doing no goddamn TikToks, dude. I hate it. I can't stand it.
Coffee is life.
We got 7,200 views, almost 7,300. 7,200 views on TikTok. Oh, can I just upload? Oh yeah, here. Oh, here we go. Court. I hear noise. I hear noise. Finally, let's get to it. Hey, what's up, TikTok? We just did a video about Kenosha.
Okay. Shall we begin? Would you come down, please? Yeah. Thank you.
You want the officer, you want the detective to go back on the stand?
Yes, please.
Yeah, going back up. Detective, yeah, sorry.
Weird.
Yeah. Okay. Yes, go ahead.
Thank you. All right, I'm pulling up what's marked as Defendant's Exhibit 63. This is picture of the dash in Mr. Anderson's van, correct?
I'm going to object, Judge. The detective has indicated he took a brief glance in without entering the van. I don't believe he's a witness who would be able to talk about details of the of areas in the van that are not the cut area in the back or the bleached area that he's testified to. So this is a close-up view. He says he took a brief glance. I don't think he's a qualified witness to testify to this exhibit.
He can respond if he doesn't know the answer.
I don't know what that is.
Okay, that's fine. That was 63. I'm going to ask you about some dates and what you reviewed. If you need your recollection refreshed, just let me know.
Okay.
Do you remember on May 25th, 2020, reviewing video footage from a Highline gas station?
Yes.
And that gas station was located near Mr. Anderson's home, correct?
I believe it was at the interstate near the tree farm.
Okay. And so if it was in Ozaukee County or Sheboygan County then?
Ozaki?
Okay.
I'm guessing. I'm sorry.
It's fine. I could give you the locations you put in your report. I don't know if that would help. You said
Please.
located at Interstate 43 and County Road D.
Correct.
Okay.
Yep.
So Ozaukee County?
Yes.
And the reason that gas station was important was because if Mr. Anderson had traveled to the tree farm or back from his home, he would have passed that gas station, correct?
Objection. We don't. The detective would have no ability to know the route that somebody took to get to someone's home. Presumably, there's a number of highways, number of roadways.
I'll rephrase it. Why was getting and reviewing the surveillance video of that location important to law enforcement in this investigation?
It was a potential route of travel.
And you reviewed several hours of video, correct? For the Highline gas station.
Yes,
And you reported that you did not see Mr. Anderson's black minivan, correct?
so the cameras were substantial distance from the road. And at nighttime, it was almost impossible to tell what cars were going by. So I don't know what cars were going by. No, I didn't see a black van drive by.
And in your report, you were clear that you reviewed several hours of video and did not see the black minivan.
Correct.
You also indicated that on May 26, 2020, you continued to review video surveillance, correct?
Of what? What surveillance are we talking?
Yeah, I was hoping you could answer that. Can I show you your report?
Sure.
Okay.
Sure.
Look, I'm strict here.
So
Did that refresh your recollection?
yeah, so we had hours and hours and hours of video from multiple locations we took. I didn't document what I looked at there, but we reviewed several locations. I don't know specifically what I was talking about when I mentioned that in my report.
But is it a fair guess that those were locations of interest due to potential traffic patterns of Mr. Anderson?
Potential routes, yes.
And in your report, you noted that you observed nothing of evidentiary value, right?
Correct.
And can you explain to the jury what nothing of evidentiary value means?
I saw nothing regarding a black van, a black Audi, or anything related to Mr. Anderson.
I have no further questions subject to redirect.
I'm going to start from the back. So you were just asked about some video that it sounded like it was a gas station location that you looked at.
Yes,
And that appeared to be on May 25th, 2020, correct?
correct.
You wrote a report that memorialized those fascinating hours, I assume, right?
Yes,
Counsel read to you, I reviewed several hours of the video and did not see the black minivan. Do you recall that just being read to you?
yes,
Is the next sentence in your report, however, the video was from a great distance, making it difficult to make out traffic, especially during the hours of darkness. Is that what you say next in your report?
that's what I testified to as well.
And so when counsel read to you the first sentence, you had already also tried to testify as to the second sentence, and it's also in your report. Is that right?
If you just read it, it's in their report.
You have no reason to dispute it. Would you like to take a look?
Sure.
I'm going to object. This witness has already testified to that contents, and the video was poor quality and it was dark.
Well, sure, you saw it's the next
Yeah.
sentence.
What page? Wait, actually, Mike, what page is that?
It is. So I'm just going to ask you to take a look at your report and ask you, do you agree that after the first sentence that was read, there was a second sentence and it's what you testified to?
Yes.
Okay, so it's also in your report, is that right?
Yes.
You were shown on the doc cam just a minute ago, or I'm sorry, before the break, the signage indicating what the 3709 address for apartment 1B. You recall that?
Yes.
And that picture was one where you said that the sign was visible, correct? Like would be visible from the road.
Yes.
You recall
From
testifying?
15th Street. Right? From the road.
Can I see it? Yep.
So I'm going to show that to you on the doc cam again. Does that appear as best you can see to be? Of course, I forgot that you got to do that. Does it appear to be a daytime photo, if you can tell?
It is.
Okay. At nighttime, would you expect there to be substantially different visibility?
I'm going to object. I asked this witness if he had been there at night, and he had said he had not. So it'd be purely speculative.
Well, I think he could.
Go ahead.
At night, would you expect that signage to be significantly more difficult to read?
I would believe that to be a safe assumption.
Okay.
It's dark.
And on the 17th of May, do you believe it to be heavy? Was it heavily raining?
Yes.
Was it heavily raining at night?
Yes.
Have you, and so if I add in heavily raining at night, would you expect the signage 3709 to be different and more difficult to read than it is in the current state of the daytime photograph?
Rain would obstruct the view of the sign at night.
You were shown a picture. It is Defense Exhibit 65, where you were asked if whether the van, and this is the defendant's van as best you know, correct?
Correct.
You were asked if it appeared to have been meticulously cleaned. You recall that?
Yes, that's what I was asked.
Okay. Now, this is not the same view you saw. You saw the van during the day, for instance, correct?
Through a window, yes.
When you saw it, did it appear to have been selectively cleaned as opposed to comprehensively cleaned?
Yes.
Okay. And what left you to the conclusion that instead of someone comprehensively cleaning the van, and have you ever cleaned one of your cars?
Yes.
Do you normally, detective, clean only small portions of your car? Say, if you have a minivan, do you only clean the back third?
Typically not, no.
Would you use bleach on just certain locations, or do you typically clean the entire automobile if you are engaged in your normal activity?
I'd clean the whole automobile and I wouldn't use bleach on a carpet.
Okay, so when you observed what appeared to be bleach stains and the back cut out, was it your sort of at least beginning conclusion that somebody had made some efforts to do something to that minivan that wasn't involved in just trying to keep it clean?
Yes, it definitely wasn't normal.
I'm going to show you what's been marked as State's Exhibit 59. Do you recall this pizza box from your walkthrough of the scene?
I know there was a pizza box, but my walkthrough was what it is, a walkthrough. I didn't stop and do crazy examinations. I didn't evaluate evidence while I walked through the residence to get a gist of what happened.
So I guess I'm going to ask you plainly, are you the best person from the Kenosha Police Department to testify as to each of these areas or items and whether anyone collectively on this investigation did anything further? Are you the ideal person to ask those questions to?
No.
For instance, if an officer called the pizza place and made some determination that this was not an issue in this case, in other words, in terms of the timing, would you know that one way or another?
No, I know some things. I don't know others. I didn't lead the investigation. I assisted.
As to the specific fact I asked you,
Yeah.
if an officer made that call and determined it was not an investigative lead, do you know that or would you know that?
Not necessarily.
Okay, and in this case, do you know that?
No.
You were showed a picture that is State's Exhibit, I'm sorry, Defense Exhibit, apologize, 76. Do you recall this?
Yes.
You recall that it was, I believe it was honed in and there's some garbage bags along the side of that particular building. Do you see that?
Yes.
And you were asked whether that was something you personally had reviewed, I believe, correct?
Something to that extent.
Are you aware that in the context of this investigation that those garbage bags were the remains of marijuana grow? That they are potting soil and other remains from a marijuana grow?
I'm going to object on the grounds that, one, speculation, lack of foundation. As he already testified, he did not look at those bags, look in those. It's also an argumentative question.
Counsel brought it up. I didn't open this door. He's either aware that that's what the contents of the bag are or not. That would lead a reasonable jury to decide, is this an investigative lead about a missing body? If it's bags of potting soil for marijuana, then it would be reasonable to conclude that's not a place, that's not necessary in terms of this investigation.
Well,
And I didn't bring the bags up, they did.
you're asking him about what his awareness was?
Yeah, which is what they asked.
Well, but the investigation is an entire group of separate inquiries. And if having an adequate investigation also involves proper coordination
Yep.
of various reports and observations. So you're asking him if he is aware.
Right. Which is my redirect question to their specific cross-examination. I'm using the same phrasing. He's either aware of it or not. If he's unaware of it, obviously I would have to put in any affirmative evidence of it with some other witness. But this is a question of whether he's aware, because the topic, I assume what my redirect is directed at is, if I am correct that these are marijuana potting soil bags, a quantity of them, then obviously they don't have an investigative lead quality here. And again,
That's argumentative.
Apologize, they brought it up. So
Now the objection is sustained.
as to his awareness, the question is to his awareness.
Yes.
Okay, all right. You were asked by the defense on cross-examination, counsel, whether there was any videotaping of the defendant cutting the carpet out of the van. Do you recall being asked that question? Whether there was any videotape available of him, of the defendant cutting the carpet from his van during this period of time? Or pictures, either
No
video
photos.
or pictures?
Yeah, and there was no photos.
Okay. Would you expect someone who is trying to remove blood evidence from their van to videotape themselves or take pictures of themselves during that process? Is that something you would expect?
I'm going to object. This question is tending towards argumentative.
Sustained.
Yeah. You were asked whether on cross-examination, whether Anderson's home had any body parts at its location or any other blood evidence. Am I correct that the search warrants at Anderson's home were 2 days and 3 days after the time you believe that Mr. Gutierrez was murdered?
Yes.
Okay. And do you have any specific reason to believe that at any point that Mr. Anderson either stored the body at his home or did any of the blood work at his own home? Do you have any reason to believe that?
No, we
Okay.
found nothing to suggest that.
And so, again, would a person having 48 hours to no longer be in possession of the body of Rosalio Gutierrez or of any of the blood evidence, would a person have enough time during that period of time to either not have that evidence at their home and also to dispose of that evidence? Is that a sufficient amount of time?
I'm going to object. This is beyond the scope of my cross-examination. And it's also argumentative.
As to the first objection, as I think I commented the other day, I am always hesitant to limit an examination as not within the scope unless it's really things that ought to have been fully covered earlier. So I'm going to overrule you on that. On the fact that it's argumentative and speculative. Speculative.
I thought the argumentative objection is me being argumentative with a witness. I'm not aware of argumentative being, that there being another form of argumentative. I thought it
There
meant
are
to be.
two forms.
Okay.
One is arguing with the witness, which is really is a branch of things that ought to be taken up in argument. And the lawyer is simply attempting to have the witness testify in a way which is a substitute for the argument. That's really the principal problem with argumentative questions, but it can be both. But it's also speculative. I mean, I think your question is, and correct me if I'm wrong, I think your question is, how long does it take to dispose of a human body?
Or, well, not how long, but can it be done in 48 hours before this search warrant is done?
Don't know.
Well.
I don't.
Okay. Okay.
I've had lots of pathologists up here and who will probably have it before this day is done, or before this case is done. Oh, no, we won't. No, not in this case. But that would be speculation as to how long it would take to dismember or otherwise dispose of a human body.
Well, I mean, I'm not aware of any specific evidence that there was a dismemberment. One can just bag up a human body and place it in a dumpster.
Also true.
Okay.
Well, but dismemberment might be the more efficient way to do it. I don't know.
Possibly.
Go ahead. No, but the objection is sustained.
So you were asked whether you saw a picture of the defendant in a flannel shirt. Do you recall that?
Yes.
And when that picture, and you don't know when the date of that photo was?
I don't.
Your reason for focusing on that flannel shirt is you have multiple witnesses who told you that just hours before Rosalio Gutierrez is murdered, in your belief, that he's wearing that shirt. Is that correct?
I'm going to object again on argumented grounds and foundation. There's been no testimony as to what time it's believed that Mr. Gutierrez was murdered or went missing.
Well, the problem I'm stumbling on with the question is what the detective's belief is. As I say, this gets into the argumentative, the subject we were just talking about this is really part of your argument later in the case that is attempting to be extracted from the witness. And the witness in order to respond, it seems to me has to employ a lot of speculation.
Well, he has a working theory as to when this occurred. And he is, remember the flannel shirt is a focus of the search.
Right.
Okay. So the cross-examination question was, well, you're basing this just on two witnesses. You have no photo at the time. So it is redirect to say, well, you have two witnesses and they are close in time because we have no photograph of him that day. They are close in time to your working theory of when Rosalio Gutierrez is killed. So that counters with his testimony that his basis of focusing on the flannel shirt is that multiple witnesses say just hours before Rosalio Gutierrez is murdered, per his working theory, based on electronic evidence, etc., that they see him wearing this flannel shirt. So it's not remote in time, which is the suggestion of the cross. And so the redirect is to show that, not that it's true, right, but that he's been provided information that it is recent in time.
If I may respond.
All right.
Thank you. First, if the state wants to ask, do you have a theory about when Mr. Gutierrez went missing, then that's the proper question to ask to lay the foundation for this series of questions, not to ask a speculative, argumentative question without laying that foundation. I have not heard any testimony from detective about his theory of when Mr. Gutierrez went missing or was killed. So again, I maintain the objection.
Counsel and Cross did not ask any foundational questions in that regard either. Why would he have to explain the theory if he's simply indicating it's near in time?
Well, given the opening statement that was made by the defense,
Yeah.
I think that the existence of a quote working theory unquote may be a line that you might want to pursue and could, but that's not entirely clear thus far. And number two, the way it's being presented is, in my opinion, argumentative, and also it's speculative. The objection is sustained.
When were you told that the two witnesses who are your source that the flannel shirt was being worn, what was your understanding of the time that they indicated they last saw the defendant in the flannel shirt?
I believe it was around 4 o'clock Sunday.
Okay, Sunday is May 17th.
Yes.
And are you a person who has knowledge of the electronic evidence of this case, at least in the general sense?
I know some.
Okay. And is, on the same day, is Mr. Gutierrez believed, based on the electronic evidence and his absence of any more responses after, is he believed to have been killed at a time in the area of 10 p.m.?
I'm going to object. This is already extremely leading.
What do you say?
Between 9 and 10 p.m. on the same.
Wait a minute.
I apologize. I thought you said yes. I apologize.
Oh, I'm sorry. I said it seemed it was leading.
Okay, I'm on redirect.
Right.
Okay, so I'm trying to direct him to the place that the court asked me to. The only other avenue I would have to ask this question is to ask him to explain what time, when he is not the detective who formulates that.
The objection to a leading question is based upon the fact that it is suggestive of the answer. And the form of your question was suggestive of the answer.
What time period, in your knowledge, detective, is the time period where it appears that Rosalio Gutierrez has been murdered?
Between 9 and 10 on Sunday the 17th.
That's the same day as as you've indicated, around just before 5, that the two witnesses saw him in the same in a flannel shirt that seems to match the picture.
That flannel shirt, yes.
You were asked whether Michael Campbell had offered you information that on May 17th that his phone was at the home of Rosalio Gutierrez at some point. Do you remember being asked that question?
Yes.
And you knew that Michael Campbell was a friend of Rosalio Gutierrez.
Yes.
Did it cause you any concern that he did not, that his friend did not tell you that he had some contact with his residence on some period on May 17th?
No.
And are you aware, pursuant to this investigation, that contact that they're speaking about is actually at 1:45 a.m. when you have just indicated that your thoughts on this case is that it would be 20 hours later 9 or 10 p.m. that Mr. Gutierrez is murdered. So it would be 20 hours earlier. Are you aware of that?
No.
You were shown a picture of the bedroom of Rosalio Gutierrez. Do you recall that picture?
Yes.
And that picture had a window in the far side of it, correct?
Yes.
Are you also aware that the reports in this case is that the slider that would face the street was also found open in this case?
Yeah. I don't know.
Oh, you don't know? Okay.
I'm sorry. The sliding
door yeah.
in the living room.
Yeah.
I thought we were talking about the bedroom window.
I apologize. I meant the sliding door in the living room. Are you aware that that was found open?
That's what I was told. Yes.
The screen was closed?
Yes.
Okay. So that would be another logical method of entry, correct?
Yes.
Simpler method of entry than climbing in a window, correct?
Yeah.
The blinds were in no way disturbed that you saw in the picture, were they?
Not that I saw.
Did that picture include notes on it? I'll show you.
I believe on the pillow on the bed.
Judge, if I can have a sidebar on this issue of line of questioning.
You probably haven't had an opportunity to see all of my brewers pictures in the back. So why don't we take 5 minutes? We'll be able to do that. Opening day is coming. So please don't talk about the case during this very short break.
Dude, he always has to talk about his baseball team too. Have you guys noticed that? He's always got to. His whole Trump ringtone went off. It's gone off every day in the trial so far. We're going to clip that again though tonight. That got us a lot of views during the Rittenhouse trial. We're going to clip it again. And then everybody on the right was like, that's not the Trump ringtone. That's God Bless America. Yet that was played at his inauguration. Stupid, dude. So stupid.
The last few years, there hasn't been much demand in my group.
Fucking traitor, dude. Why is prosecution allowed to ask hearsay questions? The witness said he was told the sliding window was open. Yeah, there's a lot of, dude, I'm telling you, there's a lot of weird stuff that happens with these Kenosha cases.
The preemptory position that the defense was noting here is there is a piece of paper on the pillow on the bed that's a note from Mr. Gutierrez's daughter. The defense's position is that the contents of that note are not relevant to this case. I could see the potential argument that the state would want to make by introducing that there's a note on the pillow. If they're going to try to loop in that, oh, we must have not slept there then that night when it was put there, that's fine. But the defense would object to going into what note says based on the fact that it's not relevant. And the defense's position would be that the introduction of what's in that letter would be simply to garner sympathy and appease to the emotions of the jury, which would be inappropriate.
I intended to simply indicate the first thing that counsel said. I did not intend to ask about the contents of the note. I just intended to ask, is this a note that was determined to be a note from the daughter? When was the daughter there? She was there Sunday into the afternoon. And that is a piece of evidence. The bed was never slept in after May 17th. So I didn't intend to go through the content. In fact, I'm not sure he'd be able to read the content of the note. So.
And I think too, I mean, there's no evidence if it's from her daughter, the daughter, or the son. So as far as who the note's from, I think too is irrelevant. I think if the state wants to say there's a letter on the pillow, that should be the extent of the inquiry.
It's signed.
Is it signed?
It's signed by the daughter, yeah.
Well,
And again, I'm not going to get in the content because I don't want her name to come up other than that it's the daughter. But again, I think it is another way to time this out. This is this is a exhibit introduced by the defense for this witness. So obviously we have other witnesses coming, but I think it's valid redirect.
well, here's the problem, and I'm not criticizing anybody. This case is coming in with an enormous amount of evidence, which ordinarily would be totally inadmissible. And you said it a moment ago when we first started talking about this, you referred to it as a note which has been determined to be from the daughter. So there's some more that we're not apparently going to get into, but it's an example of how things without any sponsorship are getting into the record. And it really is bothering me quite a bit. Now, I'm not saying anybody's done anything that isn't right, but the sooner we can move into what would ordinarily be received as circumstantial evidence, the better. Apparently, this is not a problem which is going to torment us. So I'm not going to worry about it, but just make a timely objection if you think something's going on that oughtn't. Okay? Now, let's let the jury on it.
Can we get a ruling though on the scope that the state can go into as it relates to that?
As I said before, I really can't pre-screen.
Understood. So I'll just
Go into.
understood. I will then just renew the objection where I find appropriate.
Thought his purpose, I understood, was to demonstrate that it did not appear that the bed had been slept in during the period indicated.
Since she left, since the note was placed there.
Yeah.
Right.
Okay.
Yeah, there's a lot of speaking objections that are happening in front of this jury.
I didn't I veto a couple of them?
Gravely likes
I
that though,
didn't.
because then he can get his point across in front of the jury, and the jury hears it.
What's that? Down on a contempt, yes.
Shall I proceed?
You please do.
Okay. Detective, I again ask you to turn your attention to Defense Exhibit 60. You've indicated previously that's the bedroom. Is that correct?
Correct.
Okay. And that there was no DNA, there was no blood evidence that you saw in your opinion, in this room. Is that right?
Not that I saw.
Conditions were muddy and rainy on this day. Is that correct?
Yes.
Was there any evidence on the windowsill that you yourself noticed that somebody would have entered knowing that it's wet and rainy over the last several days?
Not that I saw, but I also can't say I examined it thoroughly either.
That's not something you focused on?
No.
Is there a pink note on the bedroom pillow in this depicted here?
Yes.
And is that a note appears to be the author appears, at least by the note, to be the daughter of Rosalio Gutierrez?
I'm going to object as far as foundation and speculation.
Well, I thought that's where
I thought
that's where we drew the line.
That was my impression that That was,
The defense's position is that it's not relevant what the contents of the note are or who authored it.
I certainly remember the first part. I'm afraid I don't remember the second part of that. The remark that I made at the time was that that it was again a question about the sponsorship. Objections overruled, but I think that was the understanding. That's as far as we're going with it.
That was my understanding.
Okay.
And I don't want the name of the individual, but does the note appear to indicate an author?
Yes.
And is that is the author a person related to Rosalio Gutierrez?
His daughter.
His daughter. Okay. And is the note placed physically on a bedroom pillow?
Yes.
Are you aware of when last Rosalio's daughter was located at his apartment so she'd have access to his bedroom?
Yeah, she was at the house on the 17th through the early afternoon-ish hour.
Okay. So that pillow had a note on it, and that daughter is under 10, correct?
Yes.
Okay. And she was last at the residence on the 17th in the afternoon.
Yep.
Slide it one way and pull it down. There you go.
So much better.
Detective, what is your estimate on how many interviews you personally were involved in this case? What would be your general estimate?
25 or so.
And
Around.
and did that involve a number of people, wide variety of people from all those different directions in this case?
Yes.
And at any point that you came upon something that was evidence that persons were involved somehow in the disappearance or murder of Rosalio Gutierrez, at each of those occasions, did you pursue that evidence when it was apparent to you based on all those interviews?
If I didn't directly, I would pass it on to other detectives that would follow through with that.
Further questions, Your Honor? Thank you.
Yes, thank you, Judge.
Yeah.
I don't know if you want me to pull up the. Thanks, Jessica. So the state had in redirect asked you about that there were portions of the van that had been selectively cleaned. The area under where the missing carpet is, that area, to your observation, had not been cleaned, correct?
I'm sorry, what area?
Where the metal is exposed, that there was dirt and other items that show that area had not been cleaned?
Objection. The removing of the carpet would be the cleaning.
Well, I'm asking if under the carpet was cleaned.
Irrelevant whether you've cleaned under the carpet.
I don't think that's.
I don't want to preclude her examination. oral.
I can re-ask it, that in
Please.
that area, sorry, Detective, in that area where the metal is showing where the carpet used to be, there's a lot of dirt and other scraps indicating that that area hadn't been scrubbed clean, correct?
There is dirt and there is things over the metal.
Okay, thank you. I don't need Exhibit 263. Thank you, State. The state had asked you about the efforts that you observed in the minivan were concerning to you, and you had said that it was not normal, correct?
Correct.
But you'd agree there are plausible other explanations for why an individual cleans a work van, correct?
I'm sure you could come up with some.
And the state had asked you about the screen door being open. You said yes, but you were not the first officer on scene, correct?
I was not the first officer, no.
So you wouldn't know how that door was observed when officers first responded.
Correct.
The state just now, the last question that it asked you had to deal with all the interviews that you had with people. So I want to kind of break that down a little bit. You spoke with Michael Campbell, correct?
Yes.
He was just a friend of Mr. Gutierrez.
Correct.
You spoke to Eileen Knoll, correct?
Correct.
She was a friend of Mr. Gutierrez.
Right.
And they didn't provide you any investigatory leads, correct?
Correct.
You then spoke to Sadie Beecham, correct?
Yes.
And it was your prior testimony that she had immediately stated that she believed her ex, Zachariah Anderson, had something to do with it, correct?
Yes.
And you followed up on that one, right?
Yes.
All right. And you also spoke to Olivia Anderson, correct?
Yes.
And that was in relationship to Mr. Anderson, correct?
Yes.
You interviewed Mr. Anderson himself, right?
Yes.
And you interviewed Christine Remsburg, correct?
Yes.
That was the girlfriend of Mr. Anderson.
Correct.
So she only dealt with Mr. Anderson, right?
Yes.
And you interviewed, I'm probably going to butcher her name, but Casalina Remsburg,
I believe she went by Cassie. Yes.
and that's Christine Remsburg's sister, correct?
Correct.
Again, relating only to Mr. Anderson.
Yes.
And then you spoke with Andrew Schultz, correct?
Correct.
That was a friend of Mr. Anderson's, correct?
Yes.
And then you spoke to Alex Wetzel,
Yes.
again, a friend of Mr. Anderson's, correct?
I believe it was a cousin.
You talked to him only as it related to Mr. Anderson, though, correct?
Correct.
And then you spoke with an individual named Amber Stark.
Yes.
And she was the girlfriend of Alex Wetzel, correct?
Yes.
And that had to deal with confirming his whereabouts the weekend of May 17th through
Objection
May.
is to hearsay.
I'll rephrase the question, Judge. You spoke to her as it relates to your investigation of Mr. Anderson.
Correct.
And then you met and interviewed Solomon Anderson, correct?
Correct.
And that's Mr. Anderson's brother.
Yes.
And then you interviewed Jennifer Libers, correct?
Yes.
And that's Solomon Anderson's girlfriend, correct?
Yes.
And then you interviewed Joshua Anderson, correct?
Yes.
That's Mr. Anderson's other brother, correct?
Yes.
And then you interviewed Zenith Anderson, that's Mr. Anderson's sister, correct?
Correct.
Then you interviewed Stephen Lenz, correct?
Yes.
That's a friend of Mr. Anderson, correct?
Yes. Correct.
So who did you interview that provided you other investigatory leads other than Mr. Anderson?
I didn't say I found any.
I didn't say,
I didn't say I found any other ones.
No further questions.
Were you just asked whether you spoke to Umdeen Lavora?
Yes, that's another one. Kim?
Was that included in the list you were just asked?
No,
Okay, so that's not a person related to Mr. Anderson, is it?
correct.
Okay. And when you spoke to Michael Campbell, he provided you information that Rosalio Gutierrez had given him that led you towards the defendant.
I'm going to object as far as hearsay. Also leading.
Judge, there's just been a whole series of people listed, and they said there are no investigative leads that you pursued. I'm suggesting there are investigative leads on certain ones, and I'm asking,
He's
again,
now-
using the identical list of people that they just talked about. I'm not required to only talk about whether he found any leads that don't involve Mr. Anderson.
Judge, if I may, the state asked him, oh, you interviewed a bunch of people and you followed all those investigative leads. I then went into all the people he talked about. I asked him about Michael Campbell. He answered it. Now he's trying to go into exactly the information that Mr. Campbell had allegedly provided. And additionally, if the state is going to make commentary about what he wants the witness to answer to, I'm going to ask that that be done outside the presence of the witness.
let's just, much of the evidence you're hearing throughout this case would ordinarily not be admissible under that big rule, the hearsay rule. When I was in law school,
Here comes the history lesson, chat. Here it comes. He's got to explain. He's got to explain. Here it comes. Here it comes,
about
chat.
a third of the entire book was about the hearsay rule. The hearsay rule is a very, very, very complicated rule. It has many exceptions, things that you might think would qualify as hearsay. And hearsay is evidence of an assertion made by a person while the person was not in court, under oath, and subject to cross-examination, which is offered in evidence to prove the truth of the matter asserted. So it's not anything that somebody said who's not on the witness stand. Sometimes that's what it is. But sometimes a lot of it isn't really being offered to prove the truth of the assertion. It's being offered to prove something else. And in those cases, it's not hearsay. Then if it is hearsay, it's subject to a large number of exceptions from the hearsay rule, which even though the testimony is hearsay, an exception permits its receipt into evidence. And believe me, we could take months and talk about this. But there are many times when hearsay does find its way into the court record. I've never seen a case in which so much hearsay has come in. And I'm not suggesting that it hasn't been proper or that the lawyers haven't used it properly, but you're hearing a lot of hearsay that would ordinarily not be brought in. The critical feature for almost all of it that you're hearing has been that it's not being offered to prove the truth of the underlying assertion. And we're at that point again now where I'm going to allow the witness to testify about what Mr. Campbell, what he claims Mr. Campbell said to him. And it's not being received for use to prove what Mr. Campbell is reported to have said is true. It's not being received for that purpose, and you're not to hear it for that purpose. It's being offered in response to the defense contention that the police investigation was deficient. And what the district attorney wants to show is that the police were investigating and did receive some information, and then made a determination about whether it was worthwhile pursuing or not. It is, again, he's not the final judge of what's true and not true. It's just he has to make a judgment for purposes of his position about whether this is something worth pursuing. The burden of proof in the case is totally unchanged. And that is for the state to prove the charges against the defendant beyond a reasonable doubt. And what leads the officer decides to follow and those that he doesn't are really not relevant to that. And all this evidence that is coming in that is ordinarily hearsay is being received just in response to the defense claim that the case wasn't properly investigated. And I might add, in my final comment, is that the huge portion of the book about the hearsay rule, I can still remember the first sentence. There is nothing murkier in the law of evidence than the hearsay rule. So it's a very, very complicated rule, but I just want to caution you in this case that ultimately you must rely on facts which are proved by the case and are proved by proper evidence and that are sponsored by the person who, generally sponsored by the person who's making that assertion, who's here and subject to cross-examination. I know I could have done a better job of this, but is there anyone who has any question about this? Okay, I'm going to overrule the objection and permit the question with that understanding.
So Detective, my question was, I'm not asking for the content, but was Michael Campbell a person who provided information to law enforcement that would conclude, that would lead them to go to further their investigation of the defendant?
Yes.
Did Eileen Knoll, when questioned about what circumstances she was aware of and helpful on, did that cause you and other law enforcement to further direct your investigation towards the defendant?
Yes.
Did Sadie Beecham, in her interview, give you factual circumstances and things to investigate consistent with the defendant being the person responsible for these crimes?
Yes.
Did the defendant's daughter, when interviewed, give you information, eyewitness information and witness information that would lead you to further investigate the defendant?
Yes.
Did Christine Remsburg, the defendant's girlfriend, provide you substantive information that would lead you to continue and further your investigation of the defendant?
Yes.
Did Cassie Remsburg, her sister, provide you information that was consistent with that as well?
Yes.
Did members of his family, of the defendant's family, provide some information that would direct you towards the defendant and continue your investigation focused on the defendant?
Yes.
Did Stephen Lentz, when interviewed, lead you to have additional information that would lead you towards the defendant?
Yes.
So all of those people, when you interviewed them, again, led you in terms of following evidence towards the defendant. Is that correct?
Yes.
Nothing else.
Those people that led you to information about Mr. Anderson, none of them provided any information that they saw Mr. Anderson at Mr. Gutierrez's apartment on May 17th, 2020, correct?
Objection, that's outside the scope of my question.
I think it's exactly in scope of his questioning.
Well, actually, as I've repeatedly said, I'm usually not too rigorous in the application of that rule, but we're getting close to the point or my rigor may return. So you can have an answer to this one.
Could you repeat, please?
That those individuals that the state just asked you whether the individuals you talked to gave you information that pointed you in Mr. Anderson's direction. And I'm asking if any of those witnesses, or actually stating none of those witnesses provided you information that they saw Mr. Anderson at Mr. Gutierrez's apartment on May 17th, 2020. Correct?
Correct.
Nothing further.
Nothing on that specific question.
All right, you may step down.
Can I have 30 seconds just to talk to co-counsel and just inquire about the next?
Yes, how many Brewers fans here? One? Two. You don't have to be embarrassed about it. Three, I think I saw now. Cubs? Okay, 3-3. Sometimes there's a few other teams. How lengthy?
Short witness, we've conferred, this will be a very short witness, and then we have a stipulation to read, and then we believe we'll close evidence for today.
Thank you.
Is that accurate?
Yes.
All right, here, real quick, chat, real quick. Let me pull these up real quick. So that we shared this one out the first time. This is Judge Schrader. And then we pulled this one during the trial. All right, here we go.
So you got it. Please be seated.
Ms. Swanigan, could you please state your name for the record and spell it?
Marissa Swanigan, Marisa, Swanigan, Swanigan.
And are you currently employed in some way?
Yes,
And what in general do you do?
management.
I'm going to direct your attention all the way back to May of 2020. On May 17th of 2020, were you living at the Wood Creek Apartments, specifically 3709 15th Street, apartment 2B?
Yes,
And that apartment, was that on the first floor, second floor, or somewhere else?
the second floor.
So did you have a downstairs neighbor directly below you?
Yes,
And did you know him in passing, just being essentially apartment mates?
yes.
And did you know anything about his family situation in passing?
Just two kids that I would see in passing.
And were they young kids, probably 12 and under, let's say?
Yes,
Did you know if one boy, one girl, two boys?
one boy, one girl.
Okay. And do you recall having contact with law enforcement on the 19th of May of 2020, where they asked you, did you hear or see anything on the days preceding that caused you some sort of concern from the downstairs apartment?
Yes.
And what, if anything, do you recall telling law enforcement about your observations that they were asking about?
Just hearing loud banging, like against the wall.
And was this specifically on did you have a specific night that you had heard this?
It was a Sunday night.
So that would be May 17th?
Yes.
And when you heard this, approximately what time was it, if you recall?
Between 10 and 11
And where were you in your apartment when you heard this noise coming from downstairs?
in my bedroom.
And at that time, were you living in a one-bedroom apartment?
Yes.
And was your bedroom at the back end of your apartment, so all the way through?
Yes.
And based on where you were in your bedroom, could you tell in general where this banging noise was coming from?
Yes.
And how are you able to make that determination?
It wasn't coming, the sound wasn't coming directly from under me. It was more so further in front, but below me, if that makes sense.
And so in your knowing the layout of the apartment, what room of the apartment below you did you believe this banging to be coming from?
The living room.
And approximately how long do you remember this banging to have occurred on the 17th between approximately 10 and 11 p.m.?
About 5 minutes.
And at that time, did you hear any speaking or any sort of anything else, or just the banging?
Just the banging.
And in your experience as a human being, did you have any sort of thought as to what that banging could be in your mind while you were in bed hearing it?
I initially thought maybe something that was really big might have fell, or if the kids were still there, that they were playing around and they knocked something over.
And you said the banging went on for approximately 5 minutes?
Yeah.
And then once that 5 minutes stopped, did you hear anything further?
No.
And obviously, hearing that banging, knowing that kids sometimes are downstairs, you didn't call 911 that night?
No.
But when asked about, had you heard anything in the days preceding the 19th of May, that's what you were able to tell officers?
Yes.
And you were for sure it was Sunday night between approximately 10 and 11?
Yes.
I have nothing further. Thank you.
Thank you. Good afternoon.
Hi.
Hey, so just a couple of follow-up questions. This banging or the sound that you heard, you said in between 10 and 11. Do you remember if it was closer to 11? Do you have a more specific time?
I would say closer to 10, like a little after 10.
And when you spoke with law enforcement, do you remember telling them that you didn't see anyone or you didn't see any cars?
Yes.
Did you look out your bedroom window?
No.
Okay, so you were just staying in bed.
Yes.
Okay. And so all your observations was this sound.
Yes.
And prior to hearing this sound, I hate to go into your whole sleep schedule, but got to do it. How long were you in bed prior to hearing that sound?
Maybe 2 hours.
Okay, and were you awake and in bed?
Yes.
Okay, and prior to hearing this banging sound, did you hear anything else suspicious?
No.
So you didn't hear any screams?
No.
You didn't hear anyone arguing?
No.
And I want to talk about the apartments in general. How long did you live there for?
About 3 years.
Okay. And clearly you could hear what had happened when you heard this banging, but in general, tell me about how private that apartment building is as far as being able to hear what's going on in your neighbor's apartment.
It's pretty quiet.
But can you hear things coming from the apartment across from you or below you?
It would have to be really loud, but if it was, then yes.
And so and you're sure that this was Sunday night?
Yes.
Okay. Did you hear anything the following day?
No.
Okay. Did you see anything the following day?
No.
And were you there the following day or were you at work?
I was there.
Okay. All day?
I believe I went to work at 9 o'clock Monday night.
Okay. Do you remember telling law enforcement that you didn't hear any sounds of glass breaking?
Yes.
Okay. But you said that, I'm just trying to really get what the sound was that you heard. I know it's hard. I know it was a while ago. And you previously described it as something falling off the wall. But is there any other way that you can describe this sound?
It sounded like just something big being forced against the wall.
Okay. In the living room?
Yes.
I don't have anything further.
No, nothing further. Thank you.
You may stick down, man. I think you folks have put in a full day, and it's a good time to stop.
Can we,
Can we read the
can we read the
stipulation?
stipulation?
You may.
Okay. Counsel, we're prepared to read the stipulation.
Yes, I would like to read the first part.
Okay. Any of my copy? I'm happy to do that.
Okay, sure. Thank you. So cordial. So we have a stipulation. I'm going to read the first part, Judge, and then the state will read the second part. The following are statements attributed to Lene J. Douglas, who is an unavailable witness in this matter at this time. The parties have stipulated that these two statements should be read in their entirety to the jury in place of testimony that Ms. Douglas would have made if she had been available. Officer Paul Chase on May 19th, 2020 reported, quote, "I did speak with Lene J. Douglas in number 2C," end quote. Quote, "Douglas told me that she thought that she heard an argument from apartment 1B yesterday, May 18th, 2020 afternoon around 13 hours. She knew that the subject in 1B had kids and did not think anything of it. Douglas went on to say that she did not see who was arguing," end quote.
Members of the jury, the second part of the stipulation is as follows. Lene Douglas telephone call on March 10th, 2022 with DA Mike Gravely and victim witness coordinator Heather Beasy. Ms. Douglas was asked about her verbal statement to Officer Chase, in which he had her saying that she had heard an argument in 1B on May 18th, 2020 at about 1 p.m. Ms. Douglas stated that she could not be correct, stated that could not be correct because she was working with headphones on for her job from her back bedroom on Monday, May 18th at that time, and would not have been able to hear anything. She stated the officer must have misunderstood what she told him. She stated that when she heard something concerning apartment 1B, she was in her main living room, comma, it would have been about 9 p.m. because she was watching TV. She stated that it was in the few days prior to May 19th, 2020, when she heard at approximately 9 p.m. a scream in the hallway by 1B. She described the scream as high, as if someone was in pain and surprised. She stated that she could not hear anything further, which surprised her because based on the original scream, she thought she might hear a call for help or something. That's the completion of the stipulation, and of course, this has been filed with the court. It's been provided to the court.
Right. Folks, again, when there's stipulation, that's something the parties agree as being the true fact. And so that's something that you should accept. and no further proof will be received or received to either prove or disprove what is agreed to. Any question about that? Okay, anything else?
No.
Okay, let's break for the day. 9 o'clock tomorrow morning. Please don't read, watch, or listen to any account of the trial. Don't discuss the case even with fellow jurors or members of your household, and we'll see you tomorrow.
All right, chat. That is going to be the end of day 2 of the Zachariah Anderson trial in Kenosha, Wisconsin. Kind of a spicy trial. It's interesting. A lot of objections, tons and tons of hearsay coming into this trial. We've almost gotten into a second issue of mistrial. They're continuously walking this line. Lots and lots of hearsay. This detective, that was the first witness. So you guys haven't missed much. So if you guys are tuning in, this is the first time today. We do have the opening statements up on the channel. And then yesterday, the lawyers came back to argue over this mistrial thing. And they both sides kind of agreed that...
Daubert issue? I don't think we've had that yet.
You're right. Yep, I think that's a good idea.
And we're going to argue some Daubert issues. These are
yeah,
big.
this is a good time to tell me. Get out of here. All right, I have a number of observations on the Van Wheat testimony, or offered testimony.
Oh, we'll see. We'll see plenty of Judge Schrader. There's gonna be plenty of Kenosha cases coming. But yeah, so basically day 1 was just opening
The first
statements,
observation that
and
I
then a
want
lot
to
of
make is
argument
I
over
thought
this
it was very
mistrial
clear
issue.
from the argument that has been made here that there is no dispute as to the scientific basis for the methods and principles which were employed in this case, although there's dispute as to the qualifications of Officer Van Wee and the method in which he did his observations and analysis. But I did not understand any dispute as to the basic science of it and the requirement for the admission of this type of testimony, as stated in 907.02 subsection 1, is that scientific, technical, or other specialized knowledge will assist the jury to understand or determine the fact and issue, that the expert witness testifying is qualified as an expert by knowledge, skill, experience, training, or education, that the expert testimony is based upon sufficient facts or data, that the expert testimony is the product of reliable principles and methods, and that the expert testimony has applied the principles and methods reliably to the facts in the case. And the defense objection states that the defendant maintains that Officer Van Wee's testimony regarding his observations and conclusions of the blood evidence is not admissible for the following reasons. One, that he is not qualified as an expert in the field of blood stain pattern analysis. Second, that he does not comply. His report does not comply with industry standards and requirements. And third, that Officer Van Wee failed to reliably apply principles and methods and made substantial errors in his report.
You know, as crazy as it sounds, I just don't blow the dust.
I don't know why we're
Maryland,
getting commercials during all this.
Alice Tebbs Miller. And she has made a number of attacks on Officer Van Wee's performance in this case and the contents of his report. And then we discussed at some length the other day, and I pounced, as I frequently do, when Attorney Mueller talked, started talking about standards and requirements, and I challenged that to basically according to whom, and I think the response was the Department of Justice, and I have to say, I haven't made an exhaustive search, but I haven't found these standards from the Department of Justice. I think I made pretty clear that I'm not familiar with any authority that I'm required to follow standards of the Department of Justice. I'm not familiar with any legal authority for the Department of Justice to proclaim or enforce standards on the state courts. And I'm not suggesting that the Department of Justice may not have done so, but the Department of Justice has done a lot of things that are in the courts right now, actually, and in the Supreme Court right now, as to the reliability and the legality. But even assuming that they've made suggestions as to what standards courts should apply, I'm not familiar with any standards which I am required to employ. Certainly, I've not heard of any constitutional, under the federal constitution, that I would be required to do so. And I've not seen any that set the standard for state law. And in fact, both the United States Supreme Court, from the beginning of Daubert, and the state Supreme Court from the beginning of Wisconsin's use of Daubert, has, I think, have deliberately veered away from a course of imposing strict standards on trial judges. And to the point that, as I mentioned the other day, Judge Apremian's article, which is in whatever they call the Wisconsin Lawyer now, I guess it's the Wisconsin Lawyer, comments on Professor Blanca's splendid primer on Daubert evidence, and the fact that Professor Blanca said Wisconsin was a lax Daubert state when it's in assessing what the appellate courts have demanded of the trial courts. And Judge Apremian has not necessarily agreed with that. I think he's suggested that the individual states' laws have really defied easy definition of what is a lax and what is a strict application. But so as I say, I think that Ms. Mueller made reference to controlling. I think that was my word, controlling but on the idea that these standards are to be followed in order for the witness to be qualified. And I don't think there's any control element in it. She's advocating adherence to the standards of the organization to which she pays dues and belongs, and I think has been an officer. But why they would be preferred to a lot of other criteria. And I mentioned the other day that I thought they were very firmly rooted in an academic approach. And for example, suggesting that to be qualified for this analysis that was done here, that the officer ought to have had a bachelor's degree and have taken a course in trigonometry. And I've been in this position for 40 years. I was district attorney in the district attorney's office for 6 years, and in private practice for I think 7. And I have had this type of testimony come up numerous times, most notably in a case called State against Perez, which I won't get into. But trigonometry was never part of my analysis. Now, I'm not saying it wouldn't be an improvement of my analysis to apply some trigonometric principles, but first I'd have to take trigonometry because I didn't. And I suspect many of my colleagues in the judiciary would not have taken that course or those courses. And even a lesser number of police officers, including those who've done a lot of this work and we've relied upon for many, many years in the criminal courts, that would not be viewed as a prerequisite qualifying as an expert. I understand there were some substitute courses in that, but as a general statement, I did feel it was the viewpoint of these standards, which, well, I think they appear to be a product of the academy, and they are biased in favor of an academic background for the examiner rather than an experiential background. And from what I've read on the topic in case law over the years, both from Wisconsin and from elsewhere, as a general statement, I think the vast majority of the persons who have qualified to give opinion in this subject, while many of them have taken academic programs and have degrees of various types, but it's very likely a experience-based science. And Professor Blinka gives the example of the perfume tester who tests and distinguishes between 140 different perfumes from experience alone by smelling them. And there's no way you could scour the world even at the Sorbonne, and you'd not find someone with the credentials to do a better job than someone who's just been doing it for a long time. So I'm not saying no that the doctor is wrong about this, and she's trying well to try to move this into a more disciplined area. And certainly education is a component of that. When I say education, we get education a lot of ways. Sometimes just by failing. But so she's trying to get more standards and ensure that the people are having some good background in some of the aspects of blood stain examination and opinion. But I don't think what she's advocating, what these standards, as they're referred to, suggest are prerequisites to admission of the testimony and analysis of someone who is otherwise knowledgeable. And I remember there was some of you may remember it, but I certainly do. When Daubert was adopted in Wisconsin, there was almost a panic. There was almost a panic. What's going to happen? And hearing two different presentations, one by Professor Blanca and the other by a judge from a magistrate judge from the Western District, whose name I have to apologize, I don't recall. And also a presentation by a judge from the Court of Appeals, who was a judge in Janesville and Paris now. I can't suddenly come up with it. Very knowledgeable judge. And they all gave basically the same message. There's not much change from what the rules were pre-Daubert. It's my own opinion, from having lived through that period and having tried cases under the pre-Daubert approach. There was there was a word for it that's widely used at the time. You don't hear it too much anymore. Since Daubert, there was a lot of junk science coming into the courts. And I heard things said on the witness stand that I think, you've got to be kidding me. But we had such loose standards in those days about who qualified as an expert and what opinions those experts might convey. That's what was the driving force in the adoption of the Daubert rule in Wisconsin. But these very capable people with terrific federal experience who had worked with Daubert said it's not that there's not that big of a change, and there is no doubt in my mind that under pre-Daubert approach, Officer Van Wee would have qualified. There are only a few areas where I think the defense has scored some legitimate points, and I'll get to those. But in terms of the first 5 areas of the inquiry, whether it's really a science, whether it's verifiable. You made mention, Ms. Miller, of the peer review. And see, to me, the peer review referred more to the determination of whether this is really scientific evidence and had been tested, and that there were available statistics as much as possible for its reliability. Well, does anybody know, was the issue of the so-called shaken baby syndrome ever been resolved ultimately in the courts? You used to hear that. I used to go to judicial programs all the time. And we'd spend days on shaken baby syndrome. Only the last time I ever heard of it was a presentation with some very eminent scientists and lawyers. And the consensus was that there's no such thing. I haven't followed up on it since. I haven't had a case like that come in here since. I don't know if Daubert spelled the end of that or if it's still being pursued, but there were enormous amounts of money being taken from one pocket and put in another on the basis of those lawsuits. Same thing with the tire cases that the combo case, and the breast implants and the needless suffering which was endured because of people being afraid, because of what in the end wasn't really accurate science. That was what I think the objective was, is to shoo that stuff out the door. And peer review was part of that. Whether when you made a Daubert analysis, whether it was verifiable information or just somebody's theory. I had a person come in here from an academic background and testify that when a person is driving an automobile and is going to turn right, that motorist will always initially start to turn left to set up for the turn. I was embarrassed to be submitting that case to that jury with that kind of information. But so that was, I think, what the Daubert rules were aimed at and have largely accomplished. But I have to say, having lived through now 10 years of Daubert, 10 plus, I haven't noticed the difference. I'm just seeing less of the junk. So in terms of the what Professor Blinka refers to as, in his article, March 2011, Wisconsin lawyer, well, at page 18, these three foundational elements, relevance, qualifications, and helpfulness, are the target of the rule. And under 907.02, the qualifications element should speak to the reliability of the witnesses' principles and methods and their application to the facts. He comments, experts sometimes, he's quoting, experts sometimes reach different conclusions based on competing versions of the fact. And that the rule is not intended to authorize a trial court to exclude an expert's testimony on the ground that the court believes one version of the facts and not the other. And I made reference to that on the first day we discussed it, that while I have a gatekeeper duty, this is not my decision to make. This is for the jury. Professor Blanket continues, there is no definitive list of reliability factors that must be applied in all cases, nor is there a hierarchy of factors that ranks them in order of preference or weight. Which factors apply and how they are weighed are within the court's discretion. This is a much misunderstood aspect of the reliability standard. In Daubert, the Supreme Court discussed 5 non-exclusive factors in the context of scientific evidence. 6 years later, it quelled a circuit split when the court clarified in Cumho attire that the reliability analysis also applied to non-scientific expert testimony. But he goes on. On page 5, on 19, page 19, at point 2, whether the technique or theory has been subject to peer review and publication. And I don't think either the general technique or the theory are at issue here, and that they have been widely subject to peer review and publication. And I don't think there's any question now. I shouldn't say any, because I'm aware that there is one case that's ongoing now that raises some issues about its reliability. But I won't get into that because I don't think it has anything to do with this case anyway. But and the Supreme Court said, moreover, Rule 702 is broad enough to permit testimony that is the product of competing principles or methods in the same field of expertise. Finally, the United States Supreme Court has expressly recognized that the trial judge must have considerable leeway in making reliability determinations. Disputes among experts centers on the principles and methods. The focus must be on the principles and methods. Appellate courts give short shrift to trial judges who unduly focus on the witnesses' qualifications. The court is required to make a separate finding that the witness reliably applied otherwise reliable principles and methodology. At page 60, professor says, experience alone or experience in conjunction with other knowledge, skill, training, or education may provide a sufficiently reliable basis. In certain fields, experience is the predominant, if not sole, basis for a great deal of reliable expert testimony. Getting into Dr. Yes, Miller's report. she's made some observations of this, about this case, the most glaring of which was brought up by Mr. Gravely the other day, that she, as I said, I thought she succumbed to what a lot of us do now in the computer age and just took an earlier report and made some modifications. Nothing wrong with that. Made some modifications and issued it, but at page 4 of her report, Exhibit 3 that you've offered for the defense, during my review of Officer Van Wee's report and the case materials, including crime scene photographs, autopsy reports, and forensic laboratory testing results, I was able to identify several blood stain pattern identification errors made by Officer Van Wee. Well, of course, there was no autopsy. So she's grossly misstated what was available for her in her critique, in order to make her critique. I've in reviewing Officer Van Wee's report, he has experience. I heard a former police official being interviewed on television last night. I think the individual was from New York, but while New York's problems get more publicity, its experience is repeated around the country. This person who was very high placed in the New York Police Department, if I'm right about the community, said, we can't get police officers anymore. It's been made into a very unpopular occupation. It's a dangerous position. Number one, it's dangerous just in doing that line of work. And I understand there was a police officer killed in Chicago again last night, one in Milwaukee a couple of weeks ago. And then these people have to make life and death decisions in less than a second. There was one on trial in Milwaukee 5 or 6 years ago, and Attorney Smith used to be with Jerry Boyle. I can't think of his name.
Jonathan
Smith.
Yeah.
Defended him, and he had there was a video of the incident, and there was no question. The district attorney didn't even claim that the officer's first shot, which was non-lethal, was legal. But in, I think, about 0.7 of a second, the officer took a second shot, which was fatal, and got criminally charged for something that happened in less than 1 second. It's a big disincentive to taking that kind of a job. So there are decreasing. I think the particular, I may have read this in a part of this in an article too, just this morning. Someone talking about the lack of applicants for police jobs and how we used to have 500. No, it was Chief Deputy Levin who retired the other day, and he said we used to have 200 people apply for these jobs, and now we have, I don't know if he said less than 50 or if he said 20. But that's the problem. So where do you get all these qualified examiners if you impose even stricter criteria for them to testify as experts in the court. So you not only have to, you already have a limited number of people applying for these jobs, much less than in years gone by. And then to go with everything else, and of course there are some officers who either make mistakes or in some cases worse, but some people will paint the entire profession with just awful accusations when they're just trying to do their jobs properly. So you have an already diminished number of applicants, and then to take those limited number that you have and say, in order to do this work that the police desperately need to have done, they have to have blood stain analysis done as part of their work. They have to employ only those who have completed trigonometry courses and have a degree of various academic stature. So that is not part of the calculus for me in determining who's qualified as an expert. And I think Officer Van Wee testified very capably about his experience, credentials. And yet the defense says at page 3 of its brief or its motion, the only qualifications the state claims is that he has experience as a police officer and completed a 40-hour course in bloodstain pattern analysis. Skipping. Additionally, a 40-hour course did not make someone an expert in the respective field of study. But there's no support for that claim. I didn't see any citation to any authority that one can't learn this particular scientific analysis in a 40-hour course. I'm not saying it can, but I'm satisfied with all of his credentials, all of his experience. He is shown to have sufficient experience to qualify as an expert. The defense characterizes at page 4 Marilyn T. Miller, a national expert on blood spatter. I don't know if she is or not. I never heard her name before. And there's no citation of that. And that's always, of course, something that isn't easily quantified anyway. There are, I'll still say, I don't care what anybody says about Willie Mays or Mike Trout. I'll still say that Henry Aaron was the greatest baseball player of all time. So, you know, that's just somebody's opinion. So I don't know who said she is a national expert on blood spatter analysis, but it did, that's supported claimants. As far as I'm concerned, the defense quotes from her report about how he doesn't have the undergraduate degree with coursework and trigonometry, science-based coursework, and specifically laboratory work in biology, physics, and chemistry. I don't see where that's necessary to the job. I really don't. And in the event this ends up in a different court, taking a look at it, I don't know. I just don't see those as prerequisites. Documented mentorship program, those would all be positive and pluses, but in terms of the reality of the world in which we live, I do not embrace that claim. Not being certified with the International Association of Identification. that would not make a big difference to me. These standards, so-called,
Judge, I'm sorry to interrupt, but
Yeah.
I really need to use the restroom.
oh yeah, by all
So-
means, go ahead.
Okay.
No,
Or if,
I'm almost
if we
done, but
can-
I don't want you to wait. No, go.
I can wait if it's gonna be,
No,
if it's gonna be
I would never
quick.
do that to someone.
I'm telling you, I can wait,
Well,
but I want to be sure that I'm not, I don't want to feel like I'm rushing anyone here,
I
but,
don't feel rushed.
okay, so I can wait, but if it's gonna be like 20 more minutes, I probably will want to take a break.
Let's do the, we'll compromise. You can stay and hold on and I'll finish up within 5 minutes.
Great, I appreciate it. Thank you, Judge.
But feel free to,
If I need to leave, I
Yeah,
will, and I'll
yeah.
leave John and Kirk here.
all right. These standards, they didn't even start assembling them until 2 years before this incident. So, now, there is something about Officer Van Wee that I do think the defense makes a good point. He's not going to be permitted to testify to what was and was not blood, because he hasn't got credentials for that. He can testify to what looked like blood, whatever characteristics he wanted to see, which probably wouldn't be expert material anyway. And somebody who walks into a scene like this, a totally lay person, is perfectly capable of very quickly falling into discussing it in terms of it being, oh, there was blood all over. But he's not going to be able to characterize anything as blood, at least not on his own credentials. And this is a business about his usage of the terms, the victim was attacked in the hallway outside his apartment door. The bloodstains indicate the violent attack continued. To the extent that that is prejudicially emotive, that's got to be controlled. This is not an exercise for him to advance a theory of how the crime happened. His job is to report what he saw, and what he's qualified to report on is the pattern and the like. And I think I'm going to wrap it up with that. So that's the reason I gave the ruling that I did. And what did you have to say?
So he would be able to testify that it looks to him like blood based on his experience. There literally is no one at Kenosha Police Department who's dealt with things in.
Yeah,
he's more than him.
I would expect someone with even a few months, definitely a few years on any police department, at least around here, to be able to say, use the word blood with considerable reliance.
So he's allowed to express his opinion that it's blood. He's just not allowed to, he's not allowed to.
When he's
definitively
talking scientifically, no.
Say it one more time.
He can't do it scientifically, no.
Similar to what we just had.
We'll work it out. I'm not worried about it.
Okay. So I understand. Thank you.
Thank you.
Thank you, Judge.
What did I tell you, 9 o'clock?
9?
Yes.
Yeah.
You told the jury 9. Yeah.
Okay, please don't read, watch, or listen to the account of the trial. And enjoy the evening.
balls are too thin. Okay, wait, hold on. Let me get the number. Hold on.
So she just woke up. She just woke up. And then the yelling started. So I messaged the landlord so that I could fucking have her deal with this again. And she's been screaming. She's drunk and laying in bed, screaming for this boy who literally just walked in the house. He wasn't even there, and she was already screaming. Now she's on the phone with 911. And 911 won't come. So I'm recording out the door again. She's on the phone with 911 trying to have me arrested. 911's telling her, can you close your door? He's not doing anything illegal. Can you guys hear it this time? Unreal. All right, I'm gonna end this stream. Are you guys here? Can you guys hear this? Dude, it's been quiet all day. It's been quiet all day, because she's been asleep. So she's like even in here and she's like, he's lying. I've been asleep the whole day. It's been fucking quiet. Yeah, it has, because you've been asleep. Now you're awake and you're fucking screaming up a storm. She was laying in bed screaming to see if this kid was home yet. And he wasn't. I actually have the kid on the fucking video walking up the stairs. She's screaming in the apartment asking if this kid is home. And then I started texting Amy to be like, can you fucking please deal with this? I have a live stream interview tonight. I'm not fucking listening to this. So then I started to record to send a clip to Amy. And then the boy walked in while I was recording. She's losing her fucking mind. And she's on the phone with 911 trying to have me arrested. He's infringing on my privacy. I hear 911 on the phone because she's standing at the door screaming. I got her on video again. And 911's like, can you close your door? And she's like, yeah. And they're like, then close your door. And she's like, but he's still out there. 911's like, well, where's he standing? In his doorway. So he's filming from his doorway, you being loud, screaming at him. He's allowed to stand there. He's allowed to film and document this. That's what 911's telling her. So she's getting pissed off, and I'm just smiling at her, laughing about it. Fucking all day, because she was, I told you guys, dude, from 7 to 9, and it was actually kind of shorter today. It was only an hour this morning, so it wasn't too bad. And it wasn't super loud. It was tolerable. It was like a muffled noise that I heard. But now it's just fucking bizarre. But here, let me end this, and then I'll go live. I'll bring the fucking computer over. I'll go live out the door. All right, I'm gonna end this so I don't fuck this stream up. Here we go.